Good morning. Committee on State Affairs will come to order. Will the clerk call the roll?
Senator Betancourt.
Present.
Senator Hall. Senator Hinojosa.
Present.
Senator Parker. Senator Perry. Senator Shortner.
Present.
Dean Zaffarini. Senator Paxton. Senator Hughes.
Here, quorum is present, and there have been some travel delays which will affect some of the senators arriving, but we're thankful to everyone who's here to participate, and whether you're going to be listening or testifying, or whether you haven't decided yet, that's okay too. You've got a little time for that. We're going to hear invited and public testimony, and so we'll first take up each of our charges. We'll go through the ones for today and hear the invited testimony on each. Then after that, we'll open a public testimony. As you know, if you go to the U.S. Congress and try to testify, unless you were invited, you're not welcome there. But many states do it that way. But in Texas, we like public testimony. We like to hear from the people we work for, whether we agree or disagree, or that's how we do it. And so that'll be toward the end of this hearing, and most of you have done that before. At this point, I will see if any member of the committee wishes to make any opening remarks. It's not required or expected, but we always want to give an opportunity.
Why are you looking at me? Am I the only one awake? I think no. I know Perry got up ahead of me. Mr. Chairman, thank you for having this hearing. Thank you, Lieutenant Governor, for issuing the charges to the committee. I think all of us are interested in what are really three main subsets of state affairs charges. And I think you've collected a good team of people to start the discussion off. So I will get out of the way and let you run the show, which is what I think you're going to do anyway.
Thank you, sir. Thank you, sir. Thank you, each one, for being here and being involved. And so, Lieutenant Governor has assigned this committee interim charges. Most here know how that works. During the time between the sessions, we do our work and do our groundwork and do our research and follow up on what happened the previous session, and also prepare for the next. And so we're going to take up 4 of them in turn today. Monitoring legislation passed this legislature, beginning with our proxy advisory law, and also maintaining the security of our elections, ensuring the efficiency of our elections, and protecting the unborn. And so on monitoring, we'll be looking at Senate Bill 2337, a bill passed last session, which many states have introduced versions of, and the feds have also taken some action on, which we'll be talking about. Lieutenant Governor asked us to monitor how the laws we passed this session are being implemented and to recommend what more may be needed to complete the work. So 2 laws are named in that monitoring charge. The one we'll take up today is Senate Bill 2337. Our monitoring charge on the Lottery Commission will be at a later hearing, of course, and we'll be plenty more time to gather that unfolding story, Senator Hall, as you lead on that. And so it's important. Proxy advisory firms, at the risk of insulting your intelligence, I'll just say something about what they are, because most of us weren't real familiar with them. But if you are an institutional investor, maybe you're a retirement fund, maybe you're the Teacher Retirement System of Texas, or maybe you're a private foundation, or maybe you're just an investor that owns a bunch of stocks. Many times these entities own hundreds or thousands of shares in hundreds or thousands of companies. And of course, those shares that are in Exxon, Walmart, IBM, fill in the blank, each one of those shares entitles you to a vote at the annual meeting of that company. The annual meeting, of course, is where the board is elected, where the company takes policy positions, decides direction they're going to go, and so those votes are really important. And again, if you're an institutional investor with hundreds or thousands of shares, it's hard for you to keep up with each vote and every topic that's going to be brought before the committee. And as a result, over the years, companies called proxy advisory firms have grown up to provide a service. So historically, a proxy advisory firm would research a company and look at all the votes that are going to be taken at the annual meeting, look at the candidates for the board, look at all those decisions, and then make recommendations to the people that own those shares. And historically, they looked at things like corporate hygiene. Is this company following the law? They'd go to the Securities Exchange Commission and look at all the circulars and all the publications and all the notices and all the violations, potentially, and see how the company was doing. And then they would recommend how the owners of that company, the shareholders, should vote. Sadly, in the last few years, those proxy advisory firms have taken a very partisan political edge. And so rather than just making recommendations based on good corporate hygiene. Is this company following the law? Is it managed well? Instead, they're inserting a political agenda. And so Texas has taken the lead on pushing back against that. If you are going to hire someone to advise you, you want to make sure they're telling you the truth and they're disclosing all the information, not cherry picking and not slanting it, and not telling you one thing and another client something else. So that's what Senate Bill 2337 was about. And so the bill has taken effect. There's been litigation. There's been litigation to block the law. It is still in effect except for enforcement by the Attorney General. And we anticipate the courts will eventually do the right thing on that litigation. But for now, there is still litigation going on. And so at the end of the day, this is about Texans' retirement savings that are invested in these companies and the direction they take. And there's a larger discussion about our Texas economy and about whether we're going to let folks go after the energy industry, which provides good paying jobs, provides low cost energy. In days like these, aren't we aware that the cost of energy affects everything else? And so much of this agenda is going after energy, going after good jobs, going after good, low cost of living. And we're not going to let that happen. We can't do that. As stewards, we cannot do that. And so Senate Bill 2337 requires honesty. If you're a proxy advisory firm and you're telling people how they should vote on with their shares, you have to tell us if your recommendation rests on something other than financial interest. If it's politics, you have to disclose that. If it's a social issue you care about, you have to disclose that if you're not giving them financial advice, purely financial advice. So two firms cover most of the proxy advisory market, ISS and Glass Lewis. ISS is for Institutional Shareholder Services. They have filed litigation to block this bill, and that's okay. That's what the courthouse is for. We expect to win that case, but we're moving forward in the meantime. And so we invited Institutional Shareholder Services and Glass Lewis to appear and answer for their practices. ISS declined, let us know they're not coming. They sent us a letter. And then we haven't heard back from Glass Lewis, so we have a place prepared for them. We hope they'll show up. We'll see. In addition to inviting ISS and Glass Lewis, we're also going to hear from witnesses who can speak to how these firms operate and what next steps Texas should make. So our panel on this charge includes Terry Shen from ISS, we don't think appearing, Nicole Garzon-Mitchell from Glass Lewis, Chris Babcock, and at this time we'll call Terry Shen, Nicole Garzon-Mitchell. Chair calls Chris Babcock from Foley and Lardner. Chris, go take a seat. Chair calls Brad Hubbard from Gibson Dunn in Dallas. Call James Copland, Manhattan Institute. Call Eric Bledsoe, American Resolve Institute. So we've heard from ISS. We had them a place just in case they change their mind. It looks like most of us are.
Mr. Chairman,
Dean, of course.
what are the time limits for today's hearing?
So for public testimony, of course, we'll be limited to 2 minutes. And for our invited testimony, I believe they're generally limiting their testimony to 5 minutes, of course, subject to questions from you and the other senators.
Thank you.
Thank you, Dean. All right, so I'll ask the clerk if Nicole Garzon-Mitchell from Glass Lewis or anyone from Glass Lewis has registered to testify.
No, sir.
We'll ask the Sergeant at Arms to go in the hall and call their name 3 times.
Mr. Chairman, I do have a comment at this point because I think the audience now understands that we've asked people to come and they have not willingly decided to attend. We've been down this road before. The chairman successfully ran a very important meeting at Marshall, Texas, where this was first debated, or at least in concept. And at the time, ISS as well as 3 other firms actually attended. And it is extraordinarily disappointing that people will not respond, specifically companies that have reason to be summoned to a meeting can only expect that they may be summoned on a permanent basis to come back and explain their absence, or should I say more forceful basis, not permanent. So, Mr. Chairman, I want to thank you for trying to get people to attend because they're at the heart of this matter. speaking as someone familiar with Texas energy policy, I'm appalled that ISS would attempt to use our own funds to vote against our own energy projects. And the fact that they're not willing to come and have that public policy discussion is beyond disappointing to me, Chairman. And you have been a stalwart at trying to get transparency into this process since those Marshall hearings. And I believe that if they do not wish to come at some point, you'll have to decide to compel them. That's up to your decision. I've signed those subpoenas before, and I believe the fact that the other company ghosted you with not even a response, at least ISS put a response in here, and they could have come and testified and basically waived off any questions based on their suit, but they could have testified to the public policy, which they're wrong on. We do not need institutional proxies telling our retirement system or any of our other funds in the state to not invest in Texas energy projects. That's really at the heart of the matter. And that's what taxpayers need to understand, the citizens of the state, and why they were asked to come. And the fact that they're not here speaks volumes to what their position is.
Well, thank you, Senator. At the Marshall hearing, of course, you had a good, helpful exchange with representatives from ISS, as I recall. And so the Sergeant at Arms reports there is no response from Glass Lewis. And so, and Senator, you're right. You know, we, in addition to affecting public policy in Texas and having control of a lot of Texas money, these firms are also hired by various state entities to perform this service. So they're a client as well. So as you know, as you mentioned, the committee does have subpoena power. This committee already authorized those subpoenas during the regular session, which are still in effect until January, and will be conferring with the committee on whether we should invoke subpoena power, and we'll see if we hear from those guys in the meantime. Until then, we're going to be talking about what they're doing, what they're not doing, whether they're following the law, and how we can move forward. And so with that,
Mr. Chairman?
Oh, Dean, please, you're
Thank you.
recognized.
If they were here, even if under subpoena, and their attorney advised them not to answer a question, they simply wouldn't answer it, correct?
Senator, that's a tremendous point. So because of the litigation, if they were concerned, they didn't want to be here while the case was going on, this was even discussed with them. You can come, bring your lawyer, and question by question. If your lawyer says, I can't really answer that based on litigation, of course, that's fine. They had that option. That was discussed with ISS. I'm so glad you underscored that, because that's an option they have. It's not necessary to hide from public view. Days like today remind us of the old adage that we live around here, that sunshine is the best disinfectant. And so thank you for pointing that out. Thank you, Dean. At this time, I do have an order we'd like to take the witnesses in. So, Mr. Babcock, you're recognized. Introduce yourself. Give us your testimony. Welcome.
Today on this matter. Making sure the mic is good. Thank you. Thank you, sir. My name is Christopher Babcock, and I'd like to thank the chairman and the members of this committee for inviting me to testify today. Bill 2337, and why it was an important piece of legislation for Texas and for our overall capital markets more broadly. The members of this committee have received written testimony from Stephen M. Pantina of Proxy Analytics, LLC. His testimony highlights the significant role that proxy advisors, and in particular ISS and Glass Lewis, play in corporate decision-making. Said simply, in the United States, most shares of public companies are owned by professional asset managers, the institutional investors that the chairman mentioned in his opening remarks. These asset managers are third parties who invest the savings from ordinary Americans who are planning on retirement, saving for emergencies, otherwise seeking to build their financial future. And these asset managers are fiduciaries. That is, under law, they owe their clients duties of care and loyalty and have a recognized obligation to vote corporate shares on a reasonable basis aimed at one thing, their client's financial interest. You would assume then that when professional proxy advisors, such as ISS or Glass Lewis, sells voting advice to these fiduciaries, their advice would be based on the shareholder financial interest that is the asset manager's duty. And yet both proxy advisors have publicly disclaimed this as the basis for their voting recommendations. ISS has stated in an interview with CNBC that, quote, "The investment thesis is something we leave to the investors." Glass Lewis told the House Financial Services Committee that it does not generally conduct an economic analysis of shareholder proposals before it makes its recommendations. The proxy advisors say this despite acknowledging that if their advice were labeled as non-financial, then, as Glass Lewis said, its asset manager clients might, quote, "feel compelled to disengage from buying and acting on their voting recommendations that could cause a fiduciary to be, again, quote, perceived to be violating its fundamental duty and opening itself to litigation." Said plainly, we believe that, as stated by attorneys general in Texas and several other states, ISS and Glass Lewis have worked to advance agendas under the guise of impartial investment advice through distortion and non-disclosure of material facts. In particular, while portraying themselves as disinterested and neutral service providers to avoid regulation, ISS and Glass Lewis have gone to great lengths to avoid transparency concerning how they develop their recommendations. Both proxy advisors are suing in federal court to avoid the enforcement of SB 2337. And while they are entitled to their day in court, it's worth noting that the proxy advisors have worked hard to keep the discovery, which seeks information as to whether their voting recommendations are made solely in the shareholder financial interest, confidential, and required numerous filings to be made under seal or with significant redactions to avoid having the details of the proxy advisor's decision-making subject to public view. Moreover, ISS and Glass Lewis have recommended against all but a single corporate proposal to redomesticate to Texas. Not once in any of their published recommendations did they disclose that these firms urging shareholders to reject coming to Texas were themselves in active litigation against the state. These recommendations did more than omit material information. What ISS and Glass Lewis published provided shifting rationales that appear to show a motivated reasoning in their voting advice. Compare what ISS has said about 4 companies who have had proposals to redomesticate to Texas. In particular, what they've said about the company's decision to adopt or not adopt a derivative ownership threshold. As a reminder, Texas allows its corporation to set an ownership threshold that must be met for a shareholder to take control of a derivative claim. Texas Capital Bank proposed to adopt a threshold and disclosed to shareholders that such a threshold could protect the company against opportunistic and frivolous litigation. ISS, in evaluating that claim, stated that it determined it does not appear that the company is currently or historically unduly burdened by non-meritorious litigation. Archer Aviation proposed a similar threshold, and ISS responded by arguing that the threshold was concerning, in fact, because Archer had been involved in shareholder litigation. ArcBest Corporation proposed to redomesticate to Texas and to affirmatively not adopt a threshold without a shareholder vote. ISS determined that the opting out of the threshold was simply not relevant to its analysis. ExxonMobil did not adopt an ownership threshold, and yet ISS recommended against its redomestication because the company would be able to do so in the future. In each of these recommendations, all of which were made this year, the reasoning was different but always pointed to the same result. And the inconsistent and results-oriented reasoning shown by ISS and Glass Lewis does not only apply to litigation thresholds. We've seen numerous mistakes and errors in how they've described Texas law on the proposals for Texas redomestication. Companies redomesticating to Texas were criticized for having exclusive venue provisions, even though such provisions are common and almost universal among large public companies. Differences in legal structure were mischaracterized as reduced protections, despite being substantially comparable when the effect of the structures was analyzed. Cost savings of proposals were ignored, often on arguments based on market capitalization, even when the proxy advisors acknowledged that a company was seeking such savings, the company seeking savings was pre-revenue. That is, a company that has yet to earn revenue, that is still relying on investor funding, and identified cost savings that would allow it to have less dilution, less capital, was discounted simply because of the company's market cap. Texas law was routinely misstated in both large and small ways, but always in a way that supported a recommendation against redomestication. If all the mistakes go to one side, that suggests they're not honest mistakes. Rather, ISS and Glass Lewis decided on their preferred result and then reasoned backwards to get there. I've focused on the redomestication proposals because that is a part of my practice. But ISS and Glass Lewis have a long history of recommendations that are inconsistent with shareholder financial value. I'll mention two of them from 2022 briefly. One proposal for Chevron to adopt a report that could lead to the divestiture of significant assets. Another shareholder proposal to Pfizer that it freely transfer its intellectual property to allow vaccine and other manufacture in third world countries without receiving compensation. Both of these proposals were identified as having a material cost, a material burden on the shareholder financial return of those companies, and yet ISS supported both of those proposals without justifying that through the lens of shareholder value. The issue here is not whether the proposals that they vote for or against are good or bad on policy grounds. That is important. The important is to understand that when professional asset managers purchase advice as to how they can vote their shares in accordance with their fiduciary duties, the fiduciary duties to serve their own clients' financial interests, the recommendations should contain that analysis or explain that they do not meet that standard. ISS and Glass Lewis are free to hold and to advocate for any policy views they like. That's appropriate to do, and we believe in robust debate and discussion. ISS and Glass Lewis are not fiduciaries. They don't have a duty to the independent investors who are ultimately affected by their advice. And yet, despite this, they sell their voting recommendations to fiduciaries, and the effect is significant. In a 2019 letter to the SEC, ExxonMobil analyzed the voting patterns of its own shareholders and found that there is a set of asset managers who consistently vote in line with ISS's recommendations, and often before the asset managers would have had a reasonable chance to read and consider the report. In Exxon's analysis, every year in which ISS recommended against a company's vote on say on pay, support fell by roughly 15% on the first business day after the recommendation, leaving a material question as to whether the recommendations were independently reviewed or immediately followed. Now, many asset managers have their own stewardship teams and are able to carefully consider how they view and vote their corporate shares. But the data shows that some portion of the market does opt to simply file ISS and Glass Lewis. When the following becomes mechanical, for whatever reason, including the compressed nature of proxy season, with thousands of companies putting together shares for vote in a 2-month window, or resource constraints on smaller asset managers who may want to reduce fees they charge their clients rather than pay for stewardship teams, a proxy advisor's recommendation becomes and can become a fiduciary's vote. ISS and Glass Lewis market their research to these fiduciaries. If they continue to do so, transparency and accountability with respect to their recommendations are essential. SB 2337 took the correct position. A proxy advisor who is influencing the voting decisions made with respect to the savings of ordinary Texans and others should be asked to prove that their recommendations are consistent with the fiduciary standards of asset managers or make it clear to the market that their recommendations are not. I want to thank the committee for the time.
Thank you for your testimony. We'll have questions for each of the witnesses, I'm sure, but we'll wait till we hear from each testimony. So thank you. Thanks for being here. Thanks for what you're doing on this. Mr. Hubbard, you're recognized. Welcome. Introduce yourself and give us your testimony.
Thank you, Chairman Hughes and members of the committee. My name is Brad Hubbard, and I'm a partner at Gibson Dunn in Dallas, where I practice appellate and constitutional law and advise public companies and their boards on Texas corporate law, corporate governance, fiduciary duties, and redomestication. SB 2337 fills an important regulatory gap, and in doing so, helps ensure that shareholders receive full and fair disclosure. As a general matter, everyone who speaks to shareholders about how to vote their shares during proxy season is subject to a comprehensive federal regulatory regime, which requires disclosure and creates accountability. That includes management, that includes the board, and that includes other shareholders themselves when they submit proposals or solicit proxies. The one group that isn't covered is one of the most influential, the proxy advisory firms. These firms advise shareholders how to vote during proxy season, but their advice is virtually unregulated. They're outside of the federal proxy solicitation regulations. They lack clear fiduciary duties to shareholders, and they face no accountability for inaccurate recommendations or undisclosed conflicts of interest. Through SB 2337, Texas has again demonstrated its leadership in the corporate law space, stepping in to fill the regulatory void by requiring proxy advisors to provide full and fair disclosure, just like every other proxy season participant. SB 2337 doesn't tell proxy advisors what to recommend or what to consider in making their recommendations. It requires disclosure and parity. When speaking to shareholders, you must give them complete and accurate information. And these concerns about full and fair disclosure aren't just hypothetical. With my remaining time, I'd like to first discuss two significant undisclosed conflicts of interest that affect proxy advisors, one that's structural and pervasive, and one that's specific to the state of Texas. And second, I'd like to highlight a few troubling developments that I have observed during the 2026 proxy season. First, ISS and Glass Lewis don't just provide advice to investors about how to vote their shares. They also provide consulting services to companies. This practice, charging public companies hundreds of thousands of dollars for guidance on securing favorable voting recommendations, while simultaneously providing investors with independent advice on how to vote on those same companies' proposals, creates a significant structural conflict of interest. And if that industry structure sounds familiar, offering investors a supposedly neutral assessment of a company while simultaneously receiving significant consulting fees from that same company, it's because it is. 25 years ago, that was the accounting industry. Firms audited the very same companies they consulted for. And that practice ended only after the collapse of Enron and WorldCom, which caused massive wealth destruction and harm to shareholders. ISS and Glass Lewis also face a significant Texas-specific conflict. As the committee is well aware, both firms have sued the state to block enforcement of SB 2337. But they didn't once mention their ongoing litigation against Texas during the 2026 proxy season. And that's despite providing recommendations on more than a dozen proposals to re-domicile in Texas, which requires the advisors to analyze and evaluate Texas law and the Texas legal environment. And I'd like to close with three troubling observations from this proxy season. First, with one exception, the proxy advisors have uniformly recommended against every proposal to re-domicile in Texas. And they did so despite not only meaningful explanations from the companies about the thorough analyses their boards undertook in concluding that governance under Texas law was in the shareholders' best interests, but also significant shareholder engagement in support of the move. Second, although the advisors spilled significant ink on the Business Organization Code's ownership thresholds for derivative lawsuits and shareholder proposals, whether a company adopted those provisions and in what form or format they did or did not appears to have had no influence on the advisor's ultimate recommendations. For example, eXp World Holdings adopted both 3% thresholds. Texas Capital Bank shares proposed adopting a 1% threshold for derivative actions. ExxonMobil declined to adopt either threshold, and ArcBest not only opted out, but also included the opt-out in their charter. That's 4 significantly different approaches and 1 uniform result, voting against the recommendation. The impact of the advisor's systemic recommendations against redomestication has been stark. Faced with the near certainty of proxy advisor opposition, with its attendant financial and reputational costs, many companies are beginning to reconsider their plans to redomicile in Texas. And they're doing so despite well-informed board determinations that there's a strong economic and governance case for choosing Texas. And third, the proxy advisor's analysis of Texas corporate law during the 2026 proxy season has ranged from inaccurate and misleading to simply wrong. And I'd like to point out 2 issues that have been pervasive in particular. One pertains to books and records requests. ISS says that the Business Organization Code imposes a 5% threshold for books and records access. They complain that would be impossible for a shareholder of ExxonMobil and would require them to have something like $31 billion invested. But that's flat wrong. The plain statutory text makes clear that it's disjunctive. It's a 5% ownership interest, or that you've held the shares for a 6-month period. And even in addition to that, the Section C also makes clear that courts can compel production for any shareholder that proposes a proper purpose. And then second, when discussing and opposing shareholder proposals and derivative actions, even when discussing those for companies that have affirmatively opted out, indicating they're not going to adopt those, ISS inaccurately describes the threshold for derivative suits as being 3%, full stop. But that's not what the statute says. The statute says the company at its election can choose up to a 3% threshold. You could make it a 2 shares threshold, a 3 share threshold, or a 3% threshold. There's no acknowledgement or recommendation of the nuance in the law. And even more worrisome, in my view, is that after these verifiable inaccuracies were brought to the attention of the proxy advisors, they did nothing. No acknowledgement of the error, no corrective disclosure, and they didn't even fix the problem going forward when discussing other companies' proposals. In sum, the proxy advisor's uniform systemic opposition to Texas underscores the need for legislation like SB 2337. Shareholders deserve full and fair information from those trying to influence their votes. Federal law ensures that that's what they get from management, from the board, and from their fellow shareholders. SB 2337 closes a critical regulatory gap. It requires full and fair disclosure from the proxy advisors to Texas shareholders, Texas companies, and the Texas economy deserve nothing less. I welcome any questions the committee may have.
Thank you for your testimony. We're probably going to have questions after we hear from everyone. Thank you for being here. Welcome. Good to see you. Introduce yourself. Give us your testimony.
Thank you. Thank you, Chairman Hughes and members of the committee. Thanks for the opportunity to testify today. My name is James R. Copeland, and since 2003, I have been affiliated with the Manhattan Institute for Policy Research, a nonprofit public policy think tank in New York City, where I've long been a senior fellow and the director of the Institute's legal policy research. I also serve on the Investor Advisory Committee for the Securities and Exchange Commission. I do want to emphasize, of course, that my comments today are solely my own. They shouldn't be attributed to my employer or certainly not to the committee. I've also prepared reports and affidavits and litigation involving parallel issues, including SB 2337, and my comments are solely my own, shouldn't be attributed to any litigant or others in such litigation. I've been studying proxy advisory firms and their influence on shareholder voting at America's largest publicly traded corporations for more than 15 years. I published my first significant empirical study on these issues in 2012, which I wrote about in the Wall Street Journal that year. I think that op-ed and the study can be made available to the members of the committee. In 2018, I co-authored a study with Stanford's David Larker and Brian Tayan that laid out empirical evidence on proxy advisory firms and proposed various reforms. I've submitted multiple comment letters to the SEC and other agencies on this, which can be made available. I've testified before both houses of Congress on these questions, most recently last September before House Financial Services. All those can be made available as well. And I've sponsored and edited and published studies from outside scholars, including on the relationship between environmental and social shareholder activism and share value, and on robo-voting of proxy advisory firm recommendations. It was written by Paul Rose, now the dean of the law school at Case Western Reserve. So the sum of all this research is that two proxy advisory firms control virtually all of the proxy advisory market. Each is foreign owned. One is owned by the German stock market. One's owned by a Canadian private equity firm and its principal owner. Each of these firms has struggled with accuracy, as you've heard about from the other witnesses. Each has struggled with conflicts of interest, as you've also been hearing about. Each suffers from a significant lack of transparency about how it reaches its recommendations. And each has focused on overreaching environmental and social concerns that typically have an attenuated or an inverse relationship with share value. They have been particularly aggressive in supporting environmental proposals hostile to the interests of many large Texas employers. And you've just heard a significant recounting of how they have viewed redomiciling proposals for Texas in the most recent proxy season. So in addition to SB 2337 and other Texas lawmaking and lawmaking in various states, there have been recent federal efforts to regulate the proxy advisory industry. I want to sketch those out briefly for the committee. In July 2020, the SEC adopted amendments to the federal proxy rules that explicitly treated proxy voting advice from advisory firms as a solicitation under the Securities Exchange Act. And under this rule, proxy advisory firms could qualify for an exemption from the usual proxy solicitation information and filing requirements only if they adopted and publicly disclosed written policies and procedures designed to ensure timely sharing of voting advice with the company subject to the advice before clients received it, and ensured that clients had a way to access any written response the company made before the shareholder meeting. However, in summer of 2024, the U.S. District Court for the District of Columbia held that the SEC had acted contrary to law and in excess of statutory authority in the 2020 rulemaking. And so in essence, and it had already been backtracked after a change in administration, but in essence, the 2020 rule has been essentially vacated, leaving proxy advisory firms mostly unregulated under federal securities law. Now, last December, and Mr. Bledsoe can talk about this because he was involved in it, the White House issued an executive order urging a new effort at overseeing proxy advisors. The exact parameters of what will emerge from the SEC action in response to that White House executive order are not yet known. And in keeping with the aforementioned judicial rulings, there may be limitations in how much oversight the agency is statutorily authorized to assume. So in general, I want to emphasize there is room for Texas and other states to regulate in this area. Congress has not preempted states from overseeing proxy advisory firms. Corporate law and securities regulation remain an area of joint federal and state regulatory oversight, with states still broadly overseeing corporate law and federal law focused on disclosure. The Supreme Court has strongly stated that it will not presume federal preemption of state corporate law in particular without clear congressional directive. I emphasize also that the SEC has recently shifted toward broadly demurring in its oversight of shareholder proposals, traditionally governed through the agency's regulation of proxy statement materials under its Rule 14a8. This shift will place the onus more back on state law where it belongs and may substantially affect the role proxy advisory firms have traditionally played in influencing corporate behavior. With these shifts, state corporate law becomes even more paramount. Finally, while Delaware has long dominated state corporate franchises, its position is not inevitable, and interstate competition for corporate charters, even if mostly theoretical, and it's been mostly theoretical to this point, is a central underpinning of what my law professor Roberto Romano called the genius of American corporate law. Texas's efforts to enter this space, now with some success, are a very welcome development, particularly Texas's efforts to cabin aggressive, socially oriented shareholder activism affected through shareholder proposals, the ownership requirements previously discussed, and shake down derivative lawsuits that principally enrich plaintiffs' lawyers, which we've also just heard about. So I welcome any questions, and I look forward to working further with the committee members and staffers in this important work. Thank you.
Ms. Copeland, thank you. Ms. Bledsoe, welcome. Introduce yourself. Give us your testimony.
Chairman Hughes, members of the committee, thank you for the opportunity to testify today. My name is Eric Bledsoe. I'm a visiting fellow at the American Resolve Institute. American Resolve Institute is a nonprofit organization dedicated to promoting freedom, opportunity, and innovation grounded in the nation's founding values. Prior to joining the American Resolve Institute, I served as Special Assistant to the President for Domestic Policy at the White House from January of 25 to March of this year. For my tenure at the Domestic Policy Council, I could say that President Trump and his administration are committed to ensuring every American has the opportunity to pursue prosperity and financial freedom. That is why during his campaign even, the president promised to eradicate the politicization of the financial sector, which has weaponized Americans' investments and savings for ideological purposes, often without their knowledge or consent. That is why in the first year of his second term, President Trump signed Executive Order 14366, protecting American investors from foreign-owned and politically motivated proxy advisors. In the executive order, the president directed the chairman of both the Securities and Exchange Commission and the Federal Trade Commission to take action consistent with their agency's authorities to ensure proxy advisors advance investor returns rather than ideologies like diversity, equity, and inclusion or environmental, social, and governance agendas. Two foreign-owned firms, Institutional Shareholder Services, or ISS, and Glass Lewis control over 90% of the proxy advisor market. Many index funds vote in lockstep with their recommendations, so this advice becomes de facto control in corporate elections. Given this duopoly, proxy advisors have unmatched influence in corporate governance matters like shareholder proposals, board composition, and executive compensation, which impacts returns for investors, many of whom are just saving for retirement. They effectively decide how trillions of dollars in shares are voted. ISS and Glass Lewis have used that power to issue one-size-fits-all recommendations based off of political litmus tests rather than company-specific financial analysis. Those recommendations are then used by the fiduciaries who must vote in the financial interests of teachers, firefighters, and retirees. Take the example of board composition. From 2022 through early 2025, ISS generally recommended voting against the nominating committee chairman at large companies with, quote, no apparent racially or ethnically diverse members, and against the chair where there were no women. This is cookie-cutter governance, a fixed identity threshold applied across thousands of companies, regardless of performance, industry, strategy, or director qualifications. The proper fiduciary question is whether a director can help create long-term shareholder value. A rule key to skin color or sex is the opposite of company-specific financial analysis. Then the political weather changed. On February 11, 2025, ISS indefinitely suspended consideration of board, racial, ethnic, and gender diversity in its director recommendations, expressly citing President Trump's executive orders on DEI. A genuine financial judgment does not evaporate because an election turned out differently. Glass Lewis proves the same point, but from the other direction. Its 2026 guidelines still generally recommend against the nominating committee chair of a Russell 3000 board that is below 30% gender diverse, and against the chair of a Russell 1000 board with fewer than one director from an underrepresented community. The two firms now can treat the same company differently on the same political issue. That is judgment by policy rather than by financial analysis. And on the energy front, Phillips 66 shows the same machinery in operation. For the 2021 proxy season, ISS rewrote its benchmark policy to treat, quote, demonstrably poor risk oversight of environmental and social issues, including climate change, as grounds to recommend voting against a company's directors. A generic political standard it applied across companies, not the product of any company-specific financial analysis. Backed by that kind of pressure, an investor campaign coordinated through the activist network Climate Action 100 pushed Phillips 66, an American oil refiner, to pledge a 15% cut in the emissions of its products, its so-called Scope 3 emissions by 2030. In plain terms, the company committed to a plan to limit the use of the very product it sells. There is no company-specific financial case for that. It is a political objective routed through fiduciaries who are supposed to be voting for financial returns. The same season, the same machinery let a 4-month-old fund holding just 0.02% of ExxonMobil shares win 3 board seats. With SB 2337, Texas is protecting its investors by requiring proxy advisors to disclose a financial analysis providing an economic rationale for their recommendations. SB 2337 imposes transparency requirements and holds proxy advisors accountable to their responsibility to recommend votes that have a positive impact on returns for its investors. Reforms like these support at the state level reforms President Trump is advancing at the federal level, ensuring every American invested in their future can expect that their investments prioritize shareholder value. Texas could expand the law by requiring that the proxy advice that the Texas retirement system and other state fiduciaries receive is based on publicly disclosed financial analyses that are free from conflicts of interest, as has been mentioned a few times. Phil Anderson, president of America's Economy First, recently wrote that the proxy advisory industry is a problem created almost entirely by institutional laziness and regulatory drift. And now, 20 years on, 2 firms that nobody elected and nobody can easily fire have a quiet veto over a substantial portion of American corporate governance. Every American has the right to financial security and independence to access the American dream. Texas has the opportunity to promote transparency and bring accountability to how the shares and the funds it manages in its public retirement systems are voted. The state has a fiduciary responsibility to its beneficiaries. Teachers and firefighters have more than earned the right, after decades of public service, to retire with dignity and financial security. Measures like those in SB 2337 ensure beneficiaries remain on a pathway to prosperity. Thank you for your time this morning, and be happy to answer any questions you might have.
And thanks for your testimony. Senators, we'll open up the panel for questions. I have some, but I'll wait to see if any members have anything first. Dean, you're recognized.
Thank you, Mr. Chairman. First, is there any evidence that indicates that considering any environmental, social, or governance factors is inherently inconsistent with an investor's fiduciary duty?
There is. So Cliff Asness.
Pull the mic a little closer, Mr. Babcock, so we
Thank
can
you.
Go
Yes,
ahead,
sir.
thank you.
There is. So Cliff Asness, the head of AQR, a institutional investor fund, looked at ESG investing in a letter he published, I want to say 2019 or so, late teens. And he made the point, if you have a strategy to maximize financial value and you have the same goal, one strategy is constrained, one is not constrained, inherently the unconstrained strategy will do better. That is, if the constraints are added outside of your core goal, there is inherently a trade-off. And so if your strategy is focused on environmental, social, or governance goals, rather than purely pursuing what is the right financial interest, there is an implicit drag that shows up in the modeling.
Thank you. Anyone else?
Yeah, and Cliff is a friend, and I think he's absolutely right on this as a matter of theory. I mean, he studied his theory under Fama and Fringe and these folks. He's made a lot of money on it. We also did commission an empirical study on this question. The word inherently does a lot of work there. In other words, could there be an environmental or social factor that could add value as an investment strategy in theory? If the market is somehow not properly pricing it in, sure, in theory. But in general, Cliff's rule is almost a truism in terms of financial theory. Empirically, we commissioned a study by Tracy Weidke, who's an economist, professor at the University of Tennessee, to look at public pension fund activism and share value, because I'd been tracking, shareholder proposals in the environmental and social space for some years, and we're like, well, but the real answer here is there a share value impact? And so she, developing on a methodology she developed in her doctoral dissertation, started looking at this and looking at when public pension funds, and these are most often done by more blue state public pension funds, but are engaging in social activism through shareholder proposal sponsorship in their portfolio. What that impact is on share value, because you've got regular controls. They don't do that with all their investments. And what she found was an inverse correlation between share value and this sort of social and environmental shareholder activism. Now, that doesn't mean that there's always an inverse relationship in every case, but on average you find that. So I think it's an important public policy impact. There have been other studies as well, and I think while there's never unanimity among studies, I think the bulk of the research here would suggest that there's probably an inverse share value relationship. At a minimum, as I said, it's an attenuated relationship and a theoretical one. That in the aggregate doesn't really wash, as Cliff said.
Thank you. Should the state be involved in deciding what categories of information investors should consider, or should this be left to the market participants and investors?
So I think the important thing in the requirement for transparency with the proxy advisors, it's not whether or not the state supports the policies they want to vote for. This is not an issue that the state is opposed to ESG or supports ESG or other social initiatives. Rather, it cuts to the heart of the way the proxy advisory firms influence, not through persuading people investing their own money, but by persuading fiduciaries who are investing other people's money. And when someone is investing other people's money and has a duty to invest that for a financial return, their advice should either be consistent, we would suggest, with that shareholder financial return, or if it's not going to be consistent with that return, they should acknowledge that so that the third-party asset managers, who again have a legal duty to maximize return, can take the advice into consideration appropriately. This isn't a problem of advocacy. It's a concern that ISS and Glass Lewis essentially seek to push non-financial agendas through the mechanism of shareholder voting.
Thank you.
I think, from my perspective, the state should be broadly value neutral on these questions normatively. In the ordinary case, the select case is when you're talking about your own pension plans and your own investment strategy, and then it's really important for the state to adopt I think, consistent with share value norm. When it comes to the regulatory overlay, this is complicated by the fact you've got the federal and the state here, right? And normally disclosure rules are federal, but we have a vacuum, at least at the moment, when it comes to proxy advisory firms on this, and so and there's no preemption. So I think having various forms of disclosure or analytical requirements on the part of fiduciaries, or they're not really fiduciaries, but part of market actors, giving proxy voting advice that have massive impacts on the market. This 2012 study I looked at showed 15 to 20% market impact econometrically from ISS. When you add in Glass Lewis, it's probably about a quarter of the vote. Now that's probably shifted a little bit over time since then, but there's clearly still substantial robo-voting going on by smaller institutional investors, not the big fund families which vote on their own. When you've got something that's that significant, I think the sort of disclosure rules we're talking about and analytical rules are useful. And they're the sorts of things the SEC regularly requires of companies, of issuers, as well as institutions. So, how that state and federal fits together is a fairly complicated question. But in the absence of any federal role at the moment, I mean, I would applaud Texas for thinking carefully about this.
Thank you. Is there a risk that these policies could place Texas at a competitive disadvantage and that firms would rather go to states that don't have such requirements?
There's always a risk, but I think the obvious evidence cuts in the opposite direction right now. I mean, you've got multiple companies trying to re-domicile in Texas, so I don't think that's going to happen overnight because Delaware has such a dominant position here, has for 100 years, has a well-developed body of law. My colleague Robert Miller wrote a piece on this a couple weeks ago saying, I don't think Delaware is going to lose it all right away, but in terms of where you're going to incorporate, most big companies are still in Delaware, but the momentum is toward Texas, not away from it. So it's probably creating a competitive advantage in terms of corporate franchises for Texas, not the inverse.
And I agree with Mr. Copeland, is what we have seen in the proxy advisor's uniform recommendation against is that is chilling the willingness of companies whose boards have put in the effort and the diligence and the exercise of their fiduciary obligations to compare Delaware law and the Delaware regime to Texas law and the Texas regime and make the decision that would be in the best interest of the company and the shareholders. And yet they're hesitating to make that move now because of, not because of SB 2337, but because of the proxy advisor's unwillingness to explain exactly what it is that you need to do to get a for vote to redomesticate. I walked through a couple of the examples. Lots of different companies have done lots of sort of different moving pieces with the SB 29 stuff and the shareholder proposal stuff, and the sort of uniform result has been against. And so that's what's concerning from my view.
And I'll say one other point here. The concern is not that shareholders broadly agree and support these proposals and that ISS and Glass Lewis reflect the interest of shareholders investing their own money. What we hear time and time again when talking to companies who are concerned about the role of the proxy advisors, it's not because they think the proxy advisors are persuasive. When they talk to large asset managers, large institutions, and management is usually able to articulate and often persuade, not always, but when there's a dialogue and a way for discussion between a company and its shareholders, we find much more support for redomestication or other proposals. The problem is there are smaller asset managers who don't have their own stewardship teams. And so when ISS or Glass Lewis make a recommendation, and that recommendation is based on mistakes, it has errors, it's not transparent, it has omissions. Companies have no one they can call at some of these smaller asset managers to say, hey, your advice doesn't actually articulate this or doesn't cover this appropriately. And so again, the concern is not that ISS and Glass Lewis are persuasive, it's that they have a niche that allows them to substitute in some ways their judgment for that of the fiduciaries, and they do so while at the same time disclaiming any responsibility for the accuracy or content of their recommendations.
Thank you. When we considered this bill last year, critics said, and I quote, that the disclosure requirement would be onerous and burdensome for smaller advisory firms, and that the civil liability put on the proxy advisory firms would be chilling. Has that been the result of this legislation that you know of?
The legislation currently has not led to suits against the proxy advisors. The Attorney General is currently enjoined from enforcing it against the advisors, and so we have not seen the market effect of the law in full force.
Thank you so much. And finally, my fifth and final question is, our charge includes making recommendations for legislation needed to improve, enhance, or complete implementation of this legislation. Does any of you have any recommendations to that effect?
Yeah, well, I mean, I think it would behoove the committee to think about, legislation that could potentially moot the litigation, right? But I think, overall, it's a solid piece of legislation. I do think if the SEC comes down, and FTC's got a piece of this as well, as Mr. Bledsoe talked about, but the SEC is going to be the principal actor here. If they come down with rules vis-a-vis proxy advisors, I think that then it becomes imperative for the committee to think about that and what the interaction is between the federal and state regime. I mean, there still could be a place for state law here. There's not going to be complete preemption of the field, I don't think. But who knows? It kind of depends on that. I mean, if the feds preempt the Texas law completely, there still would be pieces of it that would be in effect, which are in effect, right? I mean, a threshold on derivative lawsuits, a threshold on shareholder proposals, because my instinct is the SEC will continue to push this towards the state level, and hopefully will do so formally. I've called on them to do so. So it kind of depends on what the SEC does, and it kind of depends what happens on the litigation front. But there may be ways to create safe harbors around what you're alluding to here. I mean, you don't want to create barriers to entry in this industry. I think it's very difficult to have new entrants in the industry. When we looked at it, ISS used to be owned by publicly traded American companies, so we could look at the books, and it's like, oh, they get 120 million in revenues, 2/3 of which is only on the proxy advisory business. 1/3 is the corporate side business, which is a conflict of sorts. That's not going to attract a bunch of big VC money, right? I mean, I think they get overpaid for a lot, and they get overpaid for because of their influence, not because of the economics of their business. At root, we have a problem with voting, which is a problem with voting every elected official is aware of, in that it doesn't make a lot of sense for a small asset manager to invest heavily in its voting, because that's not a competitive advantage relative to other asset managers. And so they try to discharge this at a low cost. And when you discharge it at low costs, and these are fairly easily captured sorts of businesses, that's why we have the world we've got. Texas isn't going to fix that on its own, but I do think Texas is very smart to be thinking about how this relates to Texas's pension funds, to Texas businesses, and Texas's efforts to have companies re-domicile here. So,
Thank you so much. Thank you, Mr. Chairman.
And thank you, Dean. Senator Betancourt, do you have questions, Senator Betancourt?
Yes.
You're recognized.
Thank you, Mr. Chairman. James, to your point, I want to make sure that that the whole subject of the Marshall hearings was to set a pattern of recognizing the obvious with Chairman Hughes's leadership, that we weren't going to accept ESG solutions on Texas retirement funds and having people come out and say, don't have our retirees' money being spent on high return Texas energy projects. Now, if I remember correctly, we had one of the firms actually dropped the ES before even the hearing, because they figured out that they could market a G solution in half the states pretty rapidly. But I just want to make that clear, at least from my one view, and I know the chairman also went through this in detail, that we're simply not going to allow proxy advisors to vote against use our own shares to vote against our own energy projects. It's really what was occurring. Okay, still is, obviously, because that's my second question. Gentlemen, all of you, how many companies have been basically by either ISS or Glass Lewis, how many times have they been advised not to move to Texas? Specific examples, if you have them. I think Brad or Christopher had them.
Yeah, I mean, so if we want to walk through this proxy season, ISS came out against the proposals to redomesticate to Texas from Forward Industries, which was from New York, Texas Capital Bank Shares, which was from Delaware, Arc Best Corporation from Delaware, EXP World Holdings from Delaware, T-Tech Holdings from Delaware, Exxon Mobil from New Jersey, Voyager Technologies from Delaware, Dreamfinders Homes from Delaware, First Cash Holdings from Delaware, AER Sale from Delaware, and Weatherford from Ireland.
I believe it's also come out against Dell and Archer,
right.
which are still pending votes.
Okay, so I'm counting 10, gentlemen, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Between, if I add Dow or Archer to the list, was Weatherford, is that the oil field supplier, or was that a different?
Correct. They're currently in Ireland. The vote did not pass. They received 62% of the shareholder votes, but they needed a 75% bar to make that.
So that's 9 votes. That's 9 votes that have already occurred. They've advised against, and 2 more.
That's right.
Right. Now, by chance, has anybody added up the total amount of CapEx on these guys, on these 11 firms?
It's over 800 billion. Exxon covers all. It
helps.
Yeah, it's over 800 billion.
Right. Okay. So nearly, Mr. Chairman, $1 trillion of total effective wealth, to translate for the lay people that are listening. They've advised not to come to Texas, and for what I believe is purely political activism. There's not a focus on what I would call the governance side of this or the shareholder side of this, but this environmental social activism. Now, you all have talked about how that can be baked into the market, baked into the decisions. These are things that are all part of our market forces that you have to go through this. But I just wanted to put a fine point on how much wealth is being prevented from coming here. Now, any estimate number of jobs at this point? It's obviously in the tens of thousands, but
I think it's hard to put a hard number on jobs.
because you're transferring a corporate.
Because
right.
you're transferring a corporate entity that tends to create jobs over time, that tends to create deeper roots to the state. But it's hard to isolate that from all the other factors. But I agree with you that it is significant.
So this isn't an esoteric discussion of what should be good public policy and the fact that you could have a more liberal view of environmental, social, or more conservative view. This is an absolute roadblock being put up by foreign-owned proxies to tell nearly $1 trillion of companies not to relocate to Texas. So, gentlemen, do agree with that summary? Eric, I've got a question for you since you brought this up. Obviously, there's a federal discussion about rules that relate to foreign-owned proxy advisors. Could you be more, should I say more descriptive to the audience of what's being discussed? Because it would appear that both ISS and Glass Lewis fall under that discussion.
Yes, Senator. To be clear, no longer speak for the administration, just here in my capacity at American Resolve Institute. What I can say is there are a number of provisions in the executive order, pretty clear. One thing that I would point out is for federal regulation to go back and examine the classification of proxy advisors. As James and a few others have said, really is a kind of gray area that proxy advisors operate in. And so one of the things to look at is regulation on how do we classify them? What are they? They're not fiduciaries. They are certainly actors in the corporate governance and financial space. So one thing would be to look at would they be classified as investment advisors, right? Which would actually put them subject to more disclosure and more requirements under federal law and regulation.
They're certainly acting as investment fiduciaries, okay? They give out advice and they don't have to maintain any type of transparency, whether it's true or false. They take no responsibility for their recommendations because they're not held accountable by any licensing standards that I understand, at least at this point. And look, you could have a debate about this because I think all of y'all recognize there's a mix of market forces here. But the Phillips example is pretty demonstrative as to what happens when you have a fight led by proxy advisors that people take the recommendation and rubber stamp and vote that way because they may not even understand what that recommendation is because it's not transparently disclosed that they have a bias. See, they clearly have a bias. Okay. Now, politics is full of bias, except that when you're running for office, that is on display with whatever communication you make to the voters en masse. And but here they don't have to even say they're biased. They don't even have to say what their opinion is based upon, and their opinion doesn't have to be right. It is wrong. Okay. And so many times, the debate I had, Mr. Chairman, with the ISS Representative Marshall, they were fundamentally wrong to advise the Texas Employee Retirement Fund not to invest in high return Texas energy projects, period. It's not up for debate. It's in the state's interest to get a good return on that money. And look, just the companies you've named, I used to work for Dow. Okay, in a galaxy long ago. I've got relatives at Weatherford. ExxonMobil's campus is huge up between mine and Senator Liggins. These are real operations that have real employment, that generate real wealth, and these proxy advisors, I believe, because of this of their political persuasion, of environmental, social, especially from the fact that they're coming from obviously what is a non-shareholder based view. They have already stopped $800 billion worth of companies from coming to Texas. Mr. Chairman, I mean, that's an enormous amount of money. It's a huge disservice to the state of Texas. It's a huge disservice to their shareholders because it's not even being debated in open transparency. I don't know, gentlemen, you got any comments? Am I missing it?
Three quick follow-ups on the federal regulatory point, right? One is there's nothing present, right? It is aspirational, right? It's a great executive order that acknowledges all of the problems, all of the regulatory gaps, right? Texas has done a really important job in filling that gap, but there is nothing working there now. In large part, that's because the SEC tried during the first Trump administration, right, to regulate them, say that their proxy advice counted as solicitation under Rule 14A9, and the Court of Appeals for the D.C. Circuit said no dice, so that's off the table. And then we're also seeing the push to the states, as we talked about with 14A8 and shareholder proposals. So I think it's still, even if the federal government is able to make some movement in this space to ensure that that regulatory gap is closed, it is important the work that Texas is doing, being on the forefront, filling this regulatory gap and ensuring that shareholders can receive full and fair information.
I think I want to highlight one of the points that Mr. Hubbard made earlier because I think it's so key to this. Everyone else who is speaking to shareholders in this context is subject to some sort of regulation, a fiduciary duty, a rule that prohibits errors and omissions, that prohibits materially misleading.
Some type of oversight.
Management is. If an activist investor thinks, I don't like how management's running this company, I want to go get shareholder support, that investor is regulated in what they can say. They have to be honest and transparent and let the markets play out. ISS and Glass Lewis have avoided deliberately that transparency and accountability, and that's why bills like 2337 are so important to try to bring some accountability to these actors.
Well, when you testify in other panels, just tell them that we're lucky to have a chairman that can write a bill like that and pass it. Okay, and that is, quite frankly, one of the major differences that why Texas is leading on the subject. Mr. Chairman?
Senator Bencourt, thank you. That the Marshall hearing you mentioned, of course, what gave rise to that hearing, one of the primary sparks for this committee and this legislature was when we learned, as you said, that ISS had recommended a Texas pension fund to vote for a recommendation that says we oppose future oil and gas development. That's just a hard one, and hearing them try to explain it was pretty fun. But that's what got us on this. That's what made us
Pretty
realize
sure
there's
I
a
was
real
sitting
problem.
next to Senator Perry when we learned that in the Finance Committee,
Yes, sir.
I believe.
Yes, sir. Yes, sir. I have a few follow-ups. This has really been helpful, and I thank the committee and the witnesses for your patience. A couple of mechanical questions I have. Mr. Babcock, we talk a lot about the votes at the annual meeting, and that's sort of the way I frame the issue at the beginning, talking about electing people to the board or unelecting people to the board or shareholder resolutions. But tell us a little bit about what goes on before the meeting, because we know that many times, at least I've been told, and we had testimony that many times, long before that meeting takes place, because ISS and Glass Lewis are calling these companies or telling them what they think, what they want, can that often affect what's even brought up at the annual meeting? Tell us about what's going on before the meeting takes place and what a big effect they can have there completely in the shadows.
Absolutely. So to give an example, the board has, at an annual meeting of shareholders, only certain items come up. The election of directors, it's very similar to a representative democracy, where the shareholders elect their directors who will then serve and generally operate the company. Certain major decisions and certain requirements of federal law are also voted on. So there's a say on pay and advisory vote on compensation that's required by the SEC. If a board wants to pursue a major transaction, a merger, an acquisition, a sale, or coming to Texas, something that is a fundamental business transaction is how the TBOC refers to it. Other state laws use different language, but the same idea. Those are proposed by management and considered by the shareholders at the annual meeting. All of this is public. Management's proxy solicitation is filed with the SEC. There are often campaigns to reach out to shareholders to explain their view, to take feedback, to make sure that the shareholders are aligned and comfortable with the vision. And management bears a reputational penalty and a cost if they make proposals that are voted down. They want to be seen as, they of course want to lead, but they also want to make sure that their guidance, their suggestions are those that are broadly supported by their shareholder base. Oftentimes, when a company is considering a significant transaction, one of the things it will do is it will sit down with its internal investor relation professionals, it will hire outside advisors, and it will ask, what support do we have for this? Do we believe not only that this is the right thing for shareholders, which is our lodestar duty, that's the first duty, but they're also going to ask, even if we believe it's the right thing, will we get the requisite support that we need? And so when ISS and Glass Lewis are known to vote against Texas constantly, for an example, just because, again, we've seen that this year, and that's the data that we've been looking at most carefully, they're going to ask, can I win a shareholder vote without ISS, without Glass Lewis? And that's probably going to have a drag of 10 to 15 to 25% of the votes. And if they believe that they can't, if they believe that they cannot win the vote without ISS and Glass Lewis support, and ISS and Glass Lewis have taken an inconsistent and changing but constant opposition, they are likely not to bring that to a shareholder vote because management is going to see the cost of a failed proposal as significant and not likely to go forward if they don't expect they have the votes. This is difficult to quantify because this happens in private conversations for months ahead of time and doesn't often percolate up. We can see some examples. For example, a company that looked to come to Texas prior to the effectiveness of SB 29, prior to the effectiveness of SB 2337, was Mercado Libre. They had a proposal to the shareholders. ISS and Glass Lewis recommended against it. That resulted in the proposal being withdrawn without ultimately going to a vote. And that was fairly far along. There are many proposals that simply don't happen, and we don't see the data because of the chilling effect of these two advisors.
That makes sense. We've also heard testimony about company policies broadly, where a CEO or a company owner or a company management is told by ISS, for example, meeting's coming up, we control this many shares of your retail shares. We think you should consider taking your company in this direction. That's what. Tell us about that. We know that happens. We've heard testimony from company management about that happening, not just about a redomestication or even maybe not even a vote before the shareholders, but a direction the company's taking, a policy, a social political issue that ISS cares about but doesn't do anything to add value to the shareholders.
That is correct. And so ISS and Glass Lewis interface with companies. And ISS and Glass Lewis, not only in their public policies, but also in conversations with companies, will discuss what their policy is looking like with a goal for influence. Because ultimately, what ISS and Glass Lewis sell is their ability to influence companies. They're not selling. They might disagree with this characterization, so I want to be clear this is my view. But they are not necessarily selling voting advice. They are selling an influence over the process that is difficult to identify and quantify because most companies who have these conversations do not want to come and testify about those. And so I can't talk to any particular conversations that I have heard of or been aware of.
Of course not.
But I can confirm that such conversations happen. And ISS and Glass Lewis often seek to influence companies to adopt policy views that ISS and Glass Lewis ultimately believe to be supported, not based on financial analysis, but based on their own policy view. And again, I think it's worth emphasizing the great work of 2337 was that it acknowledged that ISS and Glass Lewis can campaign, can have views, can articulate them. What is problematic is when they launder policy advice as financial analysis and financial advice fit for fiduciaries to vote on.
Well said, Mr. Babcock. That those conversations have been likened, those private conversations have been likened to Chicago in the 1920s when Al Capone's guys come by your store and say, hey, you got a nice store here. I'd hate for it to burn down. I can help you with that. I'm not the first one to make that observation, but thank you for that. Mr. Herbert, let me follow up on that. You talked about conflicts and, Professor, do you have something else on that? I want to ask you something else, but we don't want to miss it. That's okay. Okay, well, you won't forget. Mr. Herbert, you talked about those conflicts, and it relates to the conversation Mr. Babcock and I were having about these communications. So tell me if I got this right and clean this up. But my understanding is I know that I'm a public company, and ISS is going to be making a recommendation about how my shareholders should vote on my recommendation. I can hire ISS to help me get a better recommendation. Did I get that right?
That's correct.
Tell us about that.
I mean,
Get the microphone closer.
You have that exactly correct, Mr. Chairman. Their consulting services provide guidance on securing favorable voting recommendations, how to improve their governance such that ISS will then give the proposals from the company a for vote. And they don't disclose in any of their, they turn around and then say, we advise yes, for or against, and they don't disclose that, well, our consulting arm also worked on this particular issue at the company, provided consulting services to this company. They acknowledge broadly that they provide these services, but tend not to disclose in their reports whether they provided services to an individual company. And they say, well, we have a firewall between the two sides of the house.
That makes me feel better. Go ahead.
And right, and that was I was an accountant before I went to law school, and that was the sort of same approach that what was then the Big Five took. They provided the same consulting services and assurance audit services to the same companies and had firewalls between the teams, and we know where that led.
I want to ask you about one more thing. You talked about, there's been a lot of testimony about the recommendations and what they're based on. You shared some objective falsehoods or errors. You were talking about their characterization of Senate Bill 29, and if I wrote this down correctly, you said that they said that the new Texas law requires a 5% threshold to get books and records access. Was that was in a recommendation published by one of these proxy advisors?
That was correct. They described that as being one of the reasons why ExxonMobil should not re-domesticate, because it would be harder. It would hurt the shareholders' ability to access books. It did not acknowledge that there was the 6-month holding period. Did not acknowledge subsection C, which allows a court to compel production for any shareholder who shows a proper purpose. Right, in New Jersey, they always had to go to court, and they didn't disclose or mention that of the books and records that are available under the TBOC are broader than those that are available under New Jersey law. So it was all kinds of, it was very surprising.
Well, and thank you for that. And lest I repeat that and confuse people, I want to make it, you've made it so clear. There is no 5% threshold for seeking books and records access under Texas law. Never has been, never will be. At least I'm not going to vote for it anyway. Not in the bill. Not in the bill. You're so right.
It wasn't in the bill either.
That's right. It was not. It was not, Mr. Chairman. Thank you for that. Then you also shared with us that with regard to some of these factual errors in these reports, when these were brought to the attention of the proxy advisors, they immediately corrected and let folks know they got that wrong.
No, and again, that is you talk about and you think about what is the impact of the proxy advisors not being subject to regulation and not facing any consequences for failing to disclose conflicts or any accountability for being wrong, right? If that were to be right, because everybody else participating, right? The board owes fiduciary duty to the shareholders. They have done the research to say, look, this re-domestication makes sense. We've thought hard. We've compared both of the laws. Their statements, management statements about re-domestication, all subject to federal securities regulation. If they got something wrong like that was pointed out to them, you would expect a corrective disclosure, and you would expect one promptly. And what you did not see is not only did you not see a corrective disclosure, you didn't see an acknowledgement of error, and in even going forward, right, when opining on other re-domestications, they continue to make the same error. And again, I think that is part of the, right, with SB 2337 enjoined and no other sort of regulatory structure filling that gap at the present moment, that's what you get.
If I may say, just briefly add on to that.
Pull the mic over and go ahead. Thanks.
I think what's also important to remember is when they make these statements that are incorrect, if management made comparable errors, management would be subject to fiduciary duty litigation. It could prevent the validity of a corporate transaction because shareholders were not fully informed. It can be subject to litigation under 14A9 of the federal securities laws of the Exchange Act because management had materially misleading statements or omissions within their proxy solicitation. When management responds, which is seldom because often management may not want to respond even if they know it's wrong, they feel they've got the vote or for other reasons. But when management responds to correct these errors, that statement subjects management to liability when they try to correct the errors and omissions of ISS and Glass Lewis. Meanwhile, there is no lawsuit against ISS or Glass Lewis for comparable errors.
I did not realize that. Senator Perry, you're recognized.
I'm sorry, Mr. Chairman, and I'm probably going to ask a question I should know. I wasn't at the marshal. I don't think I was on your hearing. I think at the time I got added after that. Probably a good thing. So here's the question of the day, and I'll try to frame it so you don't have to give me a how the car's made speech. Does the board ultimately have to take their recommendation? Basically, what you said a while ago is no.
No.
There is extortion, possibly, by practice. If they don't take their recommendation, then they could be publicly ridiculed for not taking a recommendation, I assume.
The board does not have to take the recommendation, and shareholders don't have to take the recommendation.
Okay. So I'm trying to get to just who do these guys get paid from?
So I'm trying not to tell you how the car is made, so give me a second as I try to get to the right.
Somebody writes them a check. Is it a contract with the board and these folks, or is it all these individual shareholders they cobble together?
So, and I think that's the issue, is that they are not advising individual shareholders.
Okay,
Their
there you go.
clients tend to be asset managers who in turn are fiduciaries of the individual shareholders. So an asset manager, I'm saying asset manager, but think of someone wants to start a mutual fund. Someone has an idea and they realize I can make a profit on the market picking stocks. I can charge a fee and I can let people get hopefully rich, hopefully grow their wealth by following my advice. I know how to spot a trend in the market and I can invest on that. So someone sets up a fund and they take investors and they have fiduciaries to the investor, and their skill set is identifying what companies they think are going to generate an appropriate risk-adjusted return.
Right.
Well, for 2 months out of the year, almost the vast majority of public companies have an annual meeting. All of these annual meetings have director elections. Many of them have say-on-pay votes. All of them have auditor ratifications. And then there are also a handful of fundamental transactions being voted on. So you've got someone who has a really good investment thesis, but they may not have studied the dynamics of what makes a good board or not.
Sure.
They may not have studied this, and they want to keep the fees they charge their investors low. They have, under law, a duty to vote their shares. And so what has happened is ISS and Glass Lewis have said, we will prepare third-party advice that you should feel comfortable relying on in voting these shares. That structurally is not a concern. The concern is when the third-party advice does not publicly but privately disclaims that it's going to the standard to which the asset manager is going to be judged.
I appreciate exactly the fiduciary responsibility. And actually, as a corporate board member, your sole responsibility is shareholder return, like it or not. I mean, someone that's in the business of doing things that we know are not good public policy from a health perspective are still required to look to their bottom line investor return. That's their fiduciary responsibility. You've said it 100 times. I agree. My point is these hedge fund guys are the middle guy, but they've accumulated enough shares to be influential in decisions. And what I'm hearing from you is this guy over here is peddling influence with those guys.
What we find is some of the larger asset managers tend to have their own internal stewardship teams. So JP Morgan, I believe publicly this year, said they're no longer hiring the proxy advisors. They have an internal team. Other large asset managers.
Which you would expect that. And if I'm an attorney, a smart attorney, I would probably sue the crap out of them if they took advice from a hedge fund, from one of these groups that presents a return impact, because you didn't do your own due diligence. But here's a question I have. Set that aside. I get it. Do these proxy people ever get involved as a silent campaigner? Do they advocate for board positions through other influence? Are they influencing the board, not the hedge funds, but the board? And I guess hedge funds have managers that are elected too by how they run. But
they influence the board in two ways. One, they have policy guidelines on who they're going to, because the board is up for election, usually every year in most companies. The board is up for election. ISS and Glass Lewis will often have vote no campaigns against directors if they're opposed to them. For example, Southwest Airlines, a longtime Texas corporation, after SB 29 adopted a derivative.
So they're the dark money, if you will, of the investment world.
I think that's a fair metaphor.
Okay. All right. That's where I think, in my humble opinion, you can hire people to do your research. You can have them have some influence on your decision because their research is better than your research. But when they start impacting the governance of the board of the company indirectly through campaign or black money, dark money, or, for lack of a better term, but kind of setting up a cabal, right? That internally they can disrupt the final say over what hedge fund we use. That's the board. Over how we're elected and who we're elected. They get in there and start messing in that area. But you can say with confidence the vote no campaigns against this guy as a director for this board of trustees is real.
It is real, and companies take them very seriously because, again, ISS and Glass Lewis, again, generally studies vary, but are strongly correlated with 10 to 25% of the vote, depending on company and how it's built.
Summary real quick is ultimately the board of directors, the trustees for the corporation, Exxons, those are the guys that control. But what we've allowed is unaccountable control mechanisms to interject into the process.
That's correct. I would probably say influence rather than control, just to
Well,
be, but
no,
I think you can frame it either way.
I think it's control. I mean, influence and control, two different things. You ultimately have to either have the proverbial cojones to run your company or not. Fair enough?
That is fair, sir.
Okay, so buck stops where those sit.
I mean, the control or influence, whichever you want to say, is sort of indirect but very real, right? If Glass Lewis says, if you don't have the right percentage of gender diversity or racial diversity that we think is right on your board, we're going to vote no on your directors, then even though the fiduciary duties rest with those directors, they can influence that campaign. And if they can influence a quarter of that vote, that's a very strong lean.
Well, I appreciate the pressure it applies, but it goes back to what is the number one goal for a corporate board of trustee is to maximize shareholder return. And again, I don't say that's always a good thing. People are making lots of money on bad things. I can list a whole lot of corporations that their whole livelihood is making a lot of money for their shareholder returns on bad things. But set that one aside. They control all of this. And in any, 25% vote conversation, that would tell me that maybe you as a board are not in the right direction. If there's that much that's being weighted against you out there, then maybe you got the wrong policy and it should be a consideration. But I understand the ESG movement very well on a very practical level outside of the public market. Local banks in small communities were being held to those standards, and it was drying up capital. So I get the conversation about bad public policy being coerced and the impact it has on the average working day mom and pop stores when their banks say, I'm sorry, we'd love to loan you that money, but really we're out of balance on this issue and we're being judged by federals that are going to threaten to take our FDIC insurance away for our investments if we don't do this, and you don't fit the mold for that. We've got to loan this over to here. So I get that coercion that took place through federal overreach, but I'm just saying at some point we as a legislature can do a lot of good things, but at the end of the day, it comes down to a decision by a board to say, you know what, that's not applicable to my shareholder returns, and you can threaten to mess with me. If that's a public policy that the shareholders want, then I'll hear from them. But you got to take that risk, because what we're doing is circular. We're in this track. Well, it's not me, it's them, and if they say they can't, we're not going to solve it. We can find a way to enforce. I think that's what's next, right? But the board, the truth about it is these groups usually provide cover for really hard conversations that they really don't want to have. So I don't know.
Just one counterpoint to that, Senator, is that we saw 12 boards making the hard decision and putting to a vote the move to Texas, right, in the exercise of their fiduciary obligation, knowing they were going to face that opposition. We've got 12 boards that did that, and of those, 11 of them all got the against vote still. And I think that is the part that is hard, right? So even if you have, the muscle and you go, and look, it was great to see that of those, 10 of them passed, but it was very unfortunate to see the ones that the shareholders, right, because there were some set of the shareholders that voted with the proxy advisors instead of with the board's advice. The company ultimately did not get to redomesticate to Texas.
Yeah, I'd say just because it's not popular doesn't mean it's not right.
Completely agree.
And ultimately, I believe in Texas that the truth shall prevail and that your returns are maxed in Texas. When it comes to this issue, ultimately, that proxy vote changes character and goes away because they don't like the value of the corporation or whatever that be, that weird, obscure, emotional feel that's tied up in all this junk. It will go away and they will come and they will bring their money. But it's just something that you got to be, it's kind of like if you never go out there on that limb, you're never going to get it fixed. And for the ones that are, thank goodness they are. For the ones that don't, they're going to get left behind because we are going to be, unless we screw it up, we are on the track to continue to be the economic engine that everybody migrates to. So shareholder return will interject back into this conversation at some level as this other stuff goes away.
That's right. I think the one thing I might say, sir, in respect, I think I agree with everything you've said, that ultimately the board is a fiduciary. It's their responsibility to do this. What Texas can do is make sure that these conversations, which are public conversations, right? They're conversations between boards, their shareholders, they're being done in full view of the market. Texas can work to ensure those conversations are transparent. And if ISS or Glass Lewis are providing recommendations, they're showing their work so that those can be properly evaluated and treated in the market. And so you don't have to go and dig into a bunch of research as to who this is and what's actually driving it. We can simply require, which is what 2337 did, that when advice is given to people who are managing other people's money, that advice needs to be transparent with the rationale explained so that those persons who are managing other people's money can ask, am I being a good fiduciary by following this? Or is this driven by something that isn't appropriate for me to be looked at?
I do agree with everything that the chairman's done and where the state of Texas is. I just want to highlight the fact that the buck stops somewhere. And those folks have to be willing to go there, and they'll have the support of Texas Legislature when they get in those fights. And we should step up. But we can't be the policeman for social conscience at an investor level with a hedge fund between us and them, because they control too many other assets that people in Texas depend on.
That's right. That's right. Professor, I want to ask you a couple more things. And thank you for this testimony, and thank you, Senator Perry, for filling out the waterfront on what's happening here. When did you said you've been studying proxy advisors for a while? I don't recall when you said that first started.
I started following the shareholder proposal market around 2010, and my first study I did on proxy advisors specifically, and it was on ISS because that's the data set I had, was 2012, so sometime.
All right. I'm curious because at the beginning I characterized the role of proxy advisors, what they've done historically, and it was a generalization. I think I reminded my dad said something one time about how no generalization is reliable, including this one. But what I want to ask you, is it fair to say that at one time proxy advisors were more of a corporate hygiene, good governance Senate, then this drift or lurch took place where it began to take on a political agenda? If that's a fair characterization, tell us if you think that is and when, if so.
Yeah, I think that's right. Our database went back to about 2006. And you saw around the time we started studying this, we started studying it for a reason, around 2008 to 2010, you saw more leaning in from the proxy advisors in the direction of sort of the E&S components of ESG. I mean, ESG was launched right in front of that time. It was launched through the UN. It was launched through the finance industry and banks and things like that. And so you saw a gradual shift in behavior. Not to the level it became, within the last 5, 6, 7 years. Around 2017, that's when you saw some of the big fund families, the passive investor families, the State Street and BlackRock in particular, started to lean in on some of these questions, and they've backtracked now some, and ISS has backtracked some, and after the election results, as Mr. Bledsoe said. So it is it's gone a little bit back and forth, but they were under some pressure, right? I mean, I've done comment letters to ISS as well because they'll take outside comment letters. They don't listen to me, but as part of their policy guideline making process. The social investing funds are very active in this, even though they have small market share in terms of their ownership. And then some of the big state pension funds, New York's been particularly aggressive in this area, leaned into the proxy advisors. So, their policies were easily influenced in that direction. And unlike the institutional asset managers, they don't have to, retain capital. They just have to basically be able to help execute these voting fiduciary duties. And there's not the SEC has guided that there's not an express fiduciary duty to vote every share on every question, but there's an implicit assumption there that needs to happen, and so it's a way for them to discharge it. It's sort of it's effectively a safe harbor. You use the proxy advisor, you're kind of off the hook. It's not actually a safe harbor, but it's a de facto safe harbor, which is how they get this sort of level of influence. But when you control a quarter of the vote of all the big corporations, and then you're not at all, the transparent, you're not accurate, you have conflicts of interest. I mean, this is a big issue, right?
Yes, sir. You spoke about the market for doing this and how it's pretty much ISIS and Glass Lewis. I know there's been other folks getting involved, talking about getting involved, and you spoke to this briefly, but why the barriers to entry? So it's not is it a big capital cost to get into this business? Maybe there was a time when you had to have someone at the SEC looking through the physical, literal circulars. I don't know if that's still an issue, but
I mean, executing millions of votes every proxy season, and most clients, your institutional investors that would want to hire an ISS or a Glass Lewis, want to be able to execute on a global platform, so it's not just U.S. Right. It's a big enterprise, so there's a pretty big upfront cost, and as I said, a pretty low economic payoff. I mean, if your total revenues were 120 million. And only 2/3 of that, so only 80 million of that is in your proxy advisor business. That's a decade old. It's more than that now, but you're not getting massive cash flows from that upfront investment. It's something I looked at. I mean, I sort of was like, if I had enough capital, I'd want to do this, right? I mean, I think some of our rich billionaires may want to think about doing it as a loss leader to clean up this market, perhaps, right? I mean, but that's their money, right? But I think it would be kind of a loss leader. I mean, I think you could make a profit with it. I do think the economics are going to shift. I mean, part of what J.P. Morgan announced when they said they were going to do this in-house is that AI and other technologies will enable execution of some of the nuts and bolts stuff that traditionally proxy advisors took care of at significantly lower cost than it historically has been. So that may shift.
The custodian work they do.
That's right.
Go ahead, please. Go ahead.
Yeah. So I mean, I think technology and technological developments will shift the barriers to entry here, and that could be a good thing. And so we'll see how that evolves. I mean, sometimes the market will fix problems, right? But I don't think as a legislature you'd want to assume that it's going to fix it or assume that it would fix it in a good direction. But I do think that the barriers to entry there, could drop significantly in the near future.
Thank you. That makes sense. Mr. Bledsoe, you talked about the executive order, and thank you again for your work that you were doing then, where you are now. Tell us what the response was in the industry once that executive order, the one particularly about proxy advisors and about their advice, once that landed.
Yeah, once that landed, the response that we heard was overwhelmingly positive. So a lot of conversations with major company CEOs. They'd probably be upset if I said their names, so I won't. But what we can point to, which was mentioned a couple times already today, is that Jamie Dimon himself, the CEO of J.P. Morgan Chase, came out publicly and said, so it wasn't just some press release they dropped hoping it'd get buried. This is a pretty out there public statement that he said we were no longer going to use proxy advisor services. We're going to develop our own internal system. Where that goes, I think Jim's right. We'll see. We'll watch and see. But certainly a positive signal that major companies, asset managers are taking a second look of how this decades-old industry that has dramatically shifted towards politicization is going to operate.
So thank you. And Mr. Bledsoe, Mr. Copeland, Mr. Hubbard, Mr. Babcock, thank you all for your preparation, for being here, for sharing this with us, and the work you're doing. This can be pretty dry stuff, and thank you for helping it make sense. That's right, and helping it apply to the real world, and again, to Texans and to their retirement, to their savings and their investments. And yes, we want, as Senator Perry said, we don't want to mess it up. Texas is the economic engine, and I appreciate what you said. We were talking about redomestications. It's early, and I appreciate. I wasn't offended when you said the move from Delaware. The trend is mostly theoretical, but we're encouraged. We're encouraged. So things are moving in the right direction. And again, we'd love for Delaware to clean up their act a little bit, but it's fine if they don't, because there's a place here, and the goal of Senate Bill 29, which put those changes in place, was not to put a place where management wins, where the board wins, where one side with the deck is stacked. Their goal was to provide a predictable environment. So unlike the Delaware Chancery Court, which has just become kind of all over the place, the goal was to create a place where you can risk your capital and know what the rules are. No, they're not going to change arbitrarily. If you pollute somebody's water or run over them or blow them up or your product messes up, you're going to be held accountable for that, of course. But you're going to know what the rules are, and you're going to be able to risk your capital and create jobs, and that's going to be good for everybody. So thank you all for your testimony. Thanks for being here. You're excused.
Thank you.
We turn now to election security. The Lieutenant Governor has charged the committee to study how we can strengthen the security of our elections, guarantee access for poll watchers, how our counties are administering elections, and whether anyone has attempted to circumvent the laws that the legislature has passed. Secure elections, obviously, the foundation of a representative government that we cherish. Every Texan needs to know that their vote counts, that the laws followed in every county, that the rules are the same, and that the citizens of our law entrust to watch the process can do the job that they've been given. So we've worked to protect the integrity of our elections for many sessions, and if you look at the major reforms done around the country, Texas is there. Texas has led the way, but obviously there's work to do. It's never going to be finished, and where our laws are being followed, we want that on the record. Whether they're being tested or evaded, we want to hear about it so that we can act. And so the next panel on this topic, we call Christina Adkins, Jennifer Dornoff, Ed Johnson, Chad Ennis. Because this is a large topic, so we'll be talking about election security on this panel, then we'll be talking about election efficiency. There may be a little bit of overlap, a little bit of bleed, but be aware we'll be having a similar panel for two related topics. And obviously any senator is welcome to ask any question they wish. We will go through the whole panel and then go for questions unless someone feels strongly they need to ask a question before that. Ms. Adkins, welcome back. Introduce yourself and give us your testimony.
Good morning, Mr. Chairman, members. Thank you all for inviting the Secretary of State's office to participate in the hearing today. My name is Christina Adkins, and I'm the Director of Elections for the Texas Secretary of State's office. One of the primary goals of election administration is to ensure that we have safe and secure elections. And I think it's important to note that this starts well before the election process even begins. It starts with the voter registration process. An accurate voter registration list is critical to election security, and it is foundational to having challenge-free elections within our state. When we speak about voter registration, it's important to note that list maintenance is an important component to voter registration. List maintenance is the process by which we routinely review and review our voter rolls and look at data to determine if there's any eligibility issues or residency issues with individuals that are on the voter registration list, because we want to maintain an accurate voter registration list. Texas has a very robust list maintenance process. However, we have been under the moratorium imposed by the National Voter Registration Act, or the NVRA, since December of this past year. So this summer, now that the primary runoff has completed, our counties will be engaging in their routine list maintenance activities that are required both under state and federal law, and that ensure that our voter list is accurate and up to date. A couple of things that are important to note with respect to list maintenance. Most of our list maintenance activities are defined in state law. We have Texas laws that go back 30 years that give us strict parameters on how to run this part of the voter registration and election process. We require strict matching criteria for almost every data set that we provide to our counties, or that counties review on their own. And that's because we want to ensure that these matches are identifying eligible voters and voters that are on individuals that are on our voter rolls, that we're not being overly inclusive or overly broad in the matches that voter registration list maintenance might uncover or find. That strong matching criteria means that we're typically matching on first name, last name, full 9 of Social Security, Texas driver's license number, or a combination of those two things. It's also important to note that an important part of list maintenance is understanding the protections that are in place for voters. If a voter is incorrectly identified in the list maintenance process, or a registration is canceled, and we've discovered that the underlying eligibility issue is not an issue for that individual voter, Texas law protects that voter. It says that the individual is reinstated immediately, and if it's discovered in the election process, the voter can vote a regular ballot that day. And I think it's important to note that both sides of that, the strong matching criteria combined with the protections for that voter, that individual voter, is what makes our process in Texas such a strong process. Two things to note. We have two big list maintenance activities that are coming up here. One of them is brand new. First, we are doing our duplicate matching process this summer. This is where we go through to identify potential duplicate matches across the state to ensure that we don't have registrations or individuals that are registered in multiple locations. That can sometimes happen inadvertently in the election process. The other piece of list maintenance or the other new list maintenance process, rather, that we're about to roll out to our counties is a new process related to commercial mailboxes. This is an issue that's gotten a lot of attention over the last few months. We utilized our audit program. Our audit team that we have in our office has done substantial research, and by the end of the month, we'll have reviewed all 254 counties to identify potential commercial mailboxes in each county. That list of commercial addresses will be provided to each county so that they can review it to determine accuracy with that list. And then, of course, we do have a process from Senate Bill 1111. It's one of Senator Betancourt's bills that provides a specific confirmation notice process for these individuals that are registered at a commercial mailbox, which we consider an address under Texas law that's not a valid address for registration and not a valid address for residency. A commercial mailbox address can be used for mailing purposes, but not for actual voter registration purposes. And so this is a new data set that we're about to provide out to our counties. One of the other things that I think it's important to note, and that's gotten a lot of attention, is the Secretary of State's office use of the SAVE system. In 2024, we began the process of executing an MOU with USCIS to utilize the SAVE system, and we ended up signing that MOU in March of 2025. We used SAVE on a limited basis in the spring to determine its effectiveness in validating citizenship, which is something that is an eligibility issue in Texas elections. And so we looked at it, we tested the data, we reviewed the accuracy of that data to determine how this could be used in Texas to aid our list maintenance process. And at the time, potential discussions that were being had about front-end verification for citizenship. Since that time, our office has taken the steps to proactively verify the citizenship of all Texas' current list of registered voters through this federal SAVE system. Our office took these steps in order to ensure that most currently registered voters would likely not be impacted by any future citizenship verification requirements that may be imposed, and that only eligible voters remain on our list of registered voters for the state. This also helped us identify individuals who may have mistakenly become registered through no fault of their own and allow them to be removed from the voter rolls in a timely fashion. One of the things that we have noticed over the years, I've been at the Secretary of State's office from 2012, and going all the way back to 2012, we do periodically get inquiries regarding individuals that are in the naturalization process. And oftentimes, we will get inquiries from DHS regarding registered voter status. We get inquiries from those individuals that are being naturalized, requesting verification that of their vote history to prove that they've never voted, because this is something that could impact the naturalization process. And so, anecdotally, looking at our experience at the Secretary of State's office and in talking to many of our county election officials, the great majority of the time when we see individuals that are non-citizens that are registered to vote, it's typically an error. Those voters don't even know that they're registered and are swiftly taking efforts to remove their registrations because they don't want it to impact their naturalization process or their immigration status in the United States. So this is something that can protect the overall accuracy of our voter registration list, but it also provides protections for that individual to prevent them from making a mistake or having an action taken against them that could impact their immigration status and their presence in the United States. As a result of our work, our office identified approximately 2,700 potential non-citizens. This information was sent to our counties for further review. Again, it goes back to the initial point that I was making about protections for the individual. When this data is provided to our county election officials have an obligation to review that data and make their own determination as to what information or what notices they sent out to those voters. Our counties are well-versed in the list maintenance process when it comes to non-citizens because we have been doing a list maintenance process utilizing DPS data since 2021. And so our counties receive this information, they review it, they go through their own internal records and their own internal review process to make determinations as to whether any notices should be sent out to those voters. And I will say we have been discussing this with a lot of our counties. Some of our counties have requested some additional data from our Department of Public Safety, from DPS, to aid in their validations, and DPS has been assisting us in this area. We have recently asked them, several months back, we asked them to go ahead and do a full review of that 2,700. Since our counties were in that NVRA moratorium anyway, it gave us a little bit more time to do some additional reviews based on county requests, and we expect to get that information from DPS soon, so that we can do a comparison to see what information DPS has with respect to citizenship in their records and how that compares to the SAVE system. Current Texas law, however, or let me say what I've been discussing is the list maintenance process. This is how we validate citizenship on the back end. But our current Texas law right now doesn't provide for a front-end verification process. We don't have anything other than the attestations on the voter registration application where somebody says, I am a U.S. citizen, to validate an individual citizenship status. During the 89th legislative session, Senate Bill 16 from Chairman Hughes provided a documentary proof of citizenship requirement for all individuals that are registering to vote. One of the things that SB 16 did that ties back into the SAVE work that we've done is it provided for voter registrars and for the Secretary of State's office to utilize government databases to help identify U.S. citizens and provide that documentary proof of citizenship, which means that the work that we have done in SAVE already in running our voter rolls through SAVE means that we have already done most of the heavy lifting on that bill should that legislation come back and we have a front-end requirement on citizenship verification. Most of our Texas voters won't be impacted by that because we did retain that documentation that we received when we utilized the SAVE system. And so we stand ready to work with the committee or any members on any other legislation regarding citizenship or regarding either the list maintenance or the front-end verification process. But I wanted to provide context to you on what we had done with SAVE and how it could be utilized for some of the legislation that's come before this committee. In addition to that, I think it's important, since we're talking registration, to talk about the statewide voter registration and election management database that the state utilizes, known as the TEAM system. The team system is the statewide database that we are required to maintain under both federal and state law. We are on, since team first began in the early 2000s, this is, I believe, our fourth iteration of the team system. There have been various iterations of it over the years. It used to be maintained in-house. We now have a vendor relationship that has proven to be much more effective in being able to get quicker responses and to deal with the large volume of data that the system houses. As part of our transition to the new team system, we had to migrate over 20 million voter records in addition to millions and millions and millions of street-level data and data segments to ensure accuracy within the system. This is a monumental task. A huge data conversion project like that takes a substantial amount of work, and we are still very much working through this process, in particular with our counties that we can call our offline counties, the ones that use third-party voter registration systems. That process with those counties is very much still underway we've had a lot of recent changes related to redistricting that many of these counties are still trying to get in our state system and get that accurate. The timing of the rollout of this system was very well thought out. Our intention was to do it prior to a high turnout election and to do it prior to an election in which the counties had a lot more control and a lot more organizational kind of impact on how that election was run. And so we rolled out the system last July prior to our November constitutional amendment election. 2 weeks into our rollout, we had a situation occur that we did not anticipate, and that is that one of our third-party vendors that was utilized here in Texas, a company by the name of Votech, closed their doors. And we suddenly had 24 counties that no longer had vendor support for their third-party voter registration system. Of those 24 counties, we had 11 counties that ended up completely losing access to their data. They weren't able to process registrations, they weren't able to retrieve their data from the cloud-based service, and they could not go forward with the voter registration process because all of their data was housed in a system that they no longer had access to. This is something that had a significant impact on the redevelopment project and the rollout of the team system, because we had to, in order to ensure that our state had a November constitutional amendment election, we had to completely pause redevelopment of the team system. We had to pause the phased rollout approach that we had in place and shift gears to helping these 11 counties that no longer had a functioning registration system. Typically, when a third party, or when a county transitions from a third-party vendor into the state system, that takes anywhere from 2 to 4 months to make that happen because there's a lot of data validations and a lot of data conversion that goes into that. We were posed with having to onboard 11 counties in a 6 to 8 week period. Again, something that takes 2 to 4 months per county. We had to do all 11 at the same time, the largest of which is Bexar County, a pretty substantial county. We were able to work with our vendor to bring in some extra data teams, but again, we had to pause all redevelopment efforts in order to make this happen because we had some tough choices we had to make during that time. And we chose to make sure that our state could have a constitutional amendment election, that our local jurisdictions that were going to be impacted by their elections because of the county not having access to the voter registration system, we chose to move forward to help those counties to ensure that our local cities and schools could continue to have their elections in November as well. And that is something that put us very behind in the development project for the team system, without a doubt, because we had to make this tough decision to help onboard these counties. But we did that successfully. I will say it was at no small cost. There was definitely a cost to the state. It did cost the state about $600,000, between $600,000 and $700,000 to onboard these counties. This is not a cost that was passed off to our counties. We've never charged counties for onboarding into the state system, but we did have to, make some great efforts to make that happen in the time frame that was provided. But the bigger cost there was the cost that to our counties that utilize the team system exclusively. We have 24 counties that were utilizing these third-party vendors, or about 30 counties at the time utilizing those third-party vendors, and so everybody else was utilizing the state system. And in pausing our redevelopment of that system, it put all of those counties behind. Our online counties suffered because of the work that we had to do to bring these counties into the team system. But again, it was a tough decision that we had to make, but it was the right decision to make sure that our entire state could have the election that we were required to have in November. Shortly after the November election, we also had another situation arise in which we had to divert attention away from the team rollout into to another component of the election process, and that was redistricting. As we are all aware, that our state underwent some redistricting efforts last year, and all of that data had to be converted and put into the team system. That was another large project that was not anticipated in the rollout of our new system, and so that further delayed some of the development of the system. So for the last few months, because we have gone from this situation with the VOTEC counties to redistricting, and then to a series of 7 elections that we've had since the rollout started, we have not had the time to be able to address some of the issues in our system that we would like to address, and we have not been able to roll out additional functionality and modules that our counties very much want and need. But we have had 7 successful elections with the team system now. We do have a plan in place this summer to address remaining issues. Now that we are finally through this kind of tough election season where we had so many elections back to back, we now have the ability to clear out all of the remaining kind of smaller issues and smaller tickets that I think have been driving our counties crazy because it impacts the efficiency in their day-to-day responsibilities, but we're not core critical functionality of the system, things that will improve their workflow and things that will make their lives easier. But at the time, were not core issues that we had to address. So our plan is to work through that backlog of tickets. We also, in working with our vendor in the background, while we were supporting the ongoing elections, have identified several areas where we can make improvements in the system that'll improve efficiency, improve the report generation, and ensure that our system is functioning the way it needs to with the speed that it needs to. Some of these are architectural changes within the system that we're going to roll out. Again, we could not roll these out during ongoing elections, and so we have a plan this summer to phase in some of these bigger architectural changes in the system, and from what I've seen, vastly improve some of the efficiencies that we need in the processing of data that comes into our system. In addition to that, we do have some new features that we'll be rolling out in our system. We are going to be providing a service for our counties, for our military and overseas voters. We will be incorporating into our system an electronic delivery system for them. This delivers their balloting materials to military and overseas voters. Many of our military and overseas voters that are in combat zones or hostile fire pay zones don't have access to the mail, and so it's hard for them to get a ballot mailed to them, but this will find a way to securely, electronically provide that to them. Now, that individual will still have to download that ballot and mail it back in, but we are rolling out that feature to our counties so that to try to absorb some costs that they have and make sure that our voters are getting that ballot in a very safe and secure way. In addition to that, we're incorporating intelligent mail barcoding so that voters and counties can now not just track the ballot where it is with the county, but they can track a ballot for voting by mail where it is with the USPS. We have other things that we're working on long-term. We'll be rolling GIS into our system. Those are projects that are going to be coming out later this year after we complete the hardening of our system and address the functionality issues that we need to address to make sure that our counties have a system that improves their efficiency and is safe and secure and overall supporting the mission of Texas elections. In addition to the team system, there's a few other things that I wanted to address with respect to the security side. We oftentimes get questions about poll watchers in our election process. I think poll watchers, they are observers to the election process, and they're an important part of this election process. They're appointed by candidates, political parties, sometimes specific purpose political action committees, and they're done with the purpose of maintaining security in our election process. As observers, they're there to ensure that the process is completed the way it is required to be completed under the law. They're a necessary check on the system. All poll watchers in Texas must complete the SOS prescribed training. This is a requirement that came out of Senate Bill 1 from 2021. This prescribed training that poll watchers have to complete gives them a certificate. They then have to present proof of training when they show up to do poll watching. I will say, since the legislature implemented this training requirement for poll watchers, the number of complaints that we've had regarding poll watcher behavior and the number of complaints from poll watchers regarding their access to the election process have decreased significantly. And I think this is an example of where providing requirements for training and education, both for the poll watchers and our county election officials, have made an impact in creating a better environment for our poll watchers in our counties to work together. I think one way to show that this is working is I've heard anecdotally from a lot of counties that they will have poll watchers come into the process that are new to the election process. And the more they learn about elections, the more they want to participate. And it's not uncommon to see poll watchers sometimes get converted to poll workers in future elections. And so that's been a great tool for educating members of the public on the election process that can help address potential shortages that we have in workers long term. In addition to that, and I'll be brief on these other remaining items that I have, there is another bill that has come through Senate State Affairs that's important to note, and that's Senate Bill 827. It was Senator Parker's bill related to the post-election hand count audit. This is a process by which we verify the accuracy of our voting system equipment to make sure that the electronic count matches a subsequent hand count that's done in selected locations. The changes that Senator Parker helped create with this bill provided for more efficiency in the counting process and a more accurate comparison tool so that we are counting things by location and we can see the counts for a specific location from equipment used at that location to compare it to that hand count. The changes that Senator Parker brought out with this bill also greatly expanded the hand counting process to include more hand counting and to give our office the ability to prescribe procedures so that counties can add to it on their own as well to make sure they're incorporating local needs and local concerns. And that has been very successful in the implementation in that we are seeing a lot of ballots being counted, a lot more verification taking place behind the scenes after the election process, and that's an important tool. That auditing tool is important in ensuring that our elections are accurate. We have had some feedback from counties, and I'm sure Ms. Stoynoff, who's sitting here next to me, will speak to you about some of the feedback the counties have received or the counties have provided to her. In some counties, it has resulted in substantially more counting, and so I think there are some concerns in some locations about maybe ways we can review some of the requirements there and see if there's ways that we can address some of those concerns in some of our smaller jurisdictions that in some cases have ended up having to count almost all of their ballots in a given election. In addition to that, the legislation spoke specifically to county-run elections and elections in which we had a statewide measure on the ballot. Our local elections, those provisions weren't modified. They still have this post-election hand count requirement, but it's much more robust, and it may be to our advantage to look at the policy implications of aligning the county requirements to for our local jurisdictions to make sure that it's a similar process that the local folks are having to go through when they run elections on their own. And then finally, I think it's important to address when we're talking about security. You know, we've talked a little bit about the list maintenance process and security before the election. We've talked a little bit about poll watchers, the security they provide during the election process. And now we've talked about what happens after the election, thinking about our post-election hand count audit. But it's important to note that there is kind of a greater picture there. As part of Senate Bill 1 in 2021, the Secretary of State's office was provided the ability to audit county election offices and voter registration offices. It's a randomly selected audit. We select 4 counties every 2 years for the audit process. And to date now, our office has completed 12 different county audits. I think every round of audits, we've been able to improve upon the work that we have done in the previous audit, and we have a pretty good understanding of some of the reoccurring issues that we're seeing across the state. I will say that in 2023, there was another piece of legislation, Senator Betancourt's Senate Bill 1933, that created a process to address potential issues and reoccurring patterns of problems that we see within the election process. And Senator Betancourt's 1933, one of the things that it did is it provided our office the ability to place one of our audited counties, if we deem necessary, under what we call administrative oversight. Administrative oversight, I want to be clear, is not a state takeover of the Elections or Voter Registration Office. All of that authority remains with the local entity. It is the voter registrar's responsibility to register voters. It's the county election officer, county clerk in some situations, their responsibility to maintain and run elections. So placing a county under oversight does not put the Secretary of State's office over elections. We're not performing their duties. We're not taking on those responsibilities. But what we are doing is providing monitoring, additional training, and helping to remediate issues. For the first time, we have placed one of our audited counties under administrative oversight, and that county is Valverde County. Valverde County, some of the issues that we identified in our preliminary findings and audit report that was issued in July of last year, are specific to the voter registration side of the house. It is a county in which those duties are split between two offices. The tax assessor collector takes on voter registration, county clerk takes on election responsibilities. Prior to even auditing Val Verde County, we have known that there are some issues in Val Verde that we have attempted to help the county address with respect to voter registration. Going back to 2023, before this county was even selected, we had gone on site to that county to help them deal with jurisdictional boundary lines, some issues that they had where they were not maintaining those in the system, and to talk to them about workflow and process, because we were seeing that registrations were not being processed in a timely fashion, specifically those related to elections, updates through the statement of residence process, provisional voting process, and that we were seeing cancellations that were not happening at the appropriate time in the election process. And so we've done work twice on the ground with Val Verde leading up to this, and then the audit process showed us that some of those issues were continuing on in the county. What I will say to Val Verde County's credit is that they have been very receptive to the feedback that we've provided. Oftentimes, when we see county election offices or county voter registration offices that are struggling with some of the requirements that are imposed on them by Texas law, it can be because of needs for additional training. It could be because the county needs to provide more funding to an office. There are a lot of different things that contribute to that. But I will say, with this spotlight that we've shown, we've been able to shine rather on the Val Verde County voter registration process, the county has very willingly worked with us to try to resolve these issues. In fact, they've worked on creating a new policy manual for the office that our team is reviewing for them. And so we see this as the ability to help remediate these issues and get the county up to speed with where they need to be, because that's in the best interest of the voters within that community. And so we appreciate their willingness to work with us, that they have been receptive to this administrative oversight process. And I think it gives them the ability to make the necessary changes that they need to make in order to be compliant with Texas law, that sometimes it's hard to do. It's hard to do that locally. And this has given us the ability to give them that assistance that they need. And so election security and making sure that we have our secure elections, I think it's important to note. It starts before the election, it happens during the election process, and of course, with all of the tools that the legislature has given us on auditing our elections, in reviewing election data, that's how we ensure that the security process is maintained throughout the election and voter registration process, so that we can build on that and identify new and improved best practices and procedures to help us have strong elections in Texas.
Thank you, Ms. Atkins. We'll have questions for you after we hear from the rest of the panel. Thank you for your testimony. Mr. Dornoff, welcome. Introduce yourself and go ahead.
Thank you, Chairman Hughes and members of the committee. I'm Jennifer Doynoff. I'm the Hays County Election Administrator and also the Legislative Chair for Texas Association of County Election Officials, and I really appreciate the opportunity to be an invited guest today to talk to you about maintaining election security in Texas. The legislature has taken major steps in 2021 to improve election security over voter confidence in Texas election. Our state leads the way in safe and fair elections, something we're all very proud of. In Texas, county election officials believe it's important to highlight major changes in Texas law from the past few sessions. As Christina has said, this body and the legislature have passed a lot of really good laws that have secured our elections, and we just want to highlight a few of those. You've already heard Senate Bill 1 is one of the laws that we believe helps strengthen Texas elections. It requires ID requirements for mail ballots. It standardized early voting and gave authority and more clarity, better defined poll watcher access in the polling location, and then also established the use of reconciliation forms, which is very important to the process, transparency. These forms are put on every county's website, and it's a comparison of voters that have checked in with votes that have been tallied in the polling location. And I believe a lot of counties are actually using this in their canvass process with their commissioners' court to also give some comfort to the commissioners when they're canvassing an election. In 2025, the legislature made several important reforms to pre- and post-election audits, and we appreciate that. That would be Senate Bill 2166 and Senate Bill 827, which you heard a little bit about. 2166 helped define clarity in the logic and accuracy testing that we do before an election, which is our pre-election audit process. It helped define the representative sample, which was always kind of a term people threw out there, but nobody really knew what it meant. It also requires now that poll books be tested as well. And I think that gives some comfort to the voters in our areas as well. And then Senate Bill 827, improve the post-election hand count audit, which we effectively refer to now as the PECA or PCA, depends on what county you're in. And it did that in all the ways that Ms. Atkins talked about, but also one thing I didn't hear was that the early voting ballot board now conducts that count. And I think it really helps with transparency and also having other people come in to see and oversee that process. And then it also allowed counting by location, which you heard, and then also allows local authorities to expand that should they need to look further into any races. And then last session, 2217, built on Senate Bill 1 by ensuring that 30 days after an election, the county must do another reconciliation process by location that looks at voters that checked into the location, voters that voted at the location, and then makes comments on any discrepancies. And that is also on the website of every county. From TASIO, Texas Association of County Election Officials perspective, one of the most important bills passed in recent years was Senate Bill 1540 by Senator Betancourt. This is the bill that protects personal information of election officials and their employees by helping ensure it remains confidential. As was testified in the 89th session, there are numerous election officials, poll workers, and volunteers who have been threatened for their work in elections, and that's something that should never happen. During the most recent primary, some administrators were forced to stay in hotels with sheriff deputy staff nearby due to threats that they received. So there are some things that we would like to and have met with Senator Betancourt's office to maybe expand this a little bit further. County election officials look forward to continued partnership with the legislature and Secretary of State to improve election security. As the committee starts thinking about the next session, county election officials have identified a few areas in the election code that may need further legislative consideration. Ballot privacy still remains to be an issue that we would like to talk about. Election officials have concerns for voters across Texas. Several bills were introduced that address ballot privacy issues in the last session, but no law passed. Currently, the main tool counties have to protect is redaction. With redaction is better, but it is not foolproof due to human error and the sheer workload of redacting potentially thousands of data points. And then if you have somebody requesting from different offices and the same redactions aren't made, that further complicates the process. This is ballot privacy issues remain in all elections, regardless of the size or whether you utilize countywide or precinct-based. Some potential solutions discussed in 2024 interim hearings by the Secretary of State and county election officials were aggregated precinct reporting in hyper low turnout elections, increasing the timeline for certain election records to be released, and reviewing information must jointly be published by the Secretary of State and the counties to make sure that we're redacting the same way. Fail-safe voting also remains to be something that we need to address. Under current law, if a voter moves within the county, there are certain processes where voters are not supposed to be voting in those local elections. But to carry out this process is almost impossible for most counties, and also can lead to more ballot privacy issues. So we definitely want to continue to talk about fail-safe voting. And then further clarification, excuse me, on the post-election hand count recount process. Currently, there is no statutory process for a post-election audit of hand-counted elections. Given the growing interest in some counties in hand-counting election results, we believe there should be an audit of hand-counted elections. And part of the reason is because under 2217, we do have to do that reconciliation of votes that were counted and voters that checked in, and we have to describe discrepancies. And currently in a hand-counted election, there's no way to do that. So we do believe that there should be an audit process for hand-counted elections as well. We have some areas that we have spoken with Senator Parker's office on refinement areas for Senate Bill 827. For example, I think you heard this in Christina's testimony. In May elections, the processes are not aligned, and we're counting pretty much the full ballot. And a lot of times, it's a full recount in a May election. And the particular issue with that is, in even years, that timeline runs into a primary timeline. So you're doing that. All of that is overlapping. So we'd like to talk more about that. We'd like to talk more about a more equitable solution for how many ballots counties are counting, because 3 locations in a lot of counties that don't even have 3 locations doesn't equal to the same thing as 3 locations in Harris County, Dallas County, or bigger counties. So we would like to talk a little bit more about how to make a more equitable solution for that. And then now we're going to talk a little bit about team. For over a year now, counties have been working diligently with the Secretary of State to implement the new team system. Texas Association of County Election Officials acknowledges that the Secretary of State has faced significant operational hurdles throughout the implementation process. Counties have navigated challenges with team now spread across at least 4 elections. Some counties have had a lot more than that. And many of these issues have increased administrative burdens on county election officials, affecting other aspects of the election process. The Secretary of State's office and many counties communicate daily about the issues election officials are navigating. And Texas Association of County Election Officials recognizes the substantial role that Civics, the vendor, plays in implementing team and resolving potential issues. Some of the issues that counties have raised are issues with the accuracy of their official report, their official list of registered voters, which is different than all registered voters. That's the list specific that we use for programming for elections, and some inaccuracies there. And then also some significant issues with the ballot by mail module and how that's working. Again, this morning, I did hear that some counties were having issues with newly registered voters that didn't have EDR dates or effective dates of registration. We all know that a well-functioning team is integral in safety and security in Texas elections, and Texas Association of County Election Officials looks forward to our continued partnership with the Secretary of State's office, Civics, and this committee to identify and resolve these challenges. Election security is extremely important for all Texas election officials, and it's something our membership and profession take very seriously. Thank you for your time, and I'm happy to answer questions.
And thanks for your testimony. Mr. Ennis, welcome.
Thank you.
Even though we know you, introduce yourself and give us your testimony.
Thank you, Chairman Hughes. Chad Ennis, Honest Elections Project. Really be happy to be here back in front of this committee after a few years away. So I think Jennifer laid out some great things that you guys have done in the last few sessions to make our elections more secure. I want to talk about 3 things that actually this committee has passed and the Senate has passed, but we haven't been able to get them to the governor. So they're still important things and they're really important to election security and things we need to get over the finish line. Christina talked a little bit about documented proof of citizenship. And in last session, that was SB 16, passed out of this committee, passed by the Senate, didn't quite get it to the governor. But there is still a need for documentary proof of citizenship when someone registers to vote. I'm going to give you a few, draw out and look at nationwide, and then we'll zoom in on Texas. But Ohio has been a very big leader on this. They located 597 voters who are not citizens on their rolls, and 138 of them had actually voted. So 138. In 2024, Virginia discovered over 1,600 non-citizens on their rolls. They had to fight all the way to the Supreme Court to take them off their rolls, but they did, and now their rolls are better. Here in Texas, Secretary of State's office has been working on this issue. They've referred 33 potential non-citizens to the Attorney General and have identified 2,700 potential non-citizens that they've sent down to the counties for investigation. Those are big numbers, and they don't maybe sound initially like big numbers, But the Public Interest Legal Foundation has a database that will tell you tied races or races decided by one vote. Since 2002, in the United States, there have been 1,367 elections that ended in ties, and 527 decided by one vote. Here in Texas, we've had 13 ties, or 11 ties, and 13 or 2 more additional ones for a total of 13. That gets you to which were within one vote. So really having people on the rolls that aren't supposed to be there really matters, and it's important. So getting back to SB 16, SB 16 has gotten some criticism for being done in a certain way, but I want to tell you why the bill is set up in the way it is, because I think it's important to understand. Christina mentioned some problems with how the NVRA kind of ties our hands, the state of Texas anyway, as we look at these issues. And this is a place where the NVRA really ties your hands and like throws you in the water weighted down by concrete blocks. The NVRA created the federal form for voter registration. Federal form, it's one form that's supposed to work all across the country, one form to rule them all. And the problem is, you know, some states want to do more, some states want to do less on registering to vote. The NVRA does not require any proof of, or the federal form for voter registration does not require any proof of citizenship when you use it. You just check a box, and then you say, I'm a citizen, and then you get registered. And, well, you say, why can't we stop it right there? Well, there's a Supreme Court case that says, no, you can't stop it right there. You have to accept and use the form. Accept and use means that we're going to have to register that person to vote. And then if the Secretary of State determines that this is a non-citizen that inadvertently registered to vote, they're going to have to go through the process to take that person off, which is a much longer process than simply not allowing them to ever register. So, but that's only a problem for federal elections. The federal government can tell you guys what to do for federal elections, but they can't tell y'all what to do for state elections. So that creates an opportunity as well, at least to fix some of the problem. So you can run a state system of voter registration, which we do, and require documentary proof of citizenship. We already do this for most folks that register. I think close to 85% who register at the DMV. They're going to prove their citizenship right there. That's not the only way, though. We have databases that can be checked. The Trump administration has made it much easier to check, to prove citizenship at the state level through the use of the SAVE database and other databases. So it's a different even world than you guys were faced with in the last session, the last main session. So then you're left with these folks that register with the federal form but don't provide any proof of citizenship. In that case, you can, again, check the databases. Maybe we can prove citizenship by just checking the Social Security number, the driver's license number, these kinds of things. That's hopefully the plan. If you can't prove citizenship that way, you go to the voter, the last source of information as a last resort, and say, hey, please provide us some documentation that you're a citizen. And it works pretty easily. Arizona has this system. Utah has just started to go down this path as well. So it's a tried and true method. And then moving on, if we can't confirm citizenship or non-citizenship of that voter who used the federal form, we say, okay, feds, you can only tell us what to do in federal elections, so you will become a federal-only voter. And when we were developing this bill, I think with input from Jennifer and input from Christina, I think we thought of a great way to do that here in Texas would just be to create a precinct for a federal-only voter. The people who are only federal-only will be in a special precinct for their congressional district, and they'll be allowed to vote for Senate and Congress and nothing more. But the bill also builds in significant protections, and I think this is where Texas was really smart, by having a voter who comes in on election day and is on the federal-only list. They'll vote provisionally. They can vote the entire ballot. They'll vote it provisionally. then they have the provisional time to come back and prove their citizenship, giving them the chance to get that full ballot and hopefully get the information that the state needs into the voter rolls, and we get some cleaning of the voter rolls that way as well. So other states are taking different ways, but I think really the Virginia or the Arizona method, which this is based on, is the best way. There's currently a cert petition. They've had parts of it enjoined, but there's a cert petition going up to the Supreme Court. So I think it would make a lot of sense for Texas to go ahead and get this in place. So when the Supreme Court rules on it, they're ready to go. Well, that's the first thing that we didn't quite get over the finish line last session. I've got two more smaller ones, but not any less important. And you guys heard, this committee heard Senate Bill 2035 last session. This is the ban on foreign funding into ballot measures. It is illegal at the federal level to give foreign money to candidates, and you guys can't take money from foreign candidate or from foreign nationals for many different things. But there's a loophole for ballot issues. Federal law applies to elections, and ballot issues measures where you don't have people involved are not considered elections and therefore not subject to a federal ban. And this is a real problem. There's a Swiss billionaire, Hansborg Weiss, who spent $130 million gave $130 million to the Arabella Networks. Arabella Networks has changed their name, but they're a big left-wing advocacy group, and they've given, I said that backwards. Hansborg Weiss, I understated it, which I shouldn't do. Hansborg Weiss has given $280 million to Arabella, $280 million, and Arabella has turned around and given $133 million or so, $130 million to ballot issue campaigns in 26 states, including $100,000 in Texas to an Austin local measure. In 2024, Ohio was the first state to pass this. Since then, 11 states have passed a ban. And I think you'll see, and what worries me for Texas is that as that money is pushed down out of those states, the more money will come to Texas, and we will have a problem. So 2035 is a pretty simple model. Basically, you prohibit directly giving to a ballot campaign by a foreign national, and you also prohibit indirect giving, that giving where I give to one group and the group gives to the ballot measure. Also, same thing, direct and indirect contributions to independent expenditures. With those, we don't want either from foreign nationals. And then also some donor disclosures, or donor disclosure protections. So when these cases do get litigated, all the donors to a certain ballot campaign lose their privacy. Finally, an issue near and dear to my heart is, as many of you know, I for Secretary of Scott, started the audit division at the Texas Secretary of State and performed the first couple of the audits that, the first handful of audits that Ms. Atkins described. And last session, you all passed 1863, Senate Bill 1863, which strengthened the audit process. And I think that's another good issue to get election security more at the forefront. It required more audits. Right now, it's required to do 4 audits every 2 years in 2 big counties and 2 small counties. Well, if you're a small county, that's pretty good odds. That's pretty good odds you're not going to get audited. So it expands the number of audits. It clarifies, which wasn't clear in the statute, that even that if you're auditing a county, even that school board election run by the school board should be audited as well. I think the Secretary of State's doing that, but I think it needs to be clarified in the statute that those need to be covered. The statute is also, as it exists, not very specific on what should be audited. So I think y'all can put some real good teeth into that and say audit the voter registration list, audit the procedures for testing voting equipment, chain of custody documents, and provisional ballots and mail ballots. It requires cooperation by the audited parties. Some of you might remember when I audited Harris County, we had a bit of sometimes not wanting to provide documents or help And really all that I could do to get compliance was try to be really nice. There needs to be some teeth in there, so when someone's being audited, then the Secretary of State says, I want to see this document, that they get it in a quickly and timely fashion. There's some stuff that gives in that bill that allows the counties time to review the audit findings and respond ahead of time. I think that's a good thing. And it requires a public report. But those are three things that you guys have passed in the past, sometimes multiple times. They're still important, and I hope going into the next session, those are places y'all look to legislate as well. Thanks.
Thanks, Mr. Ennis. Thanks for your testimony. We'll have questions for you after the panel. Mr. Johnson, welcome back. Introduce yourself. Give us your testimony.
Ed Johnson. I'm with the Harris County Ballot Security. And I'm going to get my iPad back up here. Y'all have heard a lot of my testimony already, so I'm just going to kind of play a history and best practices coach here from what I've seen in the past. To start with, one of the issues in this thing was the poll watchers. Still have problems with poll watchers, and actually it's on both sides of the aisle. I personally think that we need to look at the authority given to an election judge. For one day, they get to be the same authority as a district judge, which is a lot of authority, and that tends to lead to lots of confrontations. That's one I think you should look at. The other bigger overarching for ballot election integrity, ballot security, all that other, is the enforcement of election laws. We have, you just heard, we have a lot of great election laws that y'all have passed. We have, plugged just about every hole you can think of. Problem is, it never gets enforced. And that is a big problem. Senator Betancourt had a bill last session, my glasses on here.
Senate Bill 2020.
It was 2020? Okay, thank you. It was, all right, so it was a Marshall's bill, and it would create a statewide expedition to get things to a court fast, to get, some authority into a polling location that was trained to, supervise the situation so they don't get out of hand and don't blow up. That would be a huge tool to have better elections and for, better integrity to actually force these laws. One that was mentioned earlier was your Senate, was it Senate Bill 16, separation of elections. We lost the national, FPCAs, federal postcard applications, actually is a huge problem, or getting to be a bigger problem. This is when you're overseas, how you apply to vote. There is zero validation that you are who you say you are or where you are. So we have people overseas mailing us applications that you, even if you know they weren't a citizen or know they don't live here, you're still forced by federal law to send them a ballot. If we separated that into a state and federal, you could send them just the federal ballot and not the state. You could have tougher requirements there for the state. Harris County last election lost a statewide court due to the FPCA slipping it. Republican won, FPCAs, because you have 5 days for them to come in, changed that race. So it is an issue, and it is actually becoming more of an issue every time. That's one I would hope we could look into. The Secretary of State over here is doing a great job, trying to clean the voter roll and doing this. The mechanism, the actual, physical force of this is the counties. They're the ones that she said, Christina said she sends a report to these counties and they're supposed to act on it. Well, if they don't do it, it doesn't get fixed. And she really doesn't have that much of a tool or a strong tool to do it. And we need to set guidelines. She can withhold Chapter 19 funds, which are funds that are provided for election support help for workers. But I think y'all should look at specific guidelines of events that happen that she shall do this and not make it into their discretion of what is an infraction and what isn't. We need to define that better. And on the Chapter 19 funds, this was something that was created in the 1950s as a funding mechanism for helping during election times register. It has never increased since the 1950s when it was created. If the state wants to have some authority and be able to have the big stick to do it, we should look at the funding of Chapter 19, because you could withhold that from a county and that would get their attention. Right now, it's getting so low, some counties really don't even care if they get it or not anymore. So that's another one we should look at. Is it worth helping ensure we have good election workers in there? On her team problem, you got to remember, Chapter 19 is paying for these employees at minimum wage. The people you have entering your data and typing those cards are minimum wage people that couldn't get a job at Burger King. This is the problem. You will see. I have a letter I'll pass out here in a second. Lee County, where I spend a lot of my time at my ranch, they had problems sending their data in, voter history data in, and getting it to upload, and it was told because it had too many spaces in the characters and things like that. When you have this low quality temporary working staff entering this, you end up with data problems, and that just spreads the problem on down the line. So it's something that I would really hope you all could look at, of trying to increase the quality of workers, and also give the Secretary of State authority to enforce these things. We were talking about the hand recounts, where we're hand counting the paper in some counties. I can give you an example. Briscoe Kane had a primary runoff race, and it was in the teens vote different, 10, 15 votes different between, of course, his opponent. Briscoe was winning. His opponent wanted a recount. He wanted a recount by paper. And at that time, Harris County was on a direct electronic machine, so what you did is you exported a print file out of the machine, and then you printed that paper. Well, on a text file, you can do a word search. And before we handed, and these are two teams that we knew of people recounting a couple of thousand votes, we did a word search for each name, and we knew exactly how many votes, how many net times that name was appearing on these pieces of paper. It took them 5 times to recount it to get the correct answer. They were off by as many as 10 votes sometimes when they were doing this. So hand count recounts really need to be audited, because it is very easy to make little bitty errors, especially when you do a lot of that. So I think that would be a great thing to do. Jumping down to the team system, if I could give this to the clerk, you could pass them around. This is from the local county judge in Lee County, where I was kind of helping with some races. Had extreme problems, this is on the political side, of getting voter history out of the team system. I would look at it, and I was helping with some Lee County races, and they would have 150 voters one day, and you go to the website, and the website would show 5 voters. I was told that it was a problem with, the data not being in the correct format, too many spaces and things like that. I think we really need to ask the team vendors to try to scrub this stuff before they import it. Ones that when I was working for the best tax collector assessor ever in Harris County, over there, we went through a data conversion from a mainframe to a network PC system, and it took 2 years. We ran in parallel a lot of times. Another good practice is you should roll out changes to a small county first on a small election, test it, make sure it works before you let them roll it out statewide. It solves a lot of frustration. And I've heard from a lot of these counties, there is tremendous frustration out there of not being able to get, data entered. I'm looking at voter history online that's not correct. You had all the counties actually had to create sites on their website to post their voter history so they would be compliant with state law. The ballot by mail tracking process had problems. You couldn't, you would get different answers every time when you would go to the Secretary of State site a lot on the ballot tracking by mail, which caused counties to actually put that onto their own websites too. So that's frustration for that county and cost to them. But the really big one is really frustrating to voters. And it really lackens their confidence. So I would almost encourage the Secretary of State in the next bidding process, or when they do this, is to have some kind of parallel testing built into the bid, and a eased rollout so you can make sure you catch problems before they happen. And you're going to always have problems. Being there, I've seen and done it. The other one that I would say that you would never do is make any changes to your election software 90 days before an election. The world's greatest tax collector assessor made that a law in the office of we are not changing anything before this election, because that has a trickle-down effect to the local counties too, because it messes up their software. It could affect their software and cause them problems also. So these are some good practices that hopefully maybe Secretary of State or y'all could look at to try to get implemented in here. So I think that's for topic A, about everything I had.
Thanks, Mr. Johnson. Senator Hall, you're recognized.
Thank you, Mr. Chairman. And first I want to thank Jennifer and Christina for working with me and my office with the attitude of how can we make this better rather than trying to defend the status quo, which is I get from so many people, well, we don't want to change anything. I really appreciate that. The question I had is, we've got another panel coming up. Do each of you have a separate statement for this next panel from this one? Okay, because my question is I'm kind of having a hard time distinguishing between one versus the other here.
It won't hurt to cover what you want to now, but we'll always have a crack at it on the next panel. If you let this one pass, it's not the last train out of town. So
okay.
Whatever you prefer, it's really either way.
Actually, there's like 6 trains on the next one that will go out of town with you, Bob. So.
Oh, okay. So I do have a few questions here that this is timely to do. One, I just want to go back to what you were talking about, the issues that we have with our voting rolls, and as we move forward, and how do we make sure that we don't have this third party problem anymore in the future, and how do we have a system where there's more than one set or one organization that's really looking at the voter roll to validate that the voter roll is accurate? And I ask that question because I've had numerous people from various counties come to me, and their story is all the same. We got a copy of our voter roll for the county, and look what we found. And they have 20 people, 30 people living at the same address. They have people with an address in a convenience store or a mailbox kind of place. Or I found my grandmother, my aunt, and one of my cousins, all who died 6, 7, 8 years ago, still on the voter rolls. That kind of thing that they were bringing in overall. It's like nobody was looking at it in there. How do we go forward so that we make sure we have a high degree of confidence, and that includes the concerns of people. I know you're going through some pains with teams and other things like that, and that's fine. Just so as long as our vision is out there when we get there, we have this confidence that the voting. If you got somebody got it, and they did an audit of it, they would find Fred and Nancy living at 17 Maple Street, and that was it, and that's where they lived, and nobody living in the FedEx mailbox down here. So,
Yes, sir. Senator, that's a very big question. So I think to start with, I think we have to acknowledge that the model that we have in Texas right now is we have this requirement for a statewide voter registration database, an election, and full-on election management system. It's much bigger than just voter registration. And for many years, we have allowed counties to use their own third-party vendors. And I will tell you, initially, when we first rolled out the statewide voter registration system back in the early 2000s, that was absolutely necessary because of capacity issues, because of technology issues. And so initially, that was an important piece that we allowed for that, and that we provide ways to validate that data and ensure that we have the correct and accurate transfer of data between county and state. Over the years, the number of counties that utilize these third-party vendors it's gone down, and that's because the state system has improved over the years. We know more now. Technology's improved. We have, been able to handle capacity issues as as the technology has, improved over the years. The difficulty in that scenario, and this has been the case the entire time, the difficulty in having third-party vendors where counties maintain voter registration locally is that you will almost never have perfect alignment between the two systems. Things change all the time. And it's, unless you have a county that's doing everything in parallel, doing everything in their third-party system and doing it in the state system at the same time, there's always going to be data discrepancies there. That's just an inevitability of the systems. And we have worked very hard with our counties over the years. Some of our counties have done a great job in trying to address the discrepancies between their local system and the state system. I think that issue right now is getting a lot of attention because of the recent redistricting efforts, because our counties that have third-party systems went and did redistricting in their local system, and now they have to align it with the state system. And that's been a challenge. And I think, folks are under the impression that if it's accurate in my local system, that's all that matters. And I will say, for voting purposes, to ensure that voters are getting the right ballot and we have accurate elections and accurate results, that's correct. Locally, if the data is right locally, and that's what we're building our election off of, then we know that we're having accurate elections. But from a data standpoint, and making sure that what is consistent across the state and what matches in the state system, which is where all of our big entities come to with data requests, the RNC, the DNC, all of the big data consultants come and get the data from the state. If that data is not right in the state system, then we're going to have a problem because it's not an accurate representation of what transpired in that particular county. And so that data alignment issue is a problem. And that's something we are working very, very hard with our counties, our offline counties with right now. We still have leftover issues from redistricting that we are still trying to get that data right in our system. We're very, very confident by the end of the summer, working individually with these different counties, that data alignment will be where it needs to be. But it is very labor intensive, this work. And it's something that if we're going to continue this model where we have these third-party vendors, where counties have that ability to run things locally and then they're required to match it with the state system, if that's the model that we're going to continue with in Texas, we can support that. But I think I definitely need more technical folks in our office to help with that data alignment and to help with maintaining those systems. Because there are days where we spend 60 or 70% of our time at the state working just with those offline counties. That means that's work we're not spending with our counties that just exclusively utilize the team system. And so it's doable, but it's quite a bit of work. And, it can be done. It takes quite a bit of effort.
Well, as we go forward here, as you're looking at those things that are coming up here, if there's a path we need to take that's different than what we're taking to do something of whatever it is, come talk. Let's talk about it, because we need to get this right. It's something that's so fundamental to the voting process that we need to have the voter list that we have.
Yes, sir.
Blind, not blind, but knowledgeable belief that it is truly accurate in there. So we would. Yes,
Senator, can make a comment here. One of the other big things that has changed, where you were talking about, voters that see multiple people registered at a house. In the Texas Election Code, it says if you have personal knowledge of, someone that doesn't live there, someone that's not alive, could be deceased, you could challenge them. The legal and some legal interpretations now is that the only people that have personal knowledge are relatives. So in Harris County, we have put out great efforts to go and try to identify these people that don't live in there anymore, 100,000 records, and we submit them to the voter registrar, and they tell us, you don't have personal knowledge. You can't do this. So we really need y'all to redefine or come up with a definition of what is personal knowledge, so that you can actually go in and pursue, if someone doesn't live there, you could pursue challenging them and put them on suspense, that you could, get them registered in the correct location.
Okay, that's what we need to do. Anybody else on that? If not,
I was going to say the same thing, that there's processes in place. So if you do identify that somebody is not at a eligible address, or there's the challenge process, which I know a lot of counties have been doing. Also, we do have local citizens that check and scrub our voter rolls for both parties. So that's also a good way to handle it from that aspect too.
Okay. With all of what we saw in this last year in particular, with election after election after election going on, overlapping, following up, and so on, why would we not consider seriously going to a single voting period each year? If you got something up, whatever it is, whether it's city, county, bonds, school boards, state, or whatever it is, it's all done at the same time. That one time from whatever it is, the May to November, whatever the dates are, a single voting period, get it in there. We saw very poor turnout at a lot of elections. I really believe because we had so many going and people were confused, they didn't know who was voting when and when early voting was on election day for them, some of them overlapping even. What are your thoughts on going to? And I'd like to hear from each of you.
Well, I can start. First of all, going back a bit to something Jennifer hit on, I think one thing this body could do that would be very helpful is open up the number of data sources that can be used for list maintenance, and really say, look, we've got commercial data, we've got state data, we've got federal data. Allow the counties and the Secretary of State to utilize that data for list maintenance. Now, they still have to go through strong matches, as Christina said earlier. You can't just throw people off. But at least you begin to get indications of when people moved or moved or died or all of these things, and you can get the rolls clean because the data is out there. We just need to tap into it. With your second point about election days, how we have too many elections, I totally agree. And the next page in my outline is that exact thing to talk about in the next section. But I can certainly give you a preview, because you're absolutely right. We have too many elections, and it causes several problems. The low turnout problem you mentioned earlier. Also, you put tremendous stress on these individuals over here on my left by having to continually run elections when you consider 2 weeks of early voting, long time for mail-in ballots. It stresses the system, and the more times you do elections, the more chances there's going to be for you to make a mistake. So you guys passed a bill last session that actually did that, got everything down to November, plus primaries and specials as needed. But that is a wonderful way to do a lot of good things.
Okay.
I'll be happy to go next. On your question about the continuing voting period, one of the big
it isn't continuing. It's just a single voting period each year.
Yeah.
No matter what it is, it's on board for that.
Correct. So we're talking about everybody in November, correct? This is what you're talking about, having one voting period.
Right.
And that actually, statistically, it shows it increases the turnout from a 3% turnout to about a 30% turnout, 30 to 40% turnout in the small entity elections. And if we need to work on the, I guess, rental structure of how you pay for this, because a lot of small entities, small little cities, and like in large counties, small little cities like Harrison and places, I live in the little city of Bunker Hill, And if we were to join Harris County's elections, well, now we're paying for a percentage of the whole county's election, and it's only one, the city's only one precinct in size. It's only 3,000 voters. So really need to look at how counties can charge entities for going in joint with an election, because right now, for some of the really small districts, it's more, it costs them more money than it does save them money, because now they're paying a percentage of this larger, this huge election, instead of just their one little precinct. So that's something that y'all could maybe look at.
Okay, and what you just said there is what I'm asking for, is when we talk about doing something to improve the system, and we have something in place over here that somebody, well, this is going to keep us from doing it because we have to do this, we need to know what that is, because a lot of this stuff got put in place that nobody had any idea why. Somebody just dreamed it up and threw it on. I mean, our election systems and folks long before we got here that worshiped the word convenience and didn't even know how to spell the word security got us into the mess we're in. And we got to make sure that we are not, and efficiency is just a first cousin to convenience. We want to be efficient, but we don't want to give up security for it. But those things like that, if you would come talk to us about, okay, we want to do this, then we got to fix this, this, and this behind it.
When Senator Betancourt was tax collector assessor, we had 4 actual voting periods across the state. And there were some voters that were having to go to over 6 to 7 different polling locations on election day to vote in all the different districts that they were in, MUD, cities, schools. You go down the list, because they were all holding separate elections, which was extremely frustrating to voters. So your idea is best for voters, to help them. We need to work on the financial part of it to make it to where the entities can afford it.
Okay, but remember, one of the things I get from the counties, with all these elections, it costs us a whole bunch of money because we got to do this over and over and over again, sometimes 3 or 4 times. This is one. It's just a longer ballot. It's what it is.
No, it's actually more efficient and should cost less.
That's what I meant. That's the point. It would be a cost savings and a worker fatigue, which gets me down to the next question, unless somebody else had a comment on that. Yes.
I have one other comment on that. We've had a lot of discussions, I think, in the community right now about this idea of election consolidation. It's coming up. It's come up in other legislative hearings, having fewer election dates. Mr. Johnson talked about maybe thinking about this from a legislative perspective on how we can cap the costs for local election officials so that it's not going to cost them more to do an election in November, for example, if that's what the legislature settles on. But there are kind of 2 other points I'd like to bring up with that. The second is that right now, only our elections administrators have a duty to contract with our local entities in all circumstances. And if there is a push to try to consolidate election dates, that's something else to think about, is perhaps imposing requirements on our county clerks that they are willing to contract with those local folks to ensure that local folks aren't having to run things on their own, apart and away from the county office if they want to contract with the county. And then the other thing that I think folks don't realize that creates a lot of time and energy, or draws a lot of time and energy from our local election officials, are elections for our home rule cities that have vacancies. Under our Texas Constitution, these cities have to have an election within 120 days of the vacancy. Right now, that doesn't even get you to a uniform election date in many circumstances. And then they have a majority vote requirement, so there might be a runoff election. So our cities are having to have an election and then a runoff election. And a good example actually is the city of Houston just had a situation where they were staggering elections with the primary, the May uniform date, the primary runoff. I mean, I think they had 4 elections all right there, and they all were separate from each other. And so there is another thing to consider, is for those local entities, for those cities that have this constitutional requirement. I just want to make the committee aware that there may be a need to talk about
that's exactly what I'm talking about. It's one of those things, there's no good reason for it. It's just the legislature requires it. And if that being the case, that's what we're here for, is to unrequire those things that don't serve a meaningful purpose on their own. It's just the way it was done to make sure it happened, and it was done independent of all the other stuff coming on in there. Anybody else on that? Yes, Jennifer.
I'm going to, just for a minute, be the devil's advocate here. So our association is about 50-50 split on this issue. And the reason is because I think it is longer ballots, but particularly when we're talking about all the cities on one ballot, all the cities doing charter amendment elections. That causes ballots that have a reaction to the voters, voter fatigue. Voters don't want to go down the ballot. That's a lot of reading. We saw it in the last constitutional amendment election. So I think that's where we're coming from. Also, I do want to mention there are models for cost allocation that is more equitable. For if everybody was in November, it would be a more equitable cost. So I think that's a training issue that we can also touch on.
All right.
And share with you.
I'll just say one thing to that. The potential for voter fatigue when you get a long ballot is certainly there. But we're comparing that to, need to not forget, a 5% turnout election in May. It's voter fatigue not even showing up at all.
Right.
So at least if you get them in there in November at a 40, 50, 60% clip, some of them, the people who care, will gut it out and get through that ballot.
Okay, thank you. And the first cousin to that, a lot of discussion I had was, again, worker fatigue, and is the length of our voting period almost 3 weeks long right now. Do we really need that? Could we not accomplish this in a week, 10 days, 12 days, 6 days? What are your thoughts on a shorter overall voting period? Ed?
So actually, we did the math on this when I used to work in the county clerk's office under Stan Stanart. In fact, I had a conversation this weekend over when we were redoing it. Probably you have 1.5 million voters in Harris County, probably 1.6 million this next November election, and to vote them, in a week time, you would probably need at least 100 early voting locations, which they currently have ramped up to now, maybe a little more than that. But shortening it to a week would actually save the county a lot of money, because they're almost running 100 polling locations now, and then you would just, it's the access to the facilities. You're almost need some kind of legislation from y'all mandating schools, large schools, facilities be open for this early voting period, so you can spread them around the county adequately to cover this. But you would need about a week to handle all the early vote. Okay,
and I think that's the point I'm getting at, is a week is adequate. We just need to make a few other changes there to make that possible, because I visit an awful lot of polling locations, and I very seldom ever see a line that's very long at them. And I've been a judge, and I've sat there, cobwebs almost growing between voters showing up in a smaller county.
Well, I mean, and that's what the data shows, Senator Hall. You see, day one of early voting is a huge spike of people, and then it trickles off pretty good. You catch a little on the weekends in that. We've polled this actually at Honest Elections Project a few years ago to look to kind of where the public is. And you can imagine if you say, you've got Virginia, who has 42 days of early voting, which is insane. But you can kind of see the tail, and you ask them how long you kind of satisfy, and you see a bell curve, right? And the bell curve actually falls about where Texas is, which is about 2 weeks. Most people say, and I think you get up to even like 80%, like that 2 weeks, with excuse-based mail balloting, not, no excuse blasting out ballots. It's like we like that kind of system. I think there's room to shorten it, probably a little more to a week or so, and especially if you get those weekends in there and a few things like that people find very convenient. But I think it's something that this body should consider.
Okay. Yeah, I think about if it's a week, whatever day of the week you have off, at least it's covered. But doing something shorter fits with what I think we've been trying to get to in sensible efficiency and working out. One last one here is.
Make one more comment on
Okay.
that. The other big problem with 2 weeks of early voting is worker fatigue. It is very, very difficult to find people that can work for 2 weeks, take off the job for 2 weeks to go run this.
Right.
Usually we have to find split shifts or everything. A week would be a lot more manageable.
Okay. And then along with issues have brought up about Harris County having problems because of its size, other counties, Hayes County, Van Zandt County, different in its size, population, demographics. What would your thoughts be on if we set rules around the election process that took into consideration the size of the county, the population, the demographics, by making some flexible requirements? That is, maybe instead of requiring everybody, no matter where they were, be open 12 hours, we had something that said at least 7 hours, or just along that line, without going through a lot of detail, but rules that would take into recognizing that we want to make sure that across the board in Texas, everyone has equal access to voting, but having different hours would not really affect that, because you got different challenges when you got a Harris County where you got people lined up some places and others where they're not there. But just the idea of, and I'm not trying to pick any specific ones, but just the concept of approaching some of these things that we do that drives inefficiency, that we make it flexible. Comments? Ed?
Okay. I've actually studied this quite a bit. So now living kind of in two different worlds, I spend a lot of time at my ranch in Giddings, Texas, and Lee County, and then, I'm back at home in Houston. But helping with some elections in Lee County, I found out real quickly that you have a large percentage for the county. It's not a huge number of voters. We're talking 12,000 voters or something like that. But you have a large percentage of them that work in Austin. I mean, that's the big city that's around. So they get up in the morning at 6, they go into Austin all day, they don't get home to 7 or 8. And when you have the limited hours of polling locations in these small counties that only open during business hours, well, during the week, they can't make it. They're at work, they're on the road or at work. And then they only have one day on the weekend to do it. And Lee County's not huge, but they only have one early voting location, and it's maybe a 40-minute trip to get down to Giddings from parts of the county to, go vote at that location. So these people, due to their working everything, are disenfranchised, but they're driving into a town in Austin where they're voting all night long. It's I don't think it's fair to the voter. Now, it's not a huge number of voters affected, but I don't think it's fair to these voters that are doing to their work.
What's not fair? I'm not sure.
Well,
point?
if they're working and the polls close at 5,
Okay.
in a small county, well, they don't get to vote during the week.
I'm talking about allowing the counties the flexibility to do what they think they need for theirs.
Yeah, and
we set the standards of a minimum or a maximum that would encompass the large and the small.
The county commissioners like to save money, so they're going to have fewer hours. That's what I've seen as a trend.
Jennifer?
What I think is important to keep in mind with this type of flexibility, which the law already allows currently, is that voters have the right to petition for additional hours, and I would suggest if we had this type of voting that we would continue to give that right to petition for additional hours.
Okay.
I mean, SB 1 addressed a lot of this with hours, and that's when we saw it was in response to Harris County going to 24-hour voting and taking it to the extreme. And I think you have to be really careful when you get too big of a bracket. And there's a bracket now in the law where you get a little wiggle room. that, you know, a nurse that works nights in Tyler needs to have the same opportunity to vote as a nurse that works in Houston. So you really don't want to get too far off that because you just run into, I wouldn't call it a constitutional equal protection problem, but in a conversational equal protection problem.
Okay.
Yeah.
Okay. I've got a couple more, but I think I'll wait till we run to the next panel.
No problem. Thank you, Senator Hall. Before I recognize Senator Betancourt, I'll note that this committee and the Senate last session passed Senate Bill 1209 to move those May elections to November, and I'm glad we had the discussion today because I think there'll be another discussion about that when we get back. Senator Betancourt, you're recognized.
Thank you. In the interest of time, I'm going to try to blast through some of this so we can get to the next panel and then the next call after that too. Ed, you mentioned Senate Bill 220. We're going to file that again because that does have a rocket docket to take election contests and get them immediately resolved because otherwise we're going to see what happens in Harris County, habitually is somebody will keep the polls open and the Supreme Court will then overturn them. And then the question is, what do we do with the 500 votes that were cast during that period of time? And it did affect an election outcome. Harris County is the only county that actually had a successful election overturn from the 2022 election cycle. I think your comment, Chad, about foreign money ban is very critical, okay, because that is a tremendous amount of money coming in on ballot initiatives in the state. I think that was Senate Bill 1863. I think it was the chairman's, I'm going from memory.
2035.
2035, all right. I do think we need to add something to that, Chairman, as well as I think Ed, your comment about the expatriate vote, for lack of, it has absolutely no documentational evidence, period, end of statement. It's a total wide open can opener. I think that needs to be closed. Jennifer, your 1540, yes, we're going to expand that because the fact that we've got people that have to stay in hotels surrounded by sheriff's deputies is just a terrible indictment of what's happening and how frothy things are, because the elections officials are not the ones responsible for writing the law. We are, and they have to be protected in its implementation. And that level of threat applies to their deputies and others, and it's just a wonder we have people that want to do this job anymore. I've just, any comments on those three things? Because I have to talk to the deputy secretary or your assistant.
No, sir, Director of Elections.
Director of Elections, sorry, about teams. Any comments about those?
Just thank you.
That right. And Christina, look, voter roll integrity is paramount. I testified 20 years ago as the, quote, greatest tax assessor in history. Thank you, Ed. I'm going to remember that. And I went to Washington and testified for photo ID and a citizenship list. 20 years later, it is still, Senator Hall has not passed. And the younger congressmen look at me and say, effectively, I'm a living fossil. Then I refer him to Bob. Never mind. That's right. Who is going to be going at this when he's at 100. But it is a simple concept that we've avoided for 2 decades at a federal level. It does talk about the interplay between the NBRA and the Help America Vote Act and all these other problems that we've got that we have to deal with. So, but voter roll integrity is totally number one. And with that, we do have to talk about teams, because I have got just a Christmas tree looking, set of problems that came my way yesterday. And I do want to point out, yes, you absorbed VOTEC, which was unusual. And yes, you have to absorb redistricting, and you've had a whole bunch of things to do this, Christina. So I'm not trying to pick with that, but we've got a problem in Harris County, Seabrook, Texas. Harris County verified 1,700 voters. The team system says there's 181,000 voters there right now.
I can explain that.
Okay, well, quickly, okay.
So this Harris County is an offline county.
Right.
They don't utilize the team system exclusively. In the system, if they don't have the right precinct assignment, the system will default it to a specific precinct. And so it goes back to Harris County. All of our offline counties have a responsibility to make sure that their data is correct in the state system. If we don't have the precinct assignments correct, the system will just default it to one precinct, and that's what's going on there, is we don't have
Kevin in
precinct
Natchez
assignments
County
correct.
has the same problem, right?
sorry?
Natchez County, Kevin, you know,
Nueces County, offline county
No,
as well.
sorry, Nueces, right, yes, right, same one. Now, this goes to a question that I've got. There's a tremendous amount of technical support for the offline counties and for the online counties through Team. And the problem is the aggregate is not strong enough to do what's necessary right now. At least
Yes, sir. That's
right,
correct.
I don't believe so.
That's correct.
Now, I have to ask, your vendor now on 4.0 Teams is Civic.
Civics.
Okay, how big of a company are there? How many states are they operating in? How much technical resources do they have? Because there is right now no chance to bring the offline counties into a system that has that level of complaints.
Absolutely.
Right, so I'm trying to understand how big of a vendor did we pick?
Sure. So we had a competitive bidding process for the contract, and we had 2 vendors that bid on the project. And Civics was a vendor that was ultimately awarded the contract. These are records that individuals can request and review to understand what took place in that competitive bidding process. I will say I can get you details on Civics and their kind of corporate makeup and the number of clients that they represent, but there's multiple components to that company. They don't just work in the election space, but they do also work with a handful of states, providing the same kind of voter registration support and services that we have. Louisiana is one of their big customers. I think Iowa is another one.
But Texas would be an order of magnitude larger.
We are the biggest, without a doubt. And I think given everything that's happened this year and the additional support that we have needed, I think most folks would say we're probably the customer that's getting the most attention at the moment.
Well, I would hope so.
Without a doubt.
Yeah, right.
And without a doubt. And, you know, when the VOTEC situation occurred, and we had to pause the redevelopment project. And I will say, you know, Mr. Johnson talked about what he would recommend, a phased rollout, no major changes in the system within 90 days. That's exactly what we were doing. We had a phased rollout scheduled for this, a phased approach where we were releasing different modules. We had a plan to work on issues every week that they were coming up to resolve issues within one individual module before we moved into the next one, until that situation happened. And the VOTEC situation, I cannot underscore enough how catastrophic that situation was and what we had to do to stop everything that we were doing to support our online counties to make sure that we had that election in November.
No, Christina, because there was actually a possibility at one point that
Yes, sir.
that vendor was claiming they were bankrupt, they were refusing to cooperate.
Yes, sir.
They asked for unbelievable amount of money from the state of Texas, and that was a difficult situation to
Yes,
get
sir.
through. And so I know that. Now,
What I would say, if I may add one thing, sir, what I would say is, given the fact that we don't make big changes to our system when we're within so many days of an election, and we have not been without an election since November, given that we had congressional vacancies and a Senate vacancy that we had to fill in January, we had the March primary, we had 3 elections in May, here in June.
we have runoffs, we've got.
Absolutely. We have not had the time to go in and address the big issues that our counties need us
Okay,
to address, and we do now.
You're leading the point. It is
Yes, sir.
critical that you try to get these big county, and also I'm going to read several small county issues
Mm-hmm.
here resolved while you've got about a 60-day period to do it.
Yes, sir, that's correct.
And that's why I'm asking, is Civic big enough to handle the questions? Because these are really big problems that I see in the system right now.
Yes, sir.
Okay, and really we're capacity bound by the vendor to be able to make some of these changes, true?
Yes, sir.
Right. Kim Wren from Austin County Tax Assessor Collector asserts that much of the information in the SOS utilizes flawed, bad example of, she's got problems with the ballot by mail module that
That's
you've talked
the one
about.
that needs the most work for our county.
Right, because they've got all sorts of problems with individual, I won't even go into the individuals that have had issues. And the new software did not recognize change in registration statuses that was sent back and forth between 2 counties. Monica Foster, Jackson County Tax Assessor Collector. Their online echoes frustration with SOS Office and their responsiveness to these. You've got to set up version control, okay, where there's specific understanding of individual changes that these counties want to make, so they have some idea if there's ever going to be progress or not, because they're saying there's 20 or 30 reps that they work with and they're, quote, demoralized, at least from the Travis County view. I'll get to that in a second, because they're not given any data as to when these problems are going to be resolved. Travis County's had to do workarounds of,
Absolutely.
because they're the largest team system, okay? They have 940,000 registered voters. And Christina, Jefferson County says that when Teams actually puts initial voter registration roll in, it never gets changed. At least that's what they view. Now, there's all sorts of, we could spend hours here talking about that. I just want to just absolutely encourage you as a former elections official. When I get half a dozen counties with their hair on fire, and some are small and online and some of them are big, it means that the vendor is behind on actually delivering fixes to the system. And those fixes have to be done, because if we go into a November election and we can't claim that we have integrity in the voter roll, we're going to have questions with people on recounts, questions with people on election results. So I don't know what else we can do except encourage that they work whatever they can. But I could spend another 30 minutes going into detail stuff, which I think you're aware of.
Absolutely, sir.
And it just has to be implemented as soon as possible.
Absolutely. Sir, there is nothing more important in our office than this project. I can assure you of that. And I can assure you that we are dedicating every possible resource that we have within our office to resolving these issues.
Right.
It's a combination of issues. It's not just system issues. Some of it's data issues with counties, some of it's workflow. And I promise you that we are doing everything that we can to resolve this issue so that we will not have another discussion about this with respect to the November election.
Because we just don't have time.
That's
We're running
correct.
out of daylight.
That's
because
correct.
these
Yes,
changes
sir.
have to be made in the next 60 days,
right.
tops 75, and otherwise we're staring down a major election for the state.
That's right. Yes, sir.
And consternation is at all-time high. I want to thank you for your comments about Val Verde, Texas. That was the purpose of 1933. I've got it posted on my social media. People believe that that was a punitive law. It was really a what gets measured gets fixed law. And to prove that point, Senator Zaffarini was a Democrat county judge that asked for that oversight over a Republican tax assessor to get that problem resolved. And I think that, so I appreciate that. And also, we do need to strengthen this whole concept of Chapter 19. That has to be reviewed, because that's another bill that we passed, which was Senate Bill 1113, that gave you the power to withhold it if people weren't doing the work to clean up their voter rolls. But all this goes back to one thing. If we don't have voter roll integrity, we will not have faith in the election process. And that's just the end. That is the key thing. So we have to have a statewide voter roll with integrity, as well as the local rolls as required right now. And they're going to run in parallel for some period of time.
Absolutely.
And so we're going to have to figure out how to make those sync up.
Yes, sir.
Okay. Anything else? Did I miss anything? Comments?
I just want to thank you. You just echoed some of the anxiety that I think election officials all over the state are feeling, not just the tax assessors. But I also want to give you the confidence in knowing that your county election officials do know what they're doing, and they have run the past 4 to 8 elections by taking lists, comparing lists, doing a bunch of
workarounds.
A bunch of workarounds. So I don't want anybody to feel like the elections are not secure. They are secure. I just don't know if that's sustainable moving into November.
And Jennifer, and here's the point. We're going to look at these recounts too, Chad. That's something we should probably look at, whether they're automatic and the state pays for it, and also recount mechanisms on hand-counted ballots. All this stuff has to be looked at. But if we've got an election in Seabrook and somebody files a contest, and the local group says it's 1,700 registered voters, and for whatever reason, the state has 181,000 voters, then we got a problem, because that election contest has two separate sources of fact, one the state and one local. And while there's been workarounds to fix all this, okay, eventually this is going to catch up. So I'm just trying to make sure that we just, whatever we have to do to try to get, and that's why I'm concerned about civics. And to the rest of the panel, and I think Senator Hall knows this, there's a problem with how much capacity any one vendor has to handle all these problems at one time. Part of the advantage of having vendors do offline work is that multiple vendors were doing it until Votech it just, literally poured gasoline on the fire and disappeared. So when we look at having to make all these technical changes, Texas is an enormous place. We've got more taxing jurisdictions that can level a property tax than any other place in the country. We have more elections. We have more individual local governments. Trust me, I count all 4,500 of them all the time. So I really have to I need some data on how big Civic is and are they big enough to handle this problem, because all these changes that they're requesting are going to come through that one vendor.
Senator Betancourt. One comment on this. We really need that enforcement tool, or Secretary of State needs that enforcement tool to make these counties get in sync with the state, because under Help America Vote, the state voter roll is the official voter roll, not the counties.
I know, and Mr. Johnson, I'll use formal terms too. Okay, when the locals are running a workaround, as she said, and they're using a local roll, that is a trouble for an election challenge, because the state roll in Seabrook's case is preposterously wrong for whatever reasons, okay? And so that's what I'm concerned about. And as much as we can tighten all this up in the next 60 to 75 days, we need to do it. Got it? Okay. All right. Thanks.
Thank you, Senator Betancourt. Senator Perry, you're recognized.
Thank you. And so take a deep breath, Christina. Just relax a little bit. So here's kind of, and I'm dealing with this over on the HHC side, and I'm dealing with it in just numerous areas. But here's where I'm at. This is Groundhog Day for me again. This issue regarding voter registration is never going to go away until we plan at a very granular level. And then we set time. And as a budget item for the state, we fund. But then we hold people accountable. And Christina, bless your heart, I think you are doing a yeoman's job. And, people bring bigger challenges. But what I'm getting to there is somebody at a very high level that understands big data, AI, movement of big data, security around big data, has to be the point person. And it's not only your agency, it's HHSC. We're going through the same thing conversation, because I'm tired of doing this process every 2 years to say, well, we still have this problem. We still have this problem. So garbage in and garbage out. Groundhog Day for me again. So you can't do this, Christina. This is not your role. You know what problems are. You know what probably should be done. But when it gets down to the nitty-gritty of actually fixing data and making it accessible in a real-time fashion, that's not your expertise. And I don't think, honestly, the state has those internal resources at agencies. They have data people and they have technicians, but they really don't understand probably the AI concept and the clouds. If we're building out all these stinking cloud accesses, then it's big enough to hold the data. It's 20 million voter rolls. Mm-hmm. It's a lot of data and it's history. But where I'm coming to is, Mr. Chairman, it needs to be, I guess, by bill, but someone needs to take the bull by the horns and put it in a formal process that we have X number of years, and we're going to require all these local offshoots of third-partiers out of the system, give them a window to clean up their data, and then you suck it in. And if there's data errors, there's a cost for them to come in and help clean it up. But we need a very detailed plan to get through this process, because if we just leave it up to us every 2 years in interims to have a conversation about data integrity and the problems it creates, I promise you, if someone to do the economics of it, we're spending more money on the back end cleaning up messes and all of the hyperbole that comes out of it and all the voter consternation, that the falsities that we chase as politicians, that this is all hairy-carry, hair's on fire. It's time to stop. And you've got to have someone that can work with us and sell us on the idea that this is doable. So whether Civics is the company or not, the technologies have evolved where it can be done. And I don't know if Civics is. And if this isn't their sole purpose in life, then they're not big enough for Texas. I promise you that. This is an all hands on deck. This is a huge contract. This is a huge maintenance contract going forward. So they could almost be our stuff if they choose to do it as a business model. But I'm done with the conversations around voter integrity roles until we actually put in place a required scheduling of this is our benchmark. The locals get on board, get the data cleaned up, because we did this in HHSC for 30 years. What we would do, and Ritter, it's on us to give them the plan.
Right.
It's not on them to determine the plan, because what we would do in HHSC for decades, Mr. Chairman, we've spent billions of dollars with Deloitte's and Accentures and all these guys and IBMers of the world and Ross Perot's old company, and only to find out that they did exactly what we told them to do in a siloed fashion. But you know what they were fighting is they did what we told them to, but our data was so bad that the output was worthless. But they did exactly what we asked them to do. But what the HHSC group, to their credit, has said, we're not going to have any of that conversation until our data is clean. So that's where we're at. But if we've got third-party vendors already in the system, they can clean that data up. And then the state's data needs to get clean too, because I promise you, being in the software world and the programming world and COBOL world and Fortran world, there was a time when you didn't put in checks and balances in it. You could actually have an alpha character in a numeric field that didn't catch it and throw it out and say this doesn't work. So I know what your data looks like. It's junk, I would guess, on a large input. For over the years, people put in crap that the fields didn't catch you and throw you out. So the AI world, this is what Elon did. He looked like a hero, but he just took AI data, he converted it all to a system, threw it into a spreadsheet, and where it had data death, if that was an alphanumeric in there, he'd throw that one out and go look at it. I mean, it's doable now, but I'm tired of chasing this. And so you need to be very thoughtful in what I'm going to tell you. Find somebody in your organization that can be lead to tell us with a detailed plan. Before we go out and find a vendor, tell us what the issues are in the data. Tell us a time frame that y'all can manage it. And tell us when we can get these third-party vendors into the system. Because until you get a single data depository, y'all are going to be chasing it, and we're going to be having these conversations going forward, because you can't have one truth.
That's right.
There's only one truth in life. The Bible's one truth. In data, there's only one truth. If you got one database, you now know everything in there is either accurate or not, but you don't have to chase why it's in there if it's not. You know to go to it and fix it. And this conversation about multiple databases, and we think we can have consistency in the data. And then with that, you're going to have to give us a framework. How much real time can we expect from the system? So prior to an election day, what is the deadline cutoff for any changes into the system? And then who is going to be the keeper of that input? And who are they going to put? Is it the locals that can input, or can you be technically savvy enough to say Charles Perry moved from this block to this block today, and there's a reporting database that you don't have access to, that if you had access to it, you would say, oh, Charles Perry moved today, let's just make that happen. Because if you can eliminate people's inputs into the system, you eliminate data errors, except for the guy that's responsible for putting my move in. But you got to be very detailed on how this works. And I don't think we have the expertise on this committee. We know a lot. But without that roadmap and without that plan and without a holistic approach to what deadlines need to look like to guarantee real time, and then you catch You catch it at the poll when they say, well, you don't live there, I'm sorry, we'll put you on provisional ballot. And now you're working with a subset of a very smaller group, because you will never eliminate 100%. So if they're right coming out of the registration and someone goes to vote and it doesn't match the registration, you put them on provisional, you clean it up, that's manual process, whatever. But this is getting old, people. It's getting old for this legislature. I'm in the 20 year of my life cycle, my season. I bought my last truck. But I'm not going to spend 10 years of the next 20 years at the Capitol talking about voter integrity rolls. Not when technologies and clouds and data movement, data block, or whatever the big data move software exists. We're better than that. It will not happen without a plan. And a granular plan to where this legislature, the next 5 sessions, will have an accountability function. Where are you at? You said you'd have all these guys in and do it, because it ain't going to happen because you're too busy managing the multiple election dates and the problems that just come with it. This is not your job. You shouldn't be in this conversation today again. It's on us. Thank you.
Senator Perry, one of the things that the legislature could do to help this project, just as we're talking about, is give the state the ability to match against other databases, and when they find this error, to match up with the National Voter Registration Act, you have to send the voter some notice. That tool does not exist right now.
I appreciate all the minutia, but it still starts with a database. Here's the other thing. Then you're questioning which database is right. If you're comparing it to 15, which one's right? Secondly, I'm sorry, Mr. Chairman, we're having this conversation about federal and state separation. I understand the need for it. It makes sense to me. It doesn't make sense the feds can't do smart, common sense things that they're not going to because they're not smart and common sense. But here's the question. All these things that we're doing in this environment of teams and coming on board in data, are they already visionary enough to say we're going to separate federal and state, or is that going to be a complete overhaul if the state chooses to go there? So it's those thoughts that I hate to even ask the obvious, but I found as a legislature, if I don't ask the obvious, then we are disappointed 5 years in and say, you're going to have to spend $20 billion to actually get the federal and state separation. Are we in that conversation with these vendors?
What I would say to that, sir, is that question has come up enough over the years. That was definitely part of our calculation when we were building out this new system, is making sure that there was some flexibility should that be the direction that we have to go, and it wouldn't require some kind of massive change or massive build to the system. Okay. That doesn't mean there won't be some cost, but it won't be what it would have been 5 years ago.
Let me give you a good example. To add a field in the database over at HHSC, when we ask for a different field to track some data point, it comes back sometimes as silly as $40 million to change that field. So being visionary, this is not rocket science. We know how to get a good voter integrity roll. We know what that expects. We may add some data points down the road that don't exist today that make it easier, but just as long as that's in the conversation. On the one that left us hanging, do these contracts have some remedy provision that when the state has to clean up their mess and is out $600,000, do they have to pay us?
No, we don't have anything in state law in particular. You know, when a county onboards to our system.
These are contracts.
So we were not a party to those contracts, sir.
Okay.
That would be a question for those local governments.
I appreciate it. I'm just saying we can fix this, but we're never going to fix it if we keep doing this routine every 2 years. And you can't stop long enough during a year to actually address it. So you find somebody, and lastly, shame on you if you come to finance with an LAR that does not specifically give me a time frame to fix this voter integrity roll and personnel. I don't have to have a vendor, but you better have somebody that's top shelf that's willing to work 7 days a week for 24 hours a day for the next 6 months just to have the conversation to find the right vendor. But if you need people and you need resource to close the door on this conversation and you don't ask for it, because I'll be your biggest advocate. This guy will be. I think Senator Hall's on there to fix it. But if you, and I'm not being exact, if you say, I think we're going to need these people and these are people we're talking to, let them talk to us too. But that is your job, kind of at that level, to make sure the LAR respects what we're trying to do. But technology, you made a great point. We had to use third party before technology. You know, when you could store 100 gigabytes and that was massive. Now we're building petabytes, petabyte, whatever it is. We don't have to be reliant on technology limitations anymore. Plain and simple. That's kind of scary, but there really is no end to capacity. And real-time access, I can pull up 2 different AI companies right now and ask whatever I want on my apps, and in 30 seconds, I usually have a response that's more detailed than I'd have gotten if we'd have put a bill together to study it for 3 years. So it's here. Just tell us you got the people, you need more people, and then we'll go find out vendors. But we've got to fix our ship before we hand it over to somebody to direct. Thank you.
Senator Parker, you're recognized.
Thank you, Mr. Chairman. Well, appreciate you all being here today and the seriousness of what you're taking up, all of these issues. And Christina, in particular, I want to thank you for all the good work you've done for so many years. And I'll tell you firsthand, I'm taken back when you're going through personal difficulties of great extreme with your family and some of the horrific things in life, and you're there to respond to my calls, and I always appreciate that very much, particularly when we're talking about all the hand count audit bill and Senate Bill 827. I was very fortunate to carry that bill, and I've gotten a lot of good feedback from people from a lot of the smaller counties and so forth that it was really working effectively. So I'm very thrilled with that. But I would like to get your thoughts. Of course, I think that hand counting audit is vitally important for the future of our state to ensure election integrity. A lot of those counties now are literally hand counting everything, which again I think is a good thing. How would you supplement or tweak or help them to be able to continue to do what they're doing? Are there any adjustments that you would make to that legislation, now seeing it implemented now this cycle, that would improve what we're doing in terms of accuracy and in terms of the support for the smaller counties in the state?
Those are great questions, and these are things that we've had many conversations about, and I will tell you, Ms. Doinoff also has some suggestions in this area. One of the things that we have noticed is that when we were looking at Senate Bill 827, you're looking at legislation, I think we addressed some of the concerns that were out there with making sure that we were doing more hand counting in more races and giving our local entities more control over that process, where they could add locations, they could add races, so that it was reflective of the needs of that local community. There are some other provisions there related to our cities and our school districts where we didn't make those same alignments. And in talking to our local political subdivisions and in talking to our elections administrators, I think mimicking some of those changes that we made so that those changes apply to our local folks as well. Right now, actually, the way the law is written sometimes requires a full recount in some of these local small jurisdictions, and making what they do more analogous to the counties, where it may not be a full recount, it may be selected races, but it gives them more control where they can add additional races as needed, add additional locations to reflect what's happening within that community, or if there's issues in particular parts of their jurisdiction. To give them that same kind of authority and those same requirements that the counties have, I think would help tremendously in some of those situations. The other thing that's come up is, and Ms. Doinoff mentioned this, one of the other changes that you made, sir, was to put the ballot board in charge of the hand count process for this post-election audit. Right. That was an excellent change in that it provides more separation from the county to the individual, to the counters. We don't have the county checking their own work, so to speak. That has been great in adding that set level of separation there, but it has increased some costs, in particular for the primary, because that hand count is a responsibility of the general custodian. It's not a responsibility of the party. But because it's a responsibility of the custodian, it's not a reimbursable primary expense that the state can pay for.
I see.
And so there may be a few other little tweaks like that that can lift some of those burdens on the counties to help make this process just more feasible for them on a regular basis from a budget standpoint too.
Oh, that's very good. Thank you for the feedback. Look, I just think, the hand count process is critical. That audit component It was very important, and it was great to work with you all, and thank you for implementing it so well with such fidelity. And I appreciate the feedback for what we can do going forward. I want to switch gears for a moment on some of the things that my colleagues were talking about, big data, and obviously getting one repository of data. I couldn't agree more, obviously, with the importance of that, obviously, to be able to have true election integrity in the state of Texas. And one of the things, whether or not we're talking about the cloud, whether or not we're talking about AI or the future of quantum and all those things that are coming at us very rapidly, I think it's vitally important that we recognize that we today, here in Texas, last session, I was very fortunate to carry another bill, which is the establishment of Texas Cyber Command. Mm-hmm. And now that Texas Cyber Command is getting operational, I believe we'll have the finest cybersecurity capabilities, not just to play offense, where I should really say not just play just defense, but to play some offense as well with bad actors around the world that are threatening Texas. But I think it's very important for us to talk about how you all, from an SOS perspective, can utilize some of the talent that is there right now that we're amassing with regard to data. We've got some great data scientists there. We've got great AI experts. We've got some really brilliant cybersecurity professionals. And I really think when you're putting together that LAR to come before finance and put together the full package about what needs to be done, because look, we're so grateful for what you're doing, but you need to have the tools. Yes. So give us the tools is what I think Senator Perry is saying. We'll get you the tools. Just tell us what you need, put that roadmap in place. But I think utilizing the assistance of Cyber Command could be of great value to you in this process. It's an investment the state has already made, and I think it'll be one of the finest investments we ever made because, again, at the end of the day, there's nothing more important than the safety and security of our people, whether or not we're talking about physical security, which obviously is impacted by the digital footprint, or whether or not we're talking about election security. It's all vital that we tackle it. And so I just think there's a real opportunity that we can leverage the good work that your office is doing with Cyber Command to be able to address these big data and AI challenges and really get some out-of-box thinking from state personnel before you contract with the private sector. So
absolutely, sir. Data security and data accuracy are two sides of the same coin.
Yes.
And both equally important, and we will absolutely do that.
Great. Thank you all for all you do. Thank you.
I'll just add one thing, Senator Parker, and this goes to what Senator Perry was saying too. You guys are both right over the target nationally of what other states are looking at. You look at Ohio, they established in their Secretary of State's office an Office of Data and Data, can't remember the full name of it, but data purity, making sure the data is correct.
Yeah.
Right? And they have a dedicated team to that, someone who can look at data, know the limitations of data, talk to your vendors and say, oh, you're trying to charge us $40 million to change that field? I know that's, out of bounds. That's ridiculous. So Florida's done it. Ohio's really led the way on it. So there are models out there that Texas should, grab a hold of and then, make them Texas worthy.
No, look, we want to lead on all things, right? Texas needs to lead on all things, and so we need to do this right. This is the next objective, obviously, in this realm of election integrity. And look, I've done a lot of big systems projects for years before the legislature, and garbage in, garbage out, right? If you don't have good quality data on the front end of the process, you cannot hope for a good outcome, right? I mean, that's just silly. And so we just got to recognize that. That's why I think all the commentary from my colleagues is so spot on that we've got to get to one repository, period. There's got to be one repository that is king and without question, the one source of data that is accurate. So I think we'll get there. I know we will with your support, this team's support, and the help of the legislature. So thank you all very much.
And thank you, Senator Parker. The Dean of the Senate is recognized.
Thank you, Mr. Chairman. I'm particularly interested in Ms. Doynoff's responses since you represent the election administrators and officials throughout the state. And first and foremost, we've talked about the number of days and how long early voting should be, and we've talked a lot of related issues. What would you think if we just ran up to Election Day and worked backward, regardless of the number of early voting days, if there was no period between early voting and Election Day?
So we are discussing that in the next phase of this in our panel for Senate Bill 2753. Mm-hmm. And we are working with Senator Hall's office on a lot of initiatives that we think can help implement that process a lot more seamlessly. Some of that being scheduling, because we do hear a lot that the number of hours, especially the 12-hour days leading up to a 12-hour election day with no break, and 9 hours on Sunday tend to scare some of our poll workers a little bit, that are probably the average age of 72 and older in some areas, and already exhausted, even with the break in between. So we're working with Senator Hall's office. We don't have, our membership is compiling a ideal schedule because I think some of our membership think that 5 days or 7 days may not be enough time. And so we're looking at other options with maybe hours and things that we can change with that. We're not done with that data, but we have talked with Senator Hall's office and plan to get him something like that.
And I know that some of the confusion was that during early voting, in some cases, voters could go to any voting site, but on election day, they had to go to their designated precinct. So if you consider that, I would hope you would also consider applying the same rules, election day and the other days especially, if there's no period in between.
Absolutely. That is actually a part of our next panel discussion as well. But yes, we believe 2753 works best in counties that operate under the countywide polling.
Good. Second, somewhere along the line, and I don't know when, we increased the number of days for the runoff from 30 days to now, what is it, 84, 85?
Days of
How would you feel about shortening the runoff period? I heard more complaints about that long runoff period this
We're talking about for the primary?
for the primary.
Okay. I think a lot of that depends on what is decided with the legislature on the May election. Just because those timelines do overlap, it is a lot. It's very confusing to voters. And I think we have a lot of good ideas coming this next legislative session for filing, maybe changing some of the filing deadlines and you guys looking at the May elections.
Dean, I was going to ask that same question. You'll recall we extended that, or the legislature extended that time frame. It used to be the runoff was 30 days after the primary.
Which
It
was too short.
Yes, ma'am. But it was extended, as I recall, because of overseas military ballots.
Yes.
So, Ms. Atkins mentioned of changing that, but what about that? If we wanted to, could we shorten that?
Sure. So a big part of that change has to do with federal law requires that military ballots be sent out no later than 45 days before Election Day. And so because they have to go out during that time frame, you have to get through your canvass, you have to get through the programming of your equipment, the testing, before you can even get to the mailing of ballots, which is why we have that long runway. For our congressional vacancies, legislative vacancies, those elections are about 70 to 77 days out, typically, from that main election. It's a long time. Now, I've been asked this question recently about why we're hearing about other states that have a much shorter time frame and why can't Texas do what they do. So I've called around and I've talked to my counterparts in other states to find out kind of what their scheme is. And in most of the states that have a shorter time frame between the runoff and the main election, to address the issue with military ballots, they typically have instant runoff for those ballots for the military voters. Not widespread throughout the election, but just contained to that group of voters where they're ranking their choices. It's a form of ranked choice voting. And then those ballots are held and they don't have to send another ballot to those military voters. And that allows them to not worry about that 45-day deadline and they can move their runoff period much earlier.
Thank you. Were you going to say something on that, Mr. Ennis?
Yeah, SB 1209 from Senator Hughes last session that consolidated everything to November and got rid of that May election, the May constitutional, did shorten the period. So we shortened it by, I believe, 2 weeks.
2 weeks.
That we thought you could still get in the things Christina was talking about and the things Jennifer was talking about and still have that election. And then the other thing is, as Christina says, there are ways, if we want to shorten it more, to get there. It just takes some work to handle those overseas and military ballots, so we give them every opportunity to weigh in as well. But there are ways to do it across the South where we have a lot of runoffs. The states deal with it. Georgia deals with it with their short one. Mississippi. So there are models out there.
Thank you. And back to, did you have something?
Please, Dean, go ahead. Thanks for letting me interrupt. Go ahead.
Thank you. Back to Ms. Doynoff. On June 3rd, I wrote a letter to the Secretary of State, and I'm going to follow up with her successor. Much as we'll miss her, we will have a successor soon, so I will follow up with that successor regarding a request that the Secretary of State appoint a permanent standing committee as long as it's needed of local officials that would address the issues related to team. Would that be helpful to you and your other election officials?
I believe so. I think probably if I could have everybody here in front of you right now, they would say the biggest thing is they don't know what's happening. And there's a big feeling of, what are we going to do if these issues aren't fixed before November? And so I do believe that that would bring more local officials into the process, and I do believe that that would give that feeling of our voices being heard.
Good, thank you. Thank you for those answers. And Ms. Atkins, specifically regarding the non-citizen voting,
Yes, ma'am.
why were DPS records not initially cross-checked before counties received flagged lists of non-citizen voters?
For two reasons, ma'am. First, because DPS utilizes the SAFE system as well. And so we had no reason to believe that there would be records from DPS that would have a different response than what we were getting from the SAFE system. So that was the first reason. As we have heard more from counties, we have identified some inconsistencies there, and we have worked with DPS on this. So we did ask them to do a full review and look at all 2,700 records. And that leads to the second reason why we didn't initially make that request. When we first received that data and had some conversations with DPS about it, there is no easy way to do a search on their database for that level of detail. The database itself does not capture the type of document that's presented when somebody provides proof of citizenship. So they have to manually review each individual record to look at the scanned images of the document that was provided and locate the data points that we were asking for. That process has taken them, we made the request several months ago, and we're still waiting for that data. They are working on it, and they are giving us updates, so DPS is being extremely cooperative. I want to acknowledge the hard work that they have done there. But in reviewing that data and looking at where we were on the election calendar, given that we didn't expect the inconsistencies, and given that it would have taken DPS a significant amount of time to do that research, we thought it was in the best interest of those individuals, these potential non-citizens, to provide that information to our counties so they could begin their investigative and review process. Because our counties may have access to more data than we have. Some of our counties keep records on naturalization ceremonies. Some of our counties work with their local law enforcement to get data. Some of them work with local DPS offices to do additional verifications and data. And the biggest thing that came out of this is that many of our counties, well, I will say generally all of our counties, I believe, do this. The first thing that they do when they get a non-citizen match, and we've learned this from the non-citizen matching process we've been doing for the last 5 years, is they go to the original registration application to look at what that voter put on that application. Because people sometimes make clerical errors. And when you talk to our counties and you ask them about what what they see in the data that's been provided, many counties will tell you that they found mistakes where they maybe had temporary workers assisting them. A voter properly identified themselves as a non-citizen on the application, but the application got processed anyway. And so for those situations, the county can very clearly see where a voter was properly disclosing their citizenship status, or rather their status as a non-citizen, but the registration happened anyway. That was not the voter's fault. And it's in that voter's best interest to quickly take action on that and remove them from the voter rolls, or go through the process of removal where they send out a notice and notify the voter, because I think our election officials in our office, we know the consequences of that. We know that DHS and that folks that are pursuing naturalization, these are things that can harm their immigration status. And in most of these situations, you don't see voting history on these records. That's a strong indicator that these individuals are not aware that they're registered. And so for where a county could take action quickly, we thought that it was in the best interest of those voters, too, to give that information and to put it in the hands of the county so they could begin that process and address the issues that could quickly be addressed while we all continued doing research and looking into those records.
Thank you. And as of today,
Yes,
how
ma'am.
many non-citizens have actually voted in elections over what period of time?
I don't have that data. That is something we will be doing some more research on when our counties complete their part of the process, their investigation process, when they provide all of the responses to us of individuals that confirm citizenship. So we know what individuals to remove from that list that we're evaluating. At that point, we'll be able to run numbers on there to determine if any of those individuals that have, we have indications in multiple databases, I'll say potential non-citizens, where we have indications that these are potential non-citizens if there's voting history tied to
You have
those.
a range of your expectations? High and low?
I don't, ma'am, actually. I don't. I would say I don't, because the only thing that I would have to base it off of is maybe work that we did about 5 or 6 years ago. But I think because we have engaged with DPS and we have this weekly DPS non-citizen list maintenance process, I think we've been able to tackle a lot of the potential non-citizens that were on the rolls, again, in many cases inadvertently. So I don't know, I don't have a sense of what those numbers would be now, but that is something that we will look at.
Thank you. Mr. Chairman, this particular aspect of the issue hasn't been brought up, but the issue of buying votes, and that is certainly related to election security.
Yes, ma'am.
So if I may, even though we don't have a
Please.
representative of the Attorney General here, I'd like to ask these panelists, suppose that there is a voter in any county in Texas who knows that a candidate has attempted to buy votes. What should that voter do? What are the steps to ensure that that law is enforced?
They have several options in front of them. They can always make a complaint to local law enforcement, though I understand sometimes there's sensitivities about handling that information locally.
But by local law enforcement, the DA, the police?
DA, they can go to the DA, they can go to the Sheriff's Department. Those are the two, usually typically the first two places that individuals will go is their local Sheriff's Department and
What
the
if it's a
DA's
sheriff?
And that's where, I think that's where the state comes into play, ma'am, because individuals can make complaints to our office, and we have statutory authority to make referrals to the Attorney General's office for their review, so that they can investigate and consider the situation there. So when we get a complaint that comes to us providing evidence of potential ballot fraud or voter fraud, we do a referral to the Attorney General's office where they have investigators that'll then take the issue and look into it more. In addition to that, I know that the Attorney General's office has at times partnered with the FBI because we have answered questions for the FBI on this issue. So I think there's also avenues through the federal government as well. But typically, our first move at the Secretary of State's office when we're provided information of a potential criminal violation is to go through the Attorney General's office because of the mandates that we have in state law to report there first.
Mr. Chairman, I really think this is something we need to look at and to have a very specific procedure because there is such a case. And basically everybody was pointing to everybody else. The district attorney said he could not react until he got a report from the Texas Rangers. Then at the state level, the point was that they had to hear from the district attorney, and so we don't have a specific procedure. And it's a very serious question. I'll send you a video about it.
Senator Zaffirini?
Yes.
Senator Betancourt's bill he had last session, we nickname it the Marshall Bill, but it addressed that because I see that problem in Harris County and all over the state. It addressed the ability to have an investigating group that could immediately respond and then a fast track through the court system so that you could resolve it. Because if you don't resolve it while the election's going on, it's too late. So I would help you. I think you could get Senator Betancourt and express those to him and make sure his bill's covering what you want.
Thank you. Thank you all. Thank you, Mr. Chairman.
Thank you, Dean. Senator Hinojosa, you are recognized.
Thank you, Mr. Chairman. Ms. Adkins, as you know, I'm from Nueces County, and Nueces County is one of those offline counties with regard to the team system. And first of all, thank you for your rapid response and taking my calls and trying to help address the situation. But for the benefit of the committee, could you kind of go over that scenario and what happened with those offline counties that were trying to upload their data,
Absolutely.
where the data is not correct at the state level versus the county, and what's being done to resolve that, just for the sake of the committee?
Absolutely. Yes, Senator. So we had a situation in Nueces County where it was brought to our knowledge during the primary, during that early voting period, that the redistricting data from Nueces County had not been fully updated and put into the team the state system. Again, I want to reassure everybody that from a voting purpose, people locally were getting the right ballot, and this did not impact the accuracy of somebody coming into a polling place and requesting a ballot, getting the right ballot there, because the data was right locally. That being said, it had a huge impact on the reporting of voting history to the state, and it had a huge impact on the reporting of in general accurate voter lists that the state produces for all of the various requesters that we get in this issue. And with redistricting, when this happened, our counties that were online, that was a much easier fix for them. It was a much easier process in some situations. Some of our counties had to go in and manually make all of these changements to their street segments, to their districts, and manually make changes to what voters were in what districts to align with redistricting. And it was pretty substantial in a lot of counties. I say this because I know that Hays County had to do all of this work manually. We had some counties, and this is specific to our offline counties, where they don't have that level of detail in our team system. We don't have their streets in our system the way online counties are in our system. So we worked with our vendor to develop a process where we could upload a series of reports that made changes to the streets and to the district assignments and to the precinct assignments for all of their individual voters. We contacted every offline county to say, do you need assistance, or is this something you're going to try to do manually? Or can we help you with this upload process because this was so substantial in some counties? And so we did work with a handful of counties early on where we were working on uploading this information. And then, of course, the county has to go back and validate to make sure that that upload occurred the right way and that all the assignments worked as they should. Nueces County, my understanding from working with the county is they thought they could go in and do this upload process in a different way. They had not contacted the state on the front end. We, in fact, had confirmations from them that they'd already handled the redistricting, so we thought they had made those manual assignments, but it turns out that they thought they could submit the files in a different way. And it didn't process them the way that it needed to. And so we went back and worked with Nueces County to help them generate the files that they needed so that they could get that data in our system. And then, of course, Nueces has to go back and validate and make sure that all of that information was entered into the system correctly. I think over the last few months, we have discovered that not all of the system is accurate. Not all of that data is accurate. That local validation of data is an extremely labor-intensive process. It takes a long time. It's very detailed, granular work. And I know many of our counties, because of where we were on the election calendar, were not able to perform those detailed validations as quickly as we would have liked them to do these validations. And so we're continuing to work with counties. Nueces is one of them. Mm-hmm. I think they're almost fully there in getting that data aligned between their system and the state system. But we are continuing to do that work with all of our offline counties right now that we're past the election process, to make sure that the data is validated, that the county has signed off and reviewed what's in the state system, and they tell us that it's accurate, because they are the keepers of that data. We don't have the county level data. We don't know what it's supposed to be. The counties know what it's supposed to be, so only the counties can tell us if the data in our system is accurate. And so we're going through that process slowly but surely with all of our offline counties to ensure accurate data going into November. And this will impact the uploading of voting history. If their data is not right in our system, then the voting history won't be captured properly, which is why people were seeing information that was inconsistent on the state website than what they were getting directly from the county.
And is your confidence level that this is something that, for these offline counties? I mean, obviously, going through an experience like this, a lot of these counties are even more hesitant to want to come online, right? And is your confidence level such that the problem has been properly addressed? There is a process to rectify the situation. As early as, I guess, maybe a week or two ago, apparently that still it is not synced properly, or it's not, the numbers are not.
75% accurate is what I would say for Nueces County, and talking to my team.
Okay.
That we're still seeing discrepancies. About 25% of what we're seeing or we can attribute to discrepancies in this area. What I would say is that we have properly identified the issue.
Okay.
The state knows what the issue is. It's up to the county to get it right. It's not about the state trying to fix these issues on behalf of the county. This is where local counties, when they take on these third-party vendors, it's their responsibility to make sure the data is aligned with the state system. Nueces County is working very hard to do that. So I want to assure you there that they are doing their part It's just a difficult process. And
was there any other counties that experienced something similar in the upload process? Because that was what was initially the complaint on my end. And again, I appreciate your responsiveness to the situation, but it was in the upload process where they felt that there was it wasn't syncing right. So you're telling me that interchange, the upload process.
The upload process was fine. They were trying to upload it through a different mechanism. In the daily files they send us, they thought if we just change all the precincts there, it'll change the precincts everywhere we need to in team. And that's not how redistricting works. It's a much bigger process. So I think that was where Nueces County made an error initially, is they didn't tell us what they were doing. And they thought they could do it through this daily upload process. And that's not how redistricting works. Once we went back and worked with them and explained to them the differences and worked with them on generating files, that's how we started getting resolution on this issue. Again, it's contingent on the data they put into the system. If the data they put into the system is in the format that it needs to be, if it's accurate with respect to what's in their local system, then it'll upload okay, and they can go through and make those validations and tell us that, and then we're good to go. But it's up to the county to ensure that the data is in the right format, that it's read correctly, and that our system reflects what's in their local system.
And I appreciate that. You brought up another point about redistricting, and I don't think it's too common, but it did occur in Nueces County where we have 2 Senate districts, and at some point, the precincts were split.
That's right.
Which created yet a further issue. And again, is that rectified by what you just described, or is that just another anomaly piece that we need to look into and address when precincts themselves are split in ways like that?
So state law says that you can't split a precinct with a Senate district. And so that's something that locally the county has to go back and redraw those precinct lines to account for that district cutting through a precinct. And so that's more work that the county has to do. And the result is now we're probably going to have 2 much smaller precincts instead of a bigger precinct that has those lines that cut through the precinct.
But that created yet another challenge.
It creates
right?
another challenge. And what I would say to that, sir, is that's where we see issues, as Ms. Doyneff brought up, with some ballot secrecy issues. The smaller the precinct, the more likely it is to be able to tie a ballot back to an individual voter. There are a number of laws that we could look at. We don't necessarily need our precincts to be that granular. Now we can accommodate multiple senators in a district. We can accommodate multiple commissioners in a district, in a voter registration precinct, what I would say. And in making changes there, we could address some of the ballot privacy issues that we still continue to hear about, because it would give us larger precincts.
Yeah, thank you. And thank you for addressing those questions. I really appreciate that. And then to you or any other panelist, we talked about the audits, right? And the randomly selected audits for after the fact. Is there any mechanism, kind of to Dean Zaffarini's point, where if there's a whistleblower who says, hey, I've seen a lot of discrepant activity in this particular county, where an audit can be directed to a county that, was being observed as not doing things properly?
Under current law, there is no other process for triggering some kind of county audit. Right now, if we randomly select your county, you can be audited. That being said, I think it's important to remember that all of our election records are public records, and we have a number of groups that are out there, a number of individuals and community groups that routinely request this data and routinely review this data on their own. And I think that idea of a citizen audit is a pretty important part of the process. We want transparency in the process itself. And some of those individuals reviewing those records have brought issues to the attention of our county election officials and to our office that once we know about, we can fix. I've yet to run into a county that has told me they refuse to fix something that has been brought to their attention. Most of our counties want to make things better and want to improve process and procedure. And so when the state comes to them saying, here's an issue we've identified, in most cases, they very willingly take efforts to try to remediate those issues.
Thank you. I want to be respectful of the committee's time, but if you would just briefly kind of go over what that audit entails. I know I had personal experience in my first run for office, and there were some issues that we've all noted here are under state law. And, some of those, I'm not going to name counties or anything like that, but one in particular, I believe, had an audit. Yet, through my recount process of my first election, we found quite a few things that were highly suspect and discrepant in certain areas, including mail-in ballots. Could you just briefly describe what your audit process is and how how would we be able to find those types of
Sure. So the audit process is something that we have developed. Our audit of our different selected counties, we've developed over time. And Chad can probably speak to this a little bit as well, because he helped create this audit process that we have in the state. But it's a comprehensive audit. We look at voter registration records. We look at compliance with list maintenance. We do comparisons between the different data sources in elections, the data coming out of poll books, data coming out of voting machines, the vote totals, and how it aligns with voter registration data to look for consistencies or problems where we don't have an alignment of data. We look at chain of custody procedure. We will take a sampling of polling locations and recreate the election from a chain of custody standpoint. We look at policies and procedures. We look at security records. We look at training records. We try to take the most comprehensive view of specific elections, but also the organization of a given office. And so we will do a piecemeal approach for the election, and we do it for various elections because we audit multiple elections within a 2-year cycle. What we have found is that typically once we've done 1 or 2 big elections, we pretty much know what the issues are in a given county. But it's getting very granular with the data that they present to us and validating records, validating voter registration actions, and validating, to some extent, outcomes where we can.
And what is the enforcement mechanism for that? You mentioned something specific like chain of custody records. And again, just speaking out of personal experience, when we were running a recount, again, not naming any specific counties, but there was one where we requested the chain of custody records, and they were like, "We don't have any." So now what?
Sure, that's an interesting. This is kind of the plight of the county election official in some ways. Counties can do all the training in the world, and they can provide all the documentation, but sometimes it's hard to get the workers to do the documentation. And we do think that that's a training component. That most of that can be addressed with good training and good procedures for our local election
What's
officials.
the enforcement aspect of it?
There really isn't one, sir. There really isn't. It's not a criminal offense to not complete your chain of custody paperwork. Not currently, anyway.
But yet it's a law.
Yes, sir, that's correct. And what I would say is, unfortunately, the time where we see these issues come up and where people pay attention to some of those problems that they may identify, because oftentimes it may be, one polling location where the workers are repeatedly making the same mistakes or repeatedly not following procedures. But because of the way the appointment process works with workers, county can't replace those workers.
And Mr. Chairman, I think that's the major flaw of what we're doing here. We're creating law. We have no enforcement mechanism in enforcing these laws. Thank you for your time. Sir, maybe.
Well, Senator Betancourt's enforcement bill would be a great help on that. But beside that, though, in the chain of custody in the law, it just names, these workers, this staff. I think if you went down to an individual person, like the head of the administrative election, the election judge at the location, and put them personally in responsibility, I think they would get it done if they knew that they were on the hook.
Yeah, I'd be happy to work with Chairman Betancourt, and you're welcome to visit my office too with any additional ideas you have. I appreciate that feedback.
Well, and speaking for county election officials, I know that we know we're on the hook if we're not following the processes. So I believe that every county election official wants to do the very best job they can there. And I think you have to take a lot of different things into account. What kind of election was it? Was this somebody that was appointed by the party? Because in my county, there would be a lot of ways that I would look at that if that was a problem and address that with the party, perhaps, if they were appointed or so on and so forth.
Yeah, I don't have too much to add to that. It's, the procedural audit aspect, Senator Parker's bill kind of, it dealt with the hand counting, auditing of the machines, making sure they're counting correctly. But this procedural audits we're talking about, I think it was really important for us when we started it out to really get down to base level and not take not take the report printed out at the end of the election as gospel, but get down and look, what happened at machine 1 in precinct 1? And if we add that to 2, 3, and 4, do we get what comes up for the precinct? And then do we go up another level and the numbers match? I hate to call it an accounting game, but done right, it's an accounting game. Because you really want to track ballots through the system. Well, people come in, they turn into ballots, and they come out as votes, right? And so you really want to track that whole system and make sure that those steps are being followed everywhere. And as you said, a problem is that a lot of these steps don't have any teeth behind them. Well, you're supposed to keep a seal log. What if you don't? Well, there's nothing. Nothing happens. But when, as Christina said, a lot of this data, a lot of our counties are doing a great job of putting out the seal logs and putting out all the documents and putting them online. Well, if someone goes and says, hey, where I voted, there were no seals on this machine ever, according to the paperwork, that's not good. And I think the counties that have been audited, I think, they get it in stark numbers where they need to fix. And whether it's a training issue or an encouragement issue, however you want to talk about it, I think a lot of those things get fixed. And that's why I think it's really important to do more of these. Because as Senator Betancourt said, I mean, if you're a small county into the system right now, you're probably more likely to get struck by lightning than get audited. Because every 2 years out of 230 of the small counties, I'll take those odds. So, updating the frequency, putting some teeth behind it, giving Christina's team tools to say when they ask her something that they get it. Some type of I hate to say subpoena power, but something similar, right? Where if I'm after a record, I can ask for it and I get it. Those kinds of things would help a lot.
I'm all for training and encouragement. I think it's time we get some enforcement, right? Thank you.
Thank you, Senator Hinojosa. Senator Hall, you're recognized.
Let me just follow up the point. The concern about no penalty. It's against the law, but there's no penalty. That's a major problem we have, because as soon as you start talking about penalties for things in elections, you start losing election workers. To figure, if I make a mistake, I'm going to go to jail. So I'm not going to show up to work, which makes it even more important that we carefully look at what we do in policy and procedure, where we minimize the opportunity for error and fraud, so that we don't have to worry about that. So that was one of the drivers behind getting rid of the gap between early voting and election day. We took out a plethora of opportunities for errors to be made and for fraud to take place in doing that. And that's what, as we go forward and looking at maybe what we're going to do is cleaning up the voter roll and bringing it in-house where we have much better control of it, we take out a lot of opportunity there. So the concern about not having penalties, because I don't, as much as I would like to do that, I recognize the real problem. We'll run off the workers real quick. So as you go forward, keep that in mind, and every time you can see something that's being done that says maybe we can eliminate that step, or we can do this instead, that makes it less chance that there be an error or fraud in there, as just a part of the basic process of making it simpler and more secure.
Senator Hall, thank you for bringing up that more criminal penalties really aren't fixing the issues. I do believe that the audits can be more robust in that they can have follow through. Right now we do the audits, we get reports, but I think Christina can probably describe it better, but there's really no mechanism for fixing the issues that the audits find. So maybe that's, instead of penalties, something we can do that actually will address the issue.
Right. If we use the audit as a part of the process to make sure we got it right, and then where we didn't, or where there's something in there, look at the next cycle in there. What do we do to fix it? What went wrong? And is it something we can change, do it differently, or get rid of it and do it altogether? So.
I think you raise a good point on complexity. I think if you look back at our 2020 audit, you'll see the more complex the process, the more mistakes you make. And I know that sounds revolutionary, but it's common sense. You look at election day voting. You come in, you show an ID, you get your ballot, you put in the tabulator, you walk out. Not a lot of mistakes get made there. You start stretching it out for 14 days of early voting, things can get a little off. You talk about mail voting, and then you look at all the steps in mail voting and all the places that can have something go wrong, then you see a process that's bad. In provisional voting, you go a little even further because there's more decision-making in that, more people involved, and things get tough. So I think simplifying is a great goal.
Absolutely, but those things, provisional votings and the others, are smaller numbers in there. And if we look forward to making some other changes that we're looking at, but when we get to where we have a single in-person voting period, it's going to put us in a position of being able to have much tighter control over what happens. You run that zero tape on day one, and then when the polls close on election day, you immediately run a results tapes for the polling location, everything in there. And that gives you an anchor of what went into those machines right there before anybody gets a chance to take a memory out and take it someplace else to print it out or whatever it is. It's just push the button and get your printout right there, which is going to give us a much better, clean insight into what actually took place in the voting location, because we've got it boxed in from one end to the other. And then that tape witnessed, signed, and there becomes your anchor. And then you follow through with that so that when the county puts together the county's results, the judge from that polling location verifies that the county results are accurate for their polling location. And then when the state gets it and they put together the total results, before they publish that, they check back with the county and say, did we accurately put in what you think you sent to us? And the county then verifies it. So you have steps in there that are verified each step of the way, just to take care of the error or fraud in doing it. So I think we're on the path to doing that. It's just getting to that point where we have that single in-person voting period and then the other little changes to make that fit together. Yes, sir.
Thank you, Senator Hall. A couple more things, Ms. Atkins, and I think you and I think each of our panelists, and we're going to have a few more questions in a moment, but on this part of our discussion, we were talking about the list of maintenance and the frustrations, and we talked about some of the tools, and I'm going to ask a question I don't know the answer to. What happens about when the Secretary of State flags a concern? There's evidence this person on the X county voter rolls is not a citizen. You send that to the county doesn't adequately deal with it. You now, as of the last few years, since 2021, I guess, have the ability to withhold those funds. We heard more about those. Have you resorted to that? Have you been in a situation as the Secretary of State's office since that time withheld funds from a county because they were not doing their job, not following the law on maintenance of the list?
No, we have not withheld funds from any counties at this point. So what we have been able to do is we've been able to look at the data that's being sent to our counties, and for our counties that are part of our online counties, part of the team system, we can look to see if they've sent notices out. We can look to see what actions that county has taken. There are circumstances where they will review a match and say, no, I've got data in this, other data outside of the system that shows me we've already resolved the citizenship issue on this individual, for example. And they'll resolve the task, is what we call it. They'll resolve that issue. It may mean that they don't do anything, but they have reviewed it and taken action and looked at it. In some circumstances where we see that counties are maybe resolving a lot of tasks, but we're not seeing a lot of work going along with it, we'll contact the county and reach out to them to get more explanation as to what their process and procedure might be in that circumstance. And by and large, the times that we've had to do that, counties have good documentation, and they show us what actions they've taken, and they'll show us what determinations they've made, or they will provide proactively an explanation as to why they're pausing on acting on some data sets. For example, some of the citizenship data, we've had some counties that have told us that because of their ongoing research, they were waiting before they took action in some of these areas. A good example of that would be Harris County. Harris County, when we provided non-citizen data to them, they were already under the NVRA moratorium because they had a federal election for a congressional vacancy. So they have been keeping us in keeping in close contact with us about their efforts and their intention to act on this data at a later date. They've requested updated information from our office. So a county like that, they were legally prohibited from acting, but they have been keeping us informed and working with our office to ensure that we know what steps they're taking until such time that they can take additional actions. And so that's what we have found with a lot of those counties. I will say for our offline counties, I don't have that same level of insight. I don't know what actions they're taking. I don't know if they're sending notices out to voters. It's dependent on their communication with our office and how much information they provide us when we call and request that data. By and large, most of those counties have been very cooperative. Again, I'll use Harris as the example. I think they've been actually more communicative on some of these issues than some of our other offline counties, because I think there's a great deal of scrutiny on Harris County. But a lot of that is contingent on just what information they provide us. I don't always have insight into what they do.
Thank you. And so in those cases where your office sends the information to the county, is there a process for following up? If we don't hear from them within X days or weeks, there's a process for following up?
Yes, sir. So we'll monitor the tasks that they have.
For those who are within the team
For those who are within the system, we monitor that, and we can see what work they're doing. We have 25 people that support our team system. Every one of those individuals is assigned to select counties. They work with those counties, they know those counties, they know that county level data. And so they are astute at noticing patterns or noticing actions that their counties are taking. And then, of course, for those offline counties, we do, look to see if issues are ultimately being resolved, and we will contact them if we're not seeing movement in a certain area or if we're seeing no work being done, in a certain area. We do reach out to them proactively.
And so far, as a result of what you've just described to us, you've been able to resolve to your satisfaction every case?
Yes, sir. I would say so far when we contact a county and say, we're concerned because we're not seeing compliance with state law in this particular area, most counties very quickly work to resolve those issues or provide documentation showing us what they have done or have not done outside of the system. Especially our larger counties, I would say for those larger counties, those are the ones that are more quick to respond because withholding Chapter 19 funds for them is a more significant issue because they have more funding available.
Right.
That ability to withhold Chapter 19 funds has been a huge or a great tool in our toolbox for ensuring compliance.
Senator Hughes.
Thank you.
One of the things that would help legislatively, y'all were talking about the fundings and everything, is to give teams the ability to bring in notices from offline counties. They need to have that in their structure and need the funding so that they could manage that so she could see what offline counties are doing.
Makes sense to me, Ms. Atkins.
What I would say on that is that's less of a team limitation and more having to do with what the third-party vendors have and can. I mean, it's modifications to those systems to provide that data and to provide that level of detail. So it's not just about modifying team. Other vendors would have to make changes to their systems.
Are there statutory or SOS rules or other state regulations which put parameters on what the counties can do? Can they just say, I've got my own vendor and then that's it? Or do we put some requirements in place, some baseline for those who are without the team or not in the team system? They're their own vendor. Do we have any control over what services are offered?
No, sir.
We don't.
No, sir. No, the only
the Secretary of State does not.
The Secretary of State does not have any authority over those third-party vendors. We don't even review them for legal compliance. So I don't know the inner workings of that system. I don't know whether the systems are compliant with state law. I don't know what their security protocols are. The only thing that we have ever done is we make sure that the data transmission works, that they can send data to us, we can receive it, we can send data out to them, and that they can receive it, that file transmission. That's the only thing that we review. Because and the reason why is because we don't have statutory authority to do more, to create a more robust kind of certification program, if you will. And we don't have any enforcement authority over those third-party vendors. Those are local contracts.
Thank you. Senator Hall.
Just one last to follow up the comment, and all of what said Senator Perry, Senator Hinojosa, and all this discussion and the answers that you're given in there, we're trying to fix the unfixable here in this thing. We can continue to mess with it. We have got to step up and move to a single integrated system that takes all of this stuff out of it, depending on people doing this and doing that and following this rule and this and that and multiple vendors and multiple levels and so on. The state's too big, it's too much, and it's too important that we get it right in the voter roll. That's an incredibly important task that we have. And I truly believe that the only solution, we talk about fixing what you're talking about, it's like patching something with clay. It's going to fall off of it. It's an unfixable system. So I think we got to recognize we've got to set some money aside and do this. It will save us money and the benefits to come from it in the long run, to have a single system. And when I say us, I mean the counties and the state together. The getting it together will cost money. Right. But then we'll have something that is much more manageable, much more transparent in there. So I think that needs to be a fairly high priority to get our elections to where we need to have high confidence in them.
The concept of counties maintaining their own roles is something that Texas has had. We're all for local control until we're not. And this is a case where it's so important that needs to be done right and done. I agree with you. I think you're right.
Well, it's like the other stuff. The world has changed.
That's right.
It has changed. It's different, and we have tools today that we didn't have when we said we don't want that big mess up here. Let the counties handle it. We could pretend it wouldn't exist out there. But now that we have the tools that are out there, between what we know with AI and programming and data, and the ability to do that, it's a different world. Right. And it's right. Just like many of the other things we're going to have to make decisions on, is recognize that the Texas we're trying to keep glued together today is not the same Texas from 25 years ago.
That's right.
And it's the rest of the world.
That's right. I agree. Senator Hall, I think our discussion has prompted Ms. Dornoff to make a remark.
Yes.
Please go ahead. And remember, we're coming back, so we're wrapping this panel up. But go ahead, please.
Once again, play devil's advocate just at this single time, at this single moment where counties are having such problems with the team program and the things that are in place today. I just want to caution that, yes, if we could take care of some of the issues that we've heard today, if we could have a system that would put everybody in and could give accurate information that election officials could, because I would say right now, counties are probably pretty happy with the fact that they've been able to take their own data and correct some things that have happened currently.
No, thank you. We understand that it's always going to be a balance. We're going to have to strike, and we need your help as we do that. I've got one last question on this topic, and then after this, we're going to do just a slight rearrangement. We're going to bring in an extra chair, and we'll have another witness helping us on the next panel. And for the benefit of those paying attention, well, I'm sure you're all paying attention. For the benefit of those in the room and those watching, well, we do have another elections charge. We've covered a lot of it, and so the next one may not take this long. But I think we agree this is important stuff. We want to get it right. We don't want to cut it short. It's important to have these discussions. So, Ms. Atkins, a question I think I do know the answer to, but I want to make sure. Since 2021, with some major election overhaul work that was done in Senate Bill 1 and related legislation, my recollection is since that time, Texas has removed over 1 million names from our voter registration system for various reasons. Please verify that for me and break that down for us just in general where those numbers come from. What is the total and what were the reasons they were taken off?
So that's correct, sir. Because of our robust list maintenance program, there's a number of different things that impact the removal of individuals from our voter rolls. We do have list maintenance programs related to non-citizens, to felons, for mental incapacity individuals, that fall under these categories. They are sent notices before any kind of removal action is taken and given an opportunity to respond. We also have a very robust program with respect to deceased voters. In Texas, if you pass away within the state of Texas, we typically get that data 4 or 5 times from 4 or 5 different sources. That is the only category of list maintenance in which, when there is a strong match, meaning we're matching with social security number, with driver's license, first name, last name, date of birth, a combination of those records, it might result in an automatic cancellation. When there's weak matches where we don't have all those data points, we do send those out to the county, but again, there's an investigation process. And then some of the bigger categories are related to individuals that move within Texas and even out of state, and what we call the address confirmation process. If individuals move, if we have reason to believe that they've moved, those individuals are placed on suspense for 2 federal elections, so they stay on the voter rolls for a while. If they come in person and vote, they can be removed from suspense and placed in that active status. But this is a process dictated in federal law that after so many elections, those individuals that have been on suspense, their registrations will be canceled. And that does account for a large number of cancellations within the system. We are about to place updated numbers on our website for our cancellation trend reports, and so those should be posted in the next day or so, where folks can go back and look at historical data over the last 6 months, actually even going back years, to see kind of what those trends have been month to month. But it's typically in that cancellation process, the suspense cancellation process for individuals that have been on suspense due to questions on residency. That's typically where the largest bulk of cancellations occur.
Thank you. Thank you very much. Members, no other questions on this topic, nor we're going to have another crack at our witnesses. We're going to ask our panelists to step back just for a moment so we can do a slight furniture rearrangement. You don't have to go anywhere. You probably shouldn't. You just really need to. And we're going to move on to our second charge, election related. And of course, that's efficiency. Security and efficiency aren't the same thing. They're related. Y'all step back just for a minute so we can get the other chair in and move that down. You don't have to go far. Well, individually, you bet. We're going to start without you, but you okay. Go ahead. That's okay. And so they're obviously related. They're not the same thing. Election can be honest and still have problems, still falter, still have long lines, confusion on where to vote, technology that doesn't work or work as it was represented. And, of course, those lead to concerns about whether we can trust the results. And that's a problem for everyone, regardless of where we are on the political spectrum. We have to have elections that are secure and that work. That's what it's about. And so we're going to look at the systems that counties rely on, where the state can bring more consistency, how polling places are designated, and challenges in this process. And so that's what this next related charge will be about. And so we'll call back Christina Adkins, Jennifer Dornoff, Ed Johnson when he gets back is fine, Honorable Chuck DeVore, and Chad Ennis. So you'll notice there's an extra seat there. And Assemblyman DeVore has a commitment off campus a little bit later, so we're going to let him go first. Welcome back. Introduce yourself. Give us your testimony.
Thank you, Mr. Chairman and members. My name is Chuck DeVore. I'm the Chief National Initiatives Officer at the Texas Public Policy Foundation. And my remarks are probably best understood through the lens of being broadly in support of last session's SB 1209 by Mr. Chairman, a bill to consolidate elections in Texas. I have 10 points to make. My understanding is that I have a paper that may have been passed out or is available. These 10 points are the highlights from a recent research paper that I completed at the foundation about a month ago. The first point about uniform election dates or consolidating elections is that they do result in higher voter turnout. There is some savings in election administration costs. There is decreased likelihood of special interests dominating a low turnout election. And there is reduced election worker burnout, which I heard mentioned once or twice previously in the prior panel. To give some historical context, prior to the 1890s, most local elections were held ad hoc. They began to be consolidated in off-year elections because the technology of the day, it was very difficult to deal with long ballots using the basic paper ballots, right? It was physically difficult. So about 110 years ago, you started to see local elections separated from federal and state elections. The other thought was that if you separate them, it would reduce the partisan inclinations at local office, which at the time were thought to be injurious. Today, as many as 60,000 of America's roughly 90,000 school board members are elected in elections with turnout of only 10 to 15%, and that applies to Texas as well. There is an incentive for local governments to essentially choose their voters by having elections at odd times with low turnouts. You end up with people voting in an election that have the greatest stakes in that local political jurisdiction, which kind of warps the preferences of the broader electorate. By consolidating or not consolidating elections, pardon me, studies have shown, these aren't my studies, but other studies that I looked into and thought that they had good methodology. But when you don't consolidate elections, there is a higher chance of passing tax increases. Again, going back to the theory of low turnout elections resulting in essentially choosing your voters. There's a significantly increased chance of candidates endorsed by the teachers' unions winning elections, and there is higher pay and benefits for public employees at the local level. That's what happens when you don't consolidate, and again, that's what the data shows nationally. Here in Texas, a good example of the massive difference in turnout, in the general election in 2024, you had 61.2% turnout. In two recent local election cycles, you had between 4.9% and 17.8% turnout, and that would have been for your local May election. To put that into comparison with the 2024 general election turnout, that's 1/12 to 1/6 of the turnout happening at the local level. Point 7 is the cost. Now, here's where things get a little challenging because there are wide ranges of estimates of what it costs to run an election. There's studies all over the place giving information, looking at the hard costs. This would be, of course, for the printing of ballots and related documents, the salary of the poll workers and other temporary staff, the renting of polling places, and postage for informational materials and mail ballots. Of course, we don't do a lot of mail ballots here compared to other states like, let's say, California, where 75 to 85% of the ballots are going to be by mail. Here in Texas, other than the COVID year where it was around 10%, it's usually around 3 to 4%. But those are the main costs, and you note that not part of that list, of course, is election equipment, because election equipment is a capital cost, and it's going to be there no matter how many elections you have. But even so, the rough estimate based on the methodology that I looked at with multiple different studies is that by consolidating Texas elections, let's say just getting rid of the May and Saturday election, we could look at about a $29.5 million to $129 million savings which would accrue to local government. So it is a wide range. I apologize to the committee that I couldn't find better data that would narrow it down. But of course, there will be some cost savings. We know that for sure. There is, of course, an issue or concern about what's called voter roll-off or drop-off or undervoting. I heard this mentioned in the prior panel. I went ahead and looked at some data from my old home county in California, where I used to live 15 years ago. They have consolidated elections there. There's, I think, 6 states that have required election consolidation. And so what was interesting with that is that in a recent election in Orange County, and again, this is to test the proposition of roll-off, in the city of Santa Ana, which is the biggest city in Orange County, the lowest ballot item was 26 items deep on the ballot. Okay, so you had to wade through 26 choices before you got to Proposition FF in the city of Santa Ana. And the roll-off was only 7%. So if you go back to the top of the ballot and all the way down to the bottom, you only lost 7%. Now, again, variable depending on the position you were looking at. The greatest roll-off was in my old area of Irvine. It was for the Irvine Ranch Water District, District 4. It was 8 positions down, and it had a roll-off of 13.4%. So to give you an example, though, to go back and then to compare it to Texas's recent Saturday and May turnout, right? Those 2 positions, the one that was 26 items deep, the overall turnout was 54.5% for that Proposition FF, even though it was 26 positions deep. That would be roughly like 10 times greater than some of the typically low turnout elections that you see in Texas for these Saturday and May elections, where you have 5% of the people turning out. So 54.5%. For that Irvine Ranch Water District, where you had the biggest roll-off from the top, that was 8 positions down, they still had a turnout of 63.7%. Again, higher than Santa Ana, because generally in Irvine, people were more likely to vote than in Santa Ana. It's a area where you have a higher turnout typically. So then the last issue, many of you know Derek Ryan. He's a data analyst for elections. I've worked with him over the years, and I asked him a lot of questions about this issue. And there was a portion of our conversation that I recorded that I used with his permission in my report. Because I've heard concerns from members of the Texas Legislature about, well, gee, if we consolidate elections, won't it potentially cause some sort of a partisan advantage for one party or the other in the general election? And this was the question I asked Derek Ryan. And I'm going to quote now, this is in my report, from Derek Ryan. This is a conversation that occurred on December 11th of last year. He said, quote, "I am all for moving May elections to November, not for any partisan gain, but because I think it's easier for voters, it's cheaper for taxpayers, and lastly, from a data collection standpoint, it would make my life easier professionally. I think, if anything, some of the data refutes the argument that conservatives want to move the election to get better results." Now, what he's referring to there is I specifically asked him, in certain jurisdictions in Texas where local elections were in fact consolidated, because we leave it up to localities in Texas so far to determine when they're going to have their elections. And I asked him, test for me the proposition, looking at the voter turnout from a partisan standpoint, do you see any particular partisan advantage with elections in November in those jurisdictions that have consolidated? And he looked at the data in Texas's largest counties, and his answer was no, it's a wash. You'll see that in some jurisdictions it seems like there's just a little bit of a boost for Democrat voters, and in other jurisdictions it seems like just a little bit of a boost for Republican. So overall, he thought it was a wash professionally. And so with that, members, that is a summary of the highlights of this 10-page report that I developed a few months ago. Happy to take any questions subject to the committee's interest, and I do apologize. I have an eye doctor appointment that I have to get off to in about 15 minutes, so.
Thank you for your testimony. Thanks for being here. And we'll go while we're down here. Mr. Johnson, you want to go next on this one? Do you have opening remarks or just here for questions on the next charge?
I'll just be here for questions on this. Let him get
Very
to my
good.
doctor.
All right. Mr. Ennis, you're recognized.
Yeah, just a few more things on consolidating elections. We've talked about it earlier, and Chuck's paper is fantastic. So if you really want the full primer on this, definitely read his paper. But I think another thing to note is that this is a growing trend.
Pull that a little closer, Chad.
This is a growing trend we're seeing across the country, consolidating elections. States are realizing that they're doing way too many. Just in 2026, this year, which this body wasn't even in session, 31 states introduced 74 bills on election day alignment, up from 7 and 10 in 2025. So you can see where it's getting a lot more attention. Since 2022, Arkansas, Louisiana, New York, and West Virginia have consolidated, and 3 more have empowered locals to do it as well. And even 2 more states, Indiana and Virginia, have launched feasibility studies on how they can do that in their election systems. So I think this puts Texas, as usual, as a leader in getting this done, and we should get it done in the next session.
Thanks, Mr. Ennis. So on the efficiency charge and what we haven't covered yet, Ms. Donoff, you're recognized. Go introduce yourself, give us your testimony.
Thank you. I'm Jennifer Doinoff. I'm the Hayes County Election Administrator and also the Legislative Chair for Texas Association of County Election Officials. And the 2 topics that I had to address in the efficiency charge were the implementation and things that we were meeting with Senator Hall's office for the implementation of Senate Bill 2753, and then also some issues and challenges we saw in this last primary election that we think we have some remedies that can help with efficiency moving forward. So on that, we'll talk about the primary election issue first, and just say when it comes to selecting polling locations and preparing for the primary, counties need to have the time that they need to prepare as much as possible. Currently, there's no deadline in the law for political parties and counties to contract to run an election, and that caused problems in this last primary in Dallas County and Williamson County, and even in Hayes County and some other counties where contracting went on for quite some time. We saw in those counties some what was defined as chaos in the primary election because the counties didn't have time to adequately prepare for the changes in the election process that were being requested. And so we feel like a deadline for these contracts would help that. And then we also think some other things that could help in a primary situation when one party wants to run an election one way and the other party wants to run their election another way is to have that freedom to do so, particularly when it comes to countywide polling. Right now, both parties have to agree to do that. And if we could find a way that we weren't restricting the other party to do that same thing, that might help eliminate some of that. And I know there's some concern that maybe that would cause more confusion, but I would say in some counties where they were consolidating precincts in one party and combining in another and then had different parties going to the same polling location, that caused what I believe probably may have been a little more confusion. So I think that probably wouldn't be the case if the other party could still hold their election in countywide polling, for instance, if they wanted to. That's the biggest thing, and we would like to continue to work with this committee on that, on some ideas of that, so that we can help maybe make sure that those instances don't happen again. And then on 2753, we've been working closely with Senator Hall's office on some things that we think can help make the implementation of that bill easier for us when we do decide to do that. I don't think we're there yet because I do think there's going to be some things that we need to address in the legislature, and we're working on some scheduling things, and we're working on some other processes that are still left over in the election code that we think can help make that process a lot easier. And I also think Christine is going to talk a little bit about that as well, the steering committee and some of the work that they're doing on that as well. And I'm going to cut this short because I know we've been here a long time and we've already talked about most of it.
Thanks, Ms. Dornoff. Ms. Atkins, welcome back. Introduce yourself. Give us your testimony on the efficiency.
Thank you. Thank you, Mr. Chairman. My name is Christina Adkins. I'm the Director of Elections for the Texas Secretary of State's office. I will also try to keep my remarks brief and limited to 3 different things I'm going to bring up to ensure that we can move forward with some great questions and some discussion in these areas. The first thing that I wanted to mention, and this relates a little bit to what Ms. Doynoff was talking about with efficiencies in the primary election, but it's kind of a different perspective or a different angle. And this relates to the type of voting system equipment that's being used in polling places today. And I say that it relates to the primary because this is where we saw this issue coming up the most and becoming or we're seeing a greater awareness of the type of equipment that's being used. There is a movement right now where folks are pushing their election offices and their counties to move to voter-marked ballots. These are ballots where the voter is using a pen or a pencil to mark the voter or mark their selection, and then that's being placed into a scanner, in contrast to the widely used ballot marking devices that have been in use all over the country and very prominently here in Texas. We have recently had a number of counties move to these voter-marked ballots, and the way they're able to do this in a large jurisdiction where you have lots of polling places and lots of precincts is to provide what we call a ballot-on-demand system. So it's a ballot printer, essentially, in a polling location that can print a custom ballot for that voter, so that they're not having to pre-print ballots ahead of time and keep track of the different ballot stock and run the risk of running out of ballots for their voters. And so these ballot-on-demand systems are gaining in popularity and they're gaining in widespread use across Texas. We have a number of counties that have been using these for years. It was typically concentrated with one vendor who had a very easy-to-use solution in the polling location. Denton County and McLennan County are examples of counties that have been using these ballot-on-demand systems for a long time. We recently had 3 more counties move over to the ballot-on-demand system, and it was widely used in all 3 cases for the primary election, and this is where we saw a little bit more of a challenge. I think it's important to note that ballot-on-demand systems, many people assume they're part of a certified voting system, but they're not, because they are simply a printer that is printing up a ballot. Our federal law, our Election Assistance Commission, and the voluntary voting system guidelines that they promulgate, for which Texas adheres to, doesn't include ballot printers. It doesn't include these on-demand systems, so they're not tested and certified as part of the federal certification process. Sometimes they're brought in as a peripheral device for testing, but they are not part of that federal certification process. In Texas law, they're not part of the definition of a voting system, and so they can't be part of the state certification process. So we don't have a lot of regulatory authority over these ballot printers that are used in polling locations. And from what we were hearing from our counties that were out there, while we have had some of these systems demoed for us, because we don't have regulatory authority over these ballot printers, it's hard for us to provide guidance to the manufacturers on how their systems comply with state law. We can notify them about what we know about, but we can't thoroughly test them the way we do certified systems. And so if there's going to be a strong desire to move to this model within Texas, that may be something that we think about, is giving a little bit more regulatory authority to the state so that we can test them and certify them the way we do other types of polling place equipment. Though they may not be part of the counting and casting of ballots, it is printing up a ballot, and it is used in conjunction with the other equipment in the polling location. And being able to ensure legal compliance there, I think, would help from an efficiency standpoint, as one of the things that we heard from some of our counties utilizing this new technology is that it may not have been as efficient as they hoped it would be, and they did have some struggles in some of those locations with that transition. And so if we can help in that area, we want to be able to provide some additional guidance to vendors to ensure better compliance with the law. The other thing I would like to discuss from an efficiency standpoint is to speak a little bit more about what Ms. Stoynoff mentioned, and that's Senate Bill 2753, which was Senator Hall's bill that creates or eliminates the gap between early voting and Election Day and creates a single unified early voting period. Our office was charged with implementing 2753 and making the determination on when the state is ready to begin this process. This is a new way of doing things, and there really aren't any other jurisdictions out there that do things exactly the way this bill is moving Texas, in the direction that for which it's moving Texas. Understanding that a new scheme, a new way of conducting voting is going to have its challenges, and also understanding that it's the county election officials that do the heavy lifting here. They're the ones that conduct the elections. They're the ones that do the work. They're the experts on the process and procedure related to administering an election. Our office convened a steering committee to assist us with making decisions about implementation and education on Senate Bill 2753. Our steering committee consists of county election officers. We have county judges on the on the steering committee, and we also have some local representatives, because it's not just counties that are impacted by this, but our cities and schools and water districts will also have to make this change in the way they conduct their election. Steering committee has met several times over the fall. We've had several meetings here in the spring to discuss the best course for moving forward with this bill. It became very clear in our discussions that from an educational perspective, counties were struggling to wrap their heads around what this change would look like for their individual counties, because again, it is a new way of doing things. And so with the support of our steering committee, we, the Secretary of State's office, put together a workshop. And we have been workshopping Senate Bill 2753 with counties all across the state. To date, we have workshopped a total of 54 counties over the course of the spring. Some of these are one-on-one, us going to a county office, sitting down and working with them to go over their unique scenarios in their counties so that they can look at what this is going to do for their county from a resource and cost perspective and from a training and education perspective. We are also in the middle of doing regional trainings this summer. We have 15 regional trainings scheduled across the state, and this workshop for 2753 is a major component to this regional training. By the time we get to the end of July, we will have workshopped Senate Bill 2753 with about 3/4 of the state, if not more, where these are counties that we are working with one-on-one with our election trainers and our election attorneys, sitting down, educating them on the bill, and then filling out, we've created a workbook and a series of worksheets that help with cost calculations that they can use to help them make projections as to what they're going to need for the implementation of this bill. I will say, by and large, the participation has been wonderful from our counties. They are very eager to get into this process, to better understand how this is going to impact them. We're hearing various things from our counties on the impacts. Many of our smaller counties and smaller jurisdictions are telling us that with their projections, this change in law could result in a cost savings to them. If there are some additional tweaks or modifications made to the process itself to account for some of those increased costs that come from having your polling locations open later. We have some counties that are concerned from a cost perspective that there may be an increase in cost because of the length of the early voting period and the length of hours for which the polls have to be open, that without having that transition period between early voting and Election Day, there may be a fiscal impact to the county. I think the largest thing that we're hearing from our counties, though, is that they're at the end of their budget cycle right now, and implementation without some modifications, a few tweaks that I think we have discovered in the course of educating our counties on this bill would make the implementation much smoother, is going to be difficult for our counties to do in the short term. I will say, by and large, though, our counties are coming to the table prepared and ready to work through these issues, coming with productive suggestions, and they want to get this right. They want to make sure that when we change the scheme for how we're conducting in-person voting, that it's done as seamlessly as possible, and that it's done in a way that is accessible to voters and accessible to their community. And so we have had some feedback from the counties on some tweaks that we could make to the law that would make this a more seamless implementation. A couple of things, and I think Ms. Stoynoff had mentioned some of these, and I'll elaborate just a little bit more. The scheme right now allows for very long hours, 12-hour days, and in some of our counties, that may not be necessary to have that many hours of voting for small counties that don't have high populations and maybe don't have the resources to staff those polling locations. And so this was discussed earlier, but the idea of providing a little bit more flexibility under the law, maybe with some minimums and maximums, some thresholds for which counties can make some selections that are right to customize it for their county needs. Couple of other things that we're hearing about, the mandatory hours on the weekends, Saturday, Sunday, Monday, again, for particularly our smaller jurisdictions that don't have the kind of staffing that larger entities have. That's going to be challenging for them. And I think challenging for them more so in the short term, just because of where we are in the budget cycle. And so I know they have been visiting with Senator Hall, and a lot of these issues have been communicated to the senator as well. And then two other areas where we've identified some potential tweaks that might make this process more seamless. Right now in Texas, we have a requirement for our early voting ballot boxes to have 2 locks on them. And this 2-lock requirement, transitioning from early voting to election day, so everything up until election day, is actually a little bit challenging because it's our law enforcement that typically holds that second key. And so being able to get out there to get those keys to those jurisdictions from law enforcement to be able to successfully transfer chain of custody in our larger jurisdictions is going to be very difficult to do in that short time frame. Some counties have proposed some solutions, perhaps changing who the custodian of that second key is to give authority for that to go back to the county office at some point so that the county can possess that key and get that back out to those jurisdictions, because you need to have both keys on election day to close out your polling location. And so it's a practical step. And so there are some discussions there, and the counties have come to the table with some great ideas on how to resolve that. And then finally, one of the issues that's been brought to our attention from the perspective of the county, but also our political parties, is the appointment of election workers. There are different appointment procedures for early voting versus election day. And since we're talking about a uniform early voting period, we may need to make some modifications in how we're appointing workers to make sure there's consistency across the county and how the workers are being assigned to locations and how the county is determining what party serves as the presiding judge, for example, in a given location, as the law for early voting and election day prescribe different procedures. And so our parties are also telling us that some small tweaks in these areas would make a more seamless transition into this new way of doing things. And I will say one other thing that we have mentioned already, but I do want to highlight is there has been a little bit of discussion on ballot privacy and ballot secrecy. One of the things that we have looked at and talked to our counties about is whether we believe that this combined early voting period will help improve ballot privacy. And by and large, our counties are telling us that by combining those buckets, early voting and election day, and grouping our voters together or reporting them as one number, can help eliminate some of the ballot privacy issues that we've seen. In that it doesn't allow for such small categories of voters. It's a bigger pool to aggregate. There are still a few little areas that we have to think about from a ballot privacy perspective. We still need to think about our provisional votes. Those voters are always going to be a smaller category, or precincts where we may only have 1 or 2 voters that vote, which goes back to one of the issues that we talked about, Senator Hinojosa, and the way we draw our precincts. There's some additional things that we can do there to help ballot privacy. And then, as Ms. Dwaynoff mentioned, fail-safe voting, where somebody moves within a county, they have to get a custom ballot. There are a few little things there that we need to think about addressing that, but by and large, this transition to the single voting period could have a positive impact on protecting ballot privacy.
Chairman, I didn't realize the ballot marking was on this session. Could I?
We did security, now we're doing efficiency, so there's going to be a lot of questions, but this is our last election panel. So if you need to say something now, or you can do it in response to a question.
Can I make just a quick comment on that issue?
Up to you.
So in the ballot marking devices or hand marked ballots, I think right now I'm with Ed Johnson with the Harris County Ballot Security. I think we have the best of both worlds. We have a official paper ballot that's coming out of a electronic marking device, that now you have 2 records. You have an electronic device and you have official paper ballot, which helps you in auditing elections come up to make sure that everything was correct. in Harris County, I don't believe that we could do the hand-marked paper ballots. That logistically becomes very, very difficult. So you have it's going to be 1.6, let's just go 1.5 million votes. And taking a ballot by mail, because that's what you're talking about, is basically producing a ballot by mail ballot for people to go hand mark. Right now in Harris County, with over 100 races, that's 4 tabloid pages that is sent to a voter. That's about the equivalent of at least 10 8.5 by 11 pages that would be printed. So now you're talking 15 million pieces of paper for an election. It gets to be very, very difficult to manage keeping all those pages together in someone's ballot to count and recount them or to scan them. Harris County had extreme difficulties when the verifiable paper trail first came out, the paper ballot, because it was on 2 pages. And there was a huge number of second pages that were lost and voters were disenfranchised. So we are fearful of the hand-marked paper ballots being so large in large counties where you have a huge number of multiple pages of keeping them together. And then just the logistics, if you waited till election night to start processing these or to scan these, I estimated you would need 2,000 scanners with about 6,000 additional employees to get it done within a 24-hour period.
Well, if I could, Mr. Chairman.
Actually, Senator Hall is
Okay.
is going to be is the first one up after this panel, and then we'll come to you next.
That's fine.
So in large counties, there are huge logistic problems with the hand-marked paper ballot. Once again, I go back, we now in our system, we have a paper ballot, and it is a summary that's shown to you. That's real easy to count and track, and it's on a single page, which makes logistics, a whole lot easier. The other thing is you will never be able to, I don't see that you would ever be able to get rid of the electronic marking device due to ADA requirements. We're required to have those to help blind people or people with disabilities. So you're always going to have that equipment in a polling location to assist the handicap. So I don't see us ever being able to get away from having that. And then you're set up with 2 different voting systems in a polling location, which get to be more complicated as you go. So in large counties, this would be a very difficult thing to do.
Okay.
And thank you. Senator Hall, you're recognized. You have the panel.
Oh, okay. Well, I'll back up a little bit here. So do you not have the ballot marking devices where they do it electronically, then it prints out a piece of paper?
That's currently what the state law.
So what's the difference in the number of pieces of paper that printed out from the machine and those that are hand marked?
So a hand marked ballot would have to be, you would have to give the voter the whole ballot. What's currently coming out of the tabulator or the electronic marked is just a list of who you voted for. It does not have all the positions. It does not have all the other candidates on the ballot. So by the time you add the titles and the multiple candidates onto a page, plus space to mark them.
Okay, so we're back to putting convenience ahead of security in there, and that's one of the reasons we talked about flexibility, because I know we'll always have counties who don't want to do things. So they will take the approach, they refuse to try to figure out how to make it work. They want to not. So we're working on being flexible to allow some counties who just refuse to try to do things a better way to be able to do that. So I think we'll probably have that solution. The question I wanted to ask about the ballot secrecy issue, because I think would we all agree that ballot secrecy is more important than convenience in voting? That keeping the ballots secret, that we don't come up with a convenient solution. That is because a number of people have recommended, well, we just redact on the ballots. Redaction is not, to me, is not solving the secrecy problem, because somebody saw the ballot to be able to do that.
That's correct. I would say that ballot secrecy is paramount to the election process and to voter confidence in the process.
Yes, okay. And the issue about the printers, what certification process do we go through for the companies that print the ballots?
We don't have a formal certification. We have a notification process. They notify us that they are printing ballots for a given election, and it's only certain elections.
Okay, so we haven't lost anything there because we don't certify those printers.
That's correct.
They
Yes,
print them. So we got printers here that aren't certified. But I'm
correct.
And I'm not arguing maybe we should have in there, but some process. But I hope we wouldn't come up with something so complicated it kind of makes it difficult, because our certification processes are difficult enough as it is.
Yes, sir.
But one of the other questions I had, I don't think we addressed, unless it was addressed while I was out for a moment or two, the issue of closed primaries. Have we discussed that? I would like to hear what your thoughts on it's been brought up, talked about. We're talking about, consolidating elections, and this is an issue that's been a lot of people very passionate about over there. I'm almost as passionate as those that like hand counting. But I'd like to hear what each of you have to say about closed primaries. Christina, once you start it off.
Yes, Senator. So I had a conversation with Secretary Nelson because we anticipated this question and this topic coming up for discussion today in the hearing. And I want to make it very clear. Secretary Nelson has never taken a position for or against closed primaries. There is some pending litigation on this matter. And I think it's important to note that this litigation, the Secretary of State's office and Secretary Nelson, she's a constitutional officer. And she, as you all know, served in the Senate for many years and has been on that side, has done the legislative work, has been part of the folks that determine and set policy and set laws here within the state of Texas. And the litigation that's there is about the role of the Secretary of State's office and the role of the legislature. Should an executive branch agency be making policy and making rules that are typically under the purview of the legislature? When we talk about closing the primaries, people assume that it's a switch that you flip, that it's an easy thing to do, that all we have to do is make the decision to close them, or the parties tell us that they're closing their primary, and it's an easy thing to implement. And there are probably 10 or 12 different policy decisions that have to be made on how a primary is closed. For example, if one of our parties says they want to close the primary, does that close it for both parties? If we're being asked to capture affiliation in our state database, does this mean we capture affiliation for both primary holding parties? Do we capture affiliation for the parties that elect their nominees through the convention process? What about new parties? When does affiliation begin? What is the timeline for which somebody has to affiliate before they can participate in a closed primary? And these are very big policy decisions. And the litigation that's there is about who should be making those decisions. And I think Secretary Nelson, has never stated a position one way or another on the closed primary issue, but feels it's very important that her role is to defend the laws that the legislature has put into place.
And I understand that completely. And I'm not looking for a position. You guys are somewhat experts in the area of the election process. And my feeling here is we're here today to talk about the process, the procedures, the good points and the bad points without advocating.
Yes, sir.
I'm not asking for advocating, just raising the question, do you see a great big red flag on something that says this, it sounds really good, but when we get down to this, it's going to be almost impossible to do it? Or the other end, hey, that's going to solve a lot of problems and make it a lot easier. I'm just looking for general, from a procedure standpoint, things you feel good or bad against it. That's all.
Yes, sir. And I would say the list that I started to articulate of some of these big policy decisions, I think it depends on how the primary is closed. How those decisions are made and what the scheme is that's put into place will determine how easy it is to implement or not. I would also say, if there is an intention that registration, that affiliation be captured with registration and that the state maintain that listing of who is affiliated with what party, We have to understand that there's 3 state agencies that are going to be impacted by this. It's not just the Secretary of State's office, but the Department of Information Resources, who handles online updates to registrations. Their system would have to be modified, and the Department of Public Safety, DPS, because 85% of our registrations come to us from DPS. And so again, going back to whether it's complicated or easy to implement is going to depend on what those policy calls are, because there could be a fiscal impact to the state as multiple agencies would have to change the systems that are in place for registration to accommodate capturing affiliation in a state system.
Okay. Jennifer?
And just because we have to say it, we also would not take a position on this. We run elections.
No, I'm not looking for a position. I'm just, thoughts. I'm just looking.
Yeah.
Do you see a big stumbling block, or do you say that it would fix something, or what do you think would be the big issues?
Either.
Because the authority would come as legislation, and then we work our way down. So the legislature would have to take this move. I don't see it happening any other way. Some people obviously do think it can happen that way. I don't think it is. But say the legislature did, we're looking for what do we need to address so we get it right when we put it out there, if we do.
So from the perspective of an election official, I would say for us, it's not fixing anything. It's also we're used to laws changing and adapting and doing those things. I think the biggest thing that we have to keep in mind when it comes to these changes is educating our public and ensuring that the public understands the changes. And that sometimes sounds very easy, but sometimes it doesn't happen quickly. So I think for us, it would be educating the public of the changes.
Okay. Chad?
I mean, I think if the legislature, which I'm assuming you guys will consider this heavily next session, and I think they're spot on. There's so many issues to consider and to do in a thoughtful way. If you look at open or closed primaries just across the country, there's a lot of flavors of open and closed primaries. A closed primary can mean that you've had to have been registered in a certain party for a certain amount of time. Some closed primaries are you can come the day of and change your affiliation. So whatever policies y'all decide are important when you switch to that, if you do, they really need to be hashed out to give these folks the guidance so they can actually implement it. And I mean, there are just a lot of things to consider, especially things like how often or when, what's my time frame for changing my party affiliation? What if I decide I've changed teams and want to go to the other side? So I think there's a lot to work through. I fully have faith in this body to do it. But there's a lot to think about.
Oh, absolutely. That's why I asked the question. It's not so we get beyond it's a good idea or it's a bad idea. I'd rather have a logical argument one way or the other on it, on why it's a good idea. It has more good points than it has bad points, or oh my gosh, it's so bad, you can't say anything good about it in there. So we make an informed decision on it. I don't want to blow this off just based on this group's for it and this group's against it. I want to have a logical, foundation for it one way or the other. Ed?
Yes. To me, it looks like the problem trying to fix going to a closed primary is the other party trying to manipulate one party's outcome in an election by switching parties that they typically would have voted for or are affiliated with. To have that effective, you're going to have the date that you commit to what party you are pretty far out, so that they can't make this last-minute decision to switch to try to monkey other parties. The downside I really see to this is then you're going to be the I guess middle ground group, the independent group that really is not that politically active. You will be cutting them out of the primary process, which I think is probably more hurtful than the potential of a party trying to manipulate another party's race. Because we're trying, I hope the group here is trying to encourage people to vote and participate in the process.
Okay, thank you. Okay, thank you, Mr. Chairman.
And thank you, Senator Hall. Senator Betancourt, you're recognized.
Thank you, Mr. Chairman. And I want to make a point about scalability, because we'll talk about Harris County and we'll talk about Loving County, then we'll go to the state. I think one of the issues that we have to look at on any change is scalability, because we go from Loving County with, last time I checked, there were 64 residents, to Harris County having 4.5 million and 2.669 million people on the voter roll, or at least that's what last number. If I'm wrong, Christina, correct me. So I think that having a discussion about what can be done and what not done is also what needs to happen, Senator Hall, because I looked at Ed's, I just did the math here on your numbers that you're talking about. I remember that Briscoe cane runoff, and I remember that everybody stood by the 20 scanners and about 750 ballots could go through, because it wasn't a full-blown situation where people were checkboxing, but there was still multiple pages. And I'm pretty sure that took most of the night to do 15,000 scans. So your upgrade to having 2,000 scanners is rational based upon the history. And we just need to understand that that's a rational thought of what it takes to do something like that. Now, and I want to tie that, so whenever we're looking at these type of changes, and I think, Senator Hall, you've talked about having some flexibility with different size counties, et cetera, but there are some fundamental physics that can't change, which is how long it takes to do scans, how fast it can be done, how many people it takes. You got to make sure you haven't mixed the ballots up. There's all sorts of things that go through this, because I remember that runoff was very contested. And again, back to the point I made earlier, Christina especially. So let's go from Loving County, Harris County, but let's look at the whole state now. So I missed a little bit of the discussion, even though Chuck DeVore handed me his papers on the way out, so I had a chance to read. When we're looking at all of this, we have to make sure we understand that as big as Texas is, if we have a vendor, which in this case, you've got one, this is like the third vendor for, this is, right. So Civics, or it could be IBM, it could be whatever, anybody, okay? They're going to have the resources to do all of that. So if we decide that we're going to make every county go on the line, okay, then we're going to have a resource capable, upsized vendor to be able to do it. Because no matter what happens is those support services, those questions, those comparing those lists, because to get to a voter roll with integrity, and you were right, because the SAVE Act, the American Help Program says the state has the priority on the list and not the locals. But if we have locals that are having to do workarounds to get their list ready, then all that effort, regardless of who's wrong, who's right, up or down, in and out, somebody has to make it work at the end. And what gets measured gets fixed. And that's why I'm strongly suggesting, Christina, that whatever can be done with these software changes, and there has to be version control, they have to be showing that transparency, because the more we rely on one entity, in this case the state, to do it all, then we have to have an upsized, robust ability to be able to do it. And that's always the cycle in elections. Because I don't think there's anywhere else in the country that goes from 64 people to 4.5 million people to 31 million people. And we're supposed to have uniform election laws in the entire state of Texas. So I just wanted to make that point home, because scalability is real. It's a real problem.
Okay.
Thank you, Mr. Chairman.
Mr. Chair.
And thank you, Senator Betancourt. Senator Hall, you're recognized.
No, I appreciate that, because I think we agree all the way around on it. And in the past, and what I'm trying to do is trying to get a little bit of a sea change in the thinking process, that Texas is big and different. And because all of our laws always are like uniform, all across the board, exactly the same everywhere. And I think it's not necessarily fair in the situation that it is actually fair to everyone, where you have a set of laws that treats a Harris County the same as you treat a Loving County and vice versa in there, because they truly are different. And then I think it's incumbent upon us to to recognize that we can better serve the people, having flexibility in what we say want done in order to meet the outcome, a common outcome, and that's an honest, accurate election. And so doing that, we may have steps that Harris County takes that are somewhat different than what Loving County would take, and maybe some of them in between, that gets us to that objective, because that's where it is. It's out there in that the accuracy and honesty of the end of the election is what we're after, and we have to maybe create a pathway for each county to adapt to get there a little bit different. So as we look at changes that are going to be made to adapt to the new system, it may include what we've talked about here today: uniform election dates, the possibility of closed primaries, just a possibility, but those kinds of things, and recognize the ballot secrecy, precinct voting, hand-marked paper ballots, machines, the combination of them to allow some flexibility that this part in between fits the bigger counties and smaller counties, so we get to that end objective across the board. Because if we don't, we're going to have something that matches over here for the big counties that doesn't work for the little counties, and vice versa. And I think we've changed it. So yes. I've said it a couple of times. I want to make sure it's kind of a different, to me, it's a different approach for the legislature that always looks at one size fits all, no matter what it is, period, bang, down the hammer goes. So thank you, Mr. Chairman.
Thank you, Senator Hall. Senator Bettencourt.
And I would just add, Senator Hall, that I think the one element that we're missing in all this discussion is when we're making these type of major election changes. I remember that we purposely ran in parallel for up to multiple years to make sure that we had a primary system and a backup system, because the problem is once you lose a voter registration roll or lose a tax roll, it's very difficult to recover it, okay? And the idea of having some of these programs piloted is really important into the field, because some of the technology we're discussing today doesn't even exist. Some of it does, okay? And we still have a paper ballot at the end of the day with the system we have right now. But then what do we do with it? Do we hand count it? Do we recount it? Do we automatically recount it? Do we pay for it? There's all these deals. But I think importantly, we should be looking at trying to do testing first on some scale before we launch. Because one of the problems, and Christine, I'm going to use the civic situation because I think it's perfect. You were ready to launch some of that. You had gotten the software to a point, and then we ran into unforeseen problems. People going bankrupt, and then trying to literally ask the state for tens of millions of dollars to stay in business. I see one person laughing. The person that got asked didn't laugh. Okay. Now, and that presupposes that the question was even valid. It wasn't, but you had to make tremendous accommodations and use the manpower and the resource that you had available in that vendor to solve that problem. And then redistricting came along. You had to use the same set of real. And now we're in catch-up mode in the summer. I'm not trying to be negative about it. It's just a fact, okay? So I just want to point out that whatever we do, we have to look at scalability, but we also should be looking at testing some of these systems. And we used to be very good at benchmark testing systems from all over the country. Now, I will leave you with this. ESS actually failed once or twice, if I remember correctly, because of, or companies like that failed because they weren't counting the votes correctly. And there was one classic example where a county judge saw the same ballot run through 3,000 times, right, Mr. Johnson?
That's correct.
And she wouldn't vote for it. And so, shock and horror for some of the Republicanos in the audience, that was Lena Hidalgo, because she didn't want to vote for a system that couldn't separate 3,000 ballots of the same thing. So we always have to be open to this and scalability. But the resources, Mr. Chairman, are almost now the critical path because of everything we're trying to do. This is an enormous project to bring everybody online to the right level that they want to be, much less add all the online counties. There is no state this big that's doing it. Okay. And if anybody wants to claim California's done it, well, you know, at least we can count votes in less than a week after the election.
Ms. Atkins, go ahead, please.
I would be remiss if I just didn't say one thing, Senator. It was Dominion voting that failed multiple exams, not ESNS.
And
Right, sorry,
oh,
right.
no, thank you. And on Dominion voting,
But it
just
was ENSS that, on the other example, that was actually true. Okay, so,
Correct.
there's been a lot of discussion about those Dominion voting machines and litigation. I think everybody here knows, but I want to ask you again: are Dominion voting machines certified for use in Texas by the Secretary of State?
No, sir, they are not. We do not have any Dominion equipment in the field in Texas, in any county or any local jurisdiction.
Thank you. I knew that, but I want to make sure we all heard that again. Thank you for that.
good counselor always asks questions that he knows.
Hopefully, thank you, Mr. Chairman. And on those machines, thank you. Thank you for that. As we close this out and we think about the methods whereby we vote in Texas, many of us in the election integrity work are fairly new to the process. And electronic voting, voting machines, those terms all kind of have different uses. But let's talk about DREs, direct recording electronic voting machines. I hope the answer to this question I'm going to ask is no. But are any of our counties still using those machines? And for those listening, those of us who like paper, it hasn't been that long ago that most voters in Texas voted on voting machines, not what we have today. You voted in this electronic machine, and there was no paper record ever. It was all internal. And, of course, you talked about that transition, Mr. Johnston. We fought hard to get paper back up to move away from that. We did that with carrot and with stick. We told counties we'll pay for you to get better machines. We won't certify the old ones. And I don't know the answer to this one. I'm violating the rules Senator Betancourt just reminded me of. Do we have any counties in Texas that are still using those machines where it's all where you vote on that machine that records your vote and there's no paper? Is anybody still using those?
For this November election, all of our Texas counties will have moved away from DREs. They will all be on paper-based systems for their primary method of voting.
Okay.
There is a small carve-out in the law for people to use DREs for curbside voting.
Okay.
And there's only a couple of jurisdictions that do that.
Okay.
So by and large, we are no longer utilizing DREs in Texas as a primary way of voting.
Okay. After the hanging chads and the Florida stuff in 2004, some are old enough to remember that, the federal government in its infinite wisdom, and yes, I'm being sarcastic, they passed the Help America Vote Act, and they forced states to lurch over into that direct recording electronic voting machines, which nobody trusts. However, for those folks with special needs, curbside voting, things like that, there does have to be a special accommodation for them. It sounds like most of our counties have gone to a ballot marking device or something else, but you said in a few places we still have those DREs for those limited uses, folks with special needs who can't vote in the mainstream process. Is that right?
That's correct. Very, very limited, but by and large, all of our counties are utilizing paper-based systems.
Good. Thank you. Senator, go ahead.
You brought up one last. Okay, that being the case, on the ballots that are being printed out with the names on them, if you read, are all of the machines that are now going to read that ballot, are they optical character readers, which are actually reading the written, typed out name on the ballot, or are they reading a embedded code or QR code that tells them what that is?
Not all of our counties are utilizing a system that has that optical character recognition or reading the words.
Right.
We still have counties in Texas that utilize systems that have a barcode on there where the vote is embedded in the barcode. It has a printout with the name. The name is also there. And so in a hand count, it's the name that's counted. That's the ballot of record. But yes, there are still systems in Texas in use that have the barcode with the vote embedded on them.
Okay. And I suggest that's something we absolutely need to eliminate. You only catch it if there's a hand count, the accuracy. Thank you.
Senator Hall, that's right, and thank you for that. And you said we still have some, so we're moving toward the optical scanner that reads candidate X that the voter voted for. I'm hearing you correctly.
One of our vendors, we have 2 certified vendors in Texas. One of them exclusively uses some form of optical character recognition where it's reading the text. The other vendor that we have in Texas, those systems have been in place for over 10 years now with the barcodes. They are moving that direction as well. We have seen the new generation of the next generation of voting devices where they have moved away from the barcodes and now it's reading the character on there. And so we are anxiously awaiting that process to complete the federal certification process so we can review it for certification in Texas.
Good. And that's good because from a practical standpoint, there's no difference between that one that's reading the barcode and a DRE.
The only difference is for a recount or an audit, we do have
for a recount.
record,
That's
so,
all there
yeah,
is, and that's
right.
only when it becomes effective.
That's
and
right.
you would never even look for it
Yeah.
unless you had some reason
That's right.
to do a hand count to do a recount in there.
That's right. That's right.
What's that?
OCR is the right. Optical character recognition.
Oh, absolutely. No, that's if you've got to do that, if you just have to do that, then it has to be. But allowing it to be embedded in a barcode or QR code, we have got to eliminate that. Period.
Chairman.
Mr. Johnson, go ahead.
On the same subject, but a little change. One of the things that I hear all the time is when you have a race that's close and you want to do a recount. That recount is still being paid for by one of the candidates. The candidate that's wants the recount that's in second place closely. This gets to be extremely expensive to do. Especially after you've gone through a heavy campaign season and spend all your money doing campaign work. Now you got to pay for a whole staff to come in and count paper recounts. And it's to validate that the system is working correctly. I would love to see y'all look at possibly within certain limits funding some of these recounts so that people have more confidence. Because I know a lot of candidates that get close and they say, I don't have the money to do that. I can't do that recount. And it just goes away.
So that if a race is within whatever margin it might be within, if it's close, then the government, the taxpayers who put the system in place would be responsible for the recount. It wouldn't be the burden of the losing candidate. Is that what you're talking about?
That's what I'm saying, yes.
Kind of like a verification vote in the House, Senator Perry. Those are within 6, I think. There is what's the law on that today, Ms. Atkins, please?
If there's a tie vote, there's an automatic recount.
Okay.
That's at no cost to the candidates. But I think what Mr. Johnson's referring to is when we have a very, very small threshold separating those votes, that losing candidate still has to incur those costs. Unless, of course, it changes the outcome. And if the recount changes the outcome, then that losing candidate does not have to pay the cost. The county or the jurisdiction holding the election would pay the cost of the recount.
So then as a practical matter, the losing candidate request the recount, do they then have to pay something?
They have to pay a deposit.
They get their money back.
They would get their money back if the outcome changes.
Okay. Mr. Ennis.
I think one more thing that maybe this committee should look at in the next session is what Florida has started to do. So Florida has ballot marking devices, I believe, in counts, just like Texas does it. But they also have a second process where they have an independent machine count. There are certain companies that will come in and OCR the ballots and look at them that way with a fresh look. So it's not ES&S verifying ES&S or Hart verifying Hart. It's you do the count and then you come back and you run them through a second machine that's independent of the other. That's become really popular in Florida. They love it. It doesn't slow results down. It's something we should look at that they do.
Mr. Chairman.
Well, I think Senator Hinojosa had his light on, then I'll come back. Go ahead.
Thank you, Mr. Chairman. And thank you for bringing that up, Mr. Johnson. Actually, I went through all that and had to pay money on my first campaign for a very small margin. And the other issue I think that we need to look at with regard to recounts is when you go to recount, you certainly start to see discrepancies in things that could potentially impact the outcome of the election. But apparently, under our current law, you cannot contest the validity of the ballot if you see something discrepant. You can only recount, making sure that the count was accurate. So whether all you're doing is recounting incorrect ballots, again, so really there's very rare circumstances where a recount actually changes the outcome of a recount. Now, then it would have to go to a contested election. And there is no real framework. And a matter of fact, the amount of time to contest an election when you would have to gather the resources, try to build evidence, and do all those kinds of things really should be looked at as well on how contested elections work versus recounts. That is something I think that is worth looking into. So I appreciate you bringing that up, and I can provide a lot of information regarding that. Ma'am, just real quick, you had mentioned the one question that kind of was triggered when you talked about curbside voting. You said very, very few places still do that. How many exactly?
I should have numbers on that. I can look into back in the office so I can get you an answer, but I think that it's only maybe 3 or 4 counties that are.
Is one in my district? Because I still see that happening. So I'm just wondering.
It's possible that one might be in your district, sir.
And
I'll
so-
double check that.
Hang on. If we can clarify,
Yeah.
curbside voting happens everywhere for folks who have special needs.
Yes, sir. That's
But
correct.
So that was
curbside
going to be
voting-
my follow-up question
But
here.
curbside voting using a DRE, is that the question?
Yes,
I'm
yes, sir.
sorry.
I'm
Go ahead.
sorry.
I was getting confused. Go ahead.
That's okay, and I appreciate you, Mr. Chairman, for clarifying. But I guess my other point to that is, what are the qualifications for somebody who's eligible for curbside voting, and how strictly enforced is that? Probably a better way to phrase that.
So curbside voting is something that must be available at every polling location across the state. What I was referring to with the question you asked before was the use of DREs for curbside voting. Very few counties do that. But curbside voting must be available at every polling location. The law says that people that are eligible to vote curbside are individuals that, I'm not going to quote it exactly right, but are unable to enter the polling place without the likelihood of injuring or impacting their health, or some kind of creating harm in some way to their health. And I'm paraphrasing there, just to warn you. And so when a person appears to curbside vote, the polling place workers go out to the polling location. Now, as a result of some recent changes in legislation in 2025, curbside voters have to sign an affidavit indicating that they meet those qualifications or are otherwise requesting some kind of accommodation to be able to curbside vote. But
Okay, that was my follow-up question. So it's basically an affidavit. They're just saying, hey, I can't, it'd be hard for me to come into. And I don't want to diminish that. There's obviously a good utilization to help people who are disabled or can't otherwise get into the voting center. But I have seen it in certain areas where there are longer lines in the curbside,
Yes, sir.
as opposed to, actual walking into the center to do the vote. And I'm just wondering what the criteria or what enforcement mechanisms and checking. But at this point, it's simple
It's an
affidavit.
It's an affidavit that the voter signs, and other than that, there's no other mechanism in place for validating whether somebody meets the definition required under the law. I think there's some ADA considerations with asking too many questions or putting conditions upon voters that need to curbside. But I will say there is that affidavit now, so there are records on the numbers of curbside voters that voted a given location and who those individuals are. I will also add that there was also another change in the law in recent years that requires if people are curbside voting and somebody's driving 7 or more curbside voters to a polling location, there's another form that individual has to complete as well. So we are tracking larger numbers like that, though I will say we have not had many of those forms filed with the state.
Okay, very good. Thank you.
And Senator, it's a tremendous point. Back in 2021, and going into the 2021 session, we heard a lot of sworn testimony about abuses. Somebody pulls up with a vehicle with a lot of people, says, hey, we need curbside voting, and then they just pass the machine around. No poll watchers, not sure if the folks are even voting their own ballots. So there were definitely abuses, and so we're always looking for those things. Boy, as you said, we want to help folks that need help, and of course everyone has the right to vote, and if they can't make it into the polling place, we're going to accommodate them, but we can do it and still make it secure and still protect their privacy and the security of their vote too. So thank you for flagging that, because it's been a real challenge, and as Ms. Adkins said, we've tweaked those laws the last few sessions, but whenever there are abuses, that needs to be addressed.
Thank you. Thank you, Mr. Chairman.
Senator Perry, you're
Mr.
right.
Chair, I'll be quick. First of all, if you're not careful, if you don't leave, the loser has to pay for the recount. You incentivize stall and dragging things out just for the sake of stall, dragging things out with no intent of overturning the election. So I like the idea you got to pay for it if you ask for it, because I don't want to incentivize stalling out the election results for whatever reason those people may have, because you can't, there's no bottom to depravity of mankind. Second, closed polling. You know, I would like to think it's to the candidate, quality of the candidate that gets people to the polls. And to be perfectly frank, I can say that's been a challenge on both sides of the aisle. So I don't want to lock me out of being able to vote for the quality of a candidate. So I haven't switched my votes, but you know, my party tests my limits sometimes. So just saying, and as we continue on the path we're on, we're going to get it down where if 5% is all that's showing up, it's just 1 million votes probably that you got to even manage. So it's going to make your job a lot easier. There's bigger issues here, is my point. And we got to be really careful to try to do something good that really just makes it that much more of a less important priority for people to want to get out and go vote. And I don't blame them, but I'm disappointed, and our republic depends on participation. And the smaller their participation, the more extreme the outcomes. And right now, the tail's wagging the dog, and both parties, all parties, and politicians alike have a vested role in why that apathy exists. So if we really want real elections that produce really quality people that really have a servant's heart, we need to look inward before we have to worry about a system that catches the byproduct of that issue. So just saying, before I jump off here on cliffs trying to fix voter apathy, we need to look the reason we're having voter apathy to begin with. But as we tweak it, we may actually just create another demon to go slay.
Senator Perry, thank you. If there are no more questions, Senators, I thank Ms. Adkins, Ms. Dornoff again, Mr. Ennis, Mr. Johnson, Assemblyman DeVore, who's off campus. Thank you for your testimony. You are excused. We have one remaining charge we'll be taking up, and so as you're making your way from the room, please keep your voices down so that we can continue the proceedings. Our charge to protect the unborn. We're asked to study the threat of abortion-inducing drugs shipped unlawfully into Texas, monitor how the protections that were enacted last year are working, and recommend what more can be done. You'll recall the testimony before this committee in multiple hearings, and also the discussions, the debates on the Senate floor and also in the media. The abortion-inducing drugs, the abortion pill regimen, historically required multiple in-person doctor visits, required prescription by a physician, and the drugs had to be administered in the doctor's office. Now, even when all those conditions are met, it still resulted in the death of the little unborn baby. But in those cases, there were protections for the moms. Under current law, with changes made by multiple federal administrations, there are little to no protections. And so basically we see Big Pharma and others taking advantage of women in Texas, harming moms, harming babies, and needed to be held accountable. That's what House Bill 7 was about, and that's what our charge is about, to see how that implementation is going and what else we can be doing going forward. Again, we recognize that there is a little unborn baby whose life needs to be protected, and there's a mom who needs to be loved and respected and protected, and we can do both. That's always our goal, to protect both of them, to love both of them. And so that's what our next panel will be about. And so Chair calls John Seago. We'll have two panels on this invited testimony. Then we'll open up public testimony for all of the charges we've had today. So Dr. John Seago, Ashley Leonards, Chelsea Yeoman. And then we'll have one more panel after this. Y'all just have a seat wherever you like. Thank you. Dr. Segal, introduce yourself, give us your testimony.
Great. Thank you, Chairman Hughes, members of the committee. Thank you all for the invitation. My name is Dr. John Segal. I serve as the president for Texas Right to Life. Texas Right to Life is proud to partner with you senators in researching, monitoring, and leading the campaign against the deadly threat of abortion pills for about 4 years now. We appreciate Chairman Hughes and and Lieutenant Governor Patrick for prioritizing this issue the last year in the Senate. The Senate passed multiple versions of the Woman and Child Protection Act and until the House was finally able to get their act together and pass the bill as House Bill 7 in September. And so we have to also thank Governor Abbott for adding this to the special session last year. As you'll hear later through the next panel, the reality is that abortion pills are still taking Texas lives and hurting women. Over 19,000 orders, at least 19,000 orders of abortion pills are coming into Texas each year. And just like with other critical goals that y'all work on, like fighting the evils of human trafficking and sexual assault, domestic violence, the legislature must continue to explore what is next in protecting Texans here in this topic and creating a culture that values each individual human and opposes these efforts to dehumanize the small, the weak, and the voiceless. You'll hear the medical side, personal side in this fight, but I want to give you an update on some lawsuits as well as some concrete recommendations. House Bill 7 authorized private lawsuits to be filed, and opponents of House Bill 7 said that there was going to be an avalanche of frivolous and abusive lawsuits. Thankfully, that has not been the case, that those have not come out. However, there have been some lawsuits filed, and we expect more this year to be filed since the law didn't go into effect until December. There's really one prominent case, Rodriguez versus Coita, that has fully utilized what y'all put in House Bill 7, but again, we expect more this year. There's kind of three categories of lawsuits. There's criminal enforcement efforts from Louisiana and South Dakota. Those are still pending. There are some civil enforcement efforts from the Attorney General. There's three major cases. The most significant one is the Texas Attorney General brought a civil case against Aid Access. Aid Access is the global syndicate. It's a company that's in Austria and the Netherlands that is kind of working on a global network of distributors of abortion pills all over the world. And that lawsuit from our Attorney General's office actually goes after not only Aid Access, but the U.S. physicians that are partnering with Aid Access and cooperating with openly violating Texas law by mailing abortion pills into the state after selling them online. And so that is just from January of this year, that lawsuit was filed. And so we're still waiting to see the outcome of that. But that's the civil enforcement efforts. There are other relevant lawsuits targeting the FDA and FDA safety guidelines. There's a Louisiana case and then a case that Texas is involved in, trying to reinstate safety procedures and safety rules for the distribution of abortion pills. The Texas case is actually saying that the abortion pill should have never been put on the market in the first place. And so it is a little bit more ambitious. However, there is a lot that we need to do as a state that we can continue to fight this evil. There were several things in Senate Bill 2880 that y'all passed in several versions that the Senate passed that were taken out in the final version. I wanted to just draw your attention. Expanding the Attorney General's authority to investigate and bring lawsuits against those promoting and committing abortions is still unfinished business. There were a lot of discussions about enhanced criminal penalties for abortion crimes. For example, classifying paying for an abortion or abortion advertising as aiding and abetting, which would be illegal, as well as penalizing the destruction of evidence related to illegal abortion. And that's what we're seeing other states are doing, is they're helping activists break Texas law, and then they're covering it up, and they're saying that we're not going to help Texas investigate these violations. There is a higher accountability that we need to discuss for those that are making and maintaining internet platforms, websites, and apps that are facilitating the advertising of abortion pill sales. And that was something that was in the bill that we've had a debate about. We want to go back to that conversation. Is a lot of this trafficking, a lot of this illegal activity is happening online, and in other policy areas, y'all have explored more tools to cut that out, including holding financial institutions accountable. If they're financial service providers, crowdfunding platforms, or payment processors that are helping these illegal websites run. Y'all have worked in other spaces and policy on holding those individuals accountable for being a part of this illegal activity. And so we encourage that conversation to continue. So after Texas has banned abortions, we see that those that are promoting abortion are still adopting new tactics. They're promoting, they're selling, they're committing abortions, and it's causing tens of thousands of Texans to die every year. It's also hurting tens of thousands of women, and so we appreciate you prioritizing this, Chairman, and exploring the options. We have a lot of concrete recommendations, as you'll hear, that you heard from me and you'll hear from some of us today, but we appreciate y'all working on this in the interim so that we can continue to stand for life and protect life from this new attack that we're seeing from abortion pills coming into the state. Thank you.
Thank you, Dr. Segal. Ms. Landers, welcome. Introduce yourself and give us your testimony.
Thank you so much. Chairman Senator Hughes and members of the committee, my name is Ashley Leonards, and I serve as the Legislative Director for Texas Right to Life, the oldest and largest pro-life statewide organization that advocates for protecting innocent human life from fertilization to natural death. Through y'all's leadership and recent pro-life measures you have helped pass, we've been able to combat abortion largely in our state, saving thousands of lives and taking us from nearly 80,000 abortions every year in 2008 to 56,000 in 2022, then roughly about 20,000 today. This is due to laws like the Sonogram Law, the Texas Heartbeat Act, and the recent Women and Child Protection Act. Still, the truth is the abortion industry has adapted, and we have yet to sufficiently counter them. Today, abortion pills have become the primary method of ending preborn life and now account for roughly 60% of the 1.13 million abortions in our nation. Abortion pills typically involve two drugs, mifepristone, which starves the preborn baby, and misoprostol, which expels the dead baby. Right now, these drugs are being shipped into Texas with little to no medical oversight and harming women and killing children. To understand this battle more, it helps to understand how these drugs were first introduced. Abortion pills were originally precariously approved by the Clinton FDA. However, at that time, they at least had some safeguards for women's health, limited to the earliest 7 weeks in pregnancy, requiring 3 in-person visits, and only being prescribed by a physician. These reflected basic truths, that these drugs carry serious risks not only, of course, to the children they aim to kill, but also to women who take them. Under the Obama administration, the abortion pill regulations were loosened again. The use was allowed to be expanded to up to 10 weeks into pregnancy. Complication reporting was limited to that of only death. The in-person oversight was reduced to a single visit, and non-physicians were allowed to prescribe these drugs. Then, even that remaining in-person visit safeguard was removed by the Biden administration, usurping pro-life laws like those of Texas and largely achieving the abortion industry's agenda of making abortion available in every zip code. Beyond this, abortion providers have gone even further by instructing women to report abortion complications as natural miscarriages, meaning that complications are misclassified and making accurate tracking extremely difficult, further insulating the abortion providers from accountability and using women that they claim to help as human shields. Without an in-person visit, there is no way to confirm how far along a woman is in pregnancy or identify underlying health risks. Beyond the medical risk, mail order abortion pills also open the door to abuse. They have been used by coercive and abusive partners to end the child's life without the pregnant woman's knowledge or consent. And this is happening here in Texas, unfortunately. In Harris County, Mason Herring secretly administered abortion pills to his pregnant wife without her knowledge. Thankfully, their child survived, but others have not been so lucky. In Montgomery County, John Demeter was indicted for administering abortion drugs without consent, resulting in the death of his preborn child and serious harm to the mother. In Tarrant County, Justin Banta was arrested for allegedly placing abortion pills in his girlfriend's drink. In Nueces County, Christopher Cooprider is currently being sued for allegedly obtaining abortion pills online and attempting to poison his pregnant partner against her will. These cases are only a fraction of what is occurring. When these drugs can be ordered online with minimal verification, it creates an environment where abuse can flourish. Texas, under your leadership, thank you, has made great strides, but there is more that can be done. We can strengthen enforcement by expanding the Attorney General's authority to act when prosecutors decline to. We can address the online networks that are knowingly facilitating the advertising of these drugs. We can ensure taxpayer-funded institutions are not enabling access to abortion pills, deny tax benefits to entities that support and fund abortion travel, hold medical professionals accountable when they violate the law. Texas has led the nation in protecting life, but the abortion industry has escalated its efforts. We must be just as determined to save life as they are to end it. Texas Right to Life stands ready to work with you in the 90th session to meet this challenge. Thank you for your time and consideration and for advocating constantly to protect innocent human life in our state. Thank you.
Thank you, Ms. Leonard. Gentlemen, welcome. Introduce yourself. Give us your testimony.
Yes, well, thank you, Chairman Hughes and committee members, for the opportunity to speak to you today. I am Chelsea Yeoman, Senior Counsel with Alliance Defending Freedom, a large nonprofit law firm dedicated to advocating for religious liberty rights, parental rights, First Amendment rights, and of course, the right to life. But I do want to begin today with a heartfelt appreciation for Texas and this body's willingness to stand as a shield and a stalwart for children in the womb. They cannot express their appreciation today, but bills like this one, HB 7, the Women and Children Protection Act, as well as the Heartbeat Act, were legal feats for human rights. And so I want to thank you for that. HB 7 works, as my colleague on the panel so eloquently said, through civil private causes of action. There were a lot of reasons for that. We are talking about illicit drug distribution. There's a chain of possession over each and every drug. While we're talking with very large amounts of statistics, each drug starts with a drug manufacturer. It is made by two manufacturers in the United States. Gen X Pro is the first manufacturer, and Gen BioPro, I should say, is the first manufacturer. Those drugs are then shipped, apparently ad nauseum around the country to a whole host of not just hospitals, not just physicians, not just pharmacies, but random organizations who are distributing these drugs through the mail. They host websites where a woman can log on, order the drug, and within about 48 hours have them appear on her doorstep. Speaking with pregnancy resource centers, particularly in Texas, we are seeing women who've had as many as 22 drugs shipped in perfume bottles to their front doorsteps. This is creating major complications, not just for the death of the children, but for the 1 in 25 women who will end up in the emergency room, according to the FDA, because of these drugs. 22 states, after the overturn of Roe, worked in lockstep to enable this illicit distribution chain. And they did that by passing SHIELD laws, 22 states plus the District of Columbia. These SHIELD laws essentially say that any citizen in that state can ship, mail, provide abortions and never be held legally accountable, either through criminal prosecution, which the state of Texas has attempted to do, or through civil liability. And that includes for malpractice. So if a woman hemorrhages because she was past the 7-week recommended deadline, she has no legal recourse under the law until HB 7 provided that. And so I want to thank you because HB 7 is the first bill in the country designed to break the distribution chain and hold at every point, or almost every juncture, I should say, accountable civilly for the harm they cause, the damage they cause for unborn children and their mothers both. HB 7 has become the nation's first vehicle to test the shield laws, which have remained untested in federal court. As we mentioned, Paxton versus Carpenter is the case where the state of Texas did obtain a judgment against Dr. Maggie Carpenter out of New York City, but the county clerk in New York refused to domesticate that order because she was protected by the shield law. Other cases have been thrown out because of shield laws, but HB 7 and the Rodriguez case is the first case that is continuing. It's moving forward and going to hopefully be able to test these shield laws to allow Texas to once again be able to protect children within state lines. I want to be very frank with you that there are two gaps that are being taken advantage of in that distribution chain. The first is the drug manufacturers are not held liable under HB 7 for the drugs that they enter into the marketplace, do not keep track of, allow to be distributed into the state, and harm women and kill children. There is zero liability across state lines right now for that. We at ADF would recommend strict liability for a drug that's intended and designed for homicide to be held accountable for that death. The second gap in the distribution chain is at the website level. As I mentioned, there's a website right now. This one, I put in the state of Texas, 17 results for 17 providers where the drugs can be ordered. 7 are clinics, or say they are. 7 are just websites that sell pills. That's what it says, websites that sell pills. We don't know who they are. We don't know if they're practitioners, nurses, doctors, but they distribute pills. Those websites can and should be taken down by internet service providers who should have a third-party duty to take down that website. And this can be done legally because Section 230 of federal law only exempts internet service providers to the extent that they are not publishers of the information. But we can create a third-party duty upon them to remove illicit websites, including things like child pornography. There should be a responsibility and a duty of care for their services being utilized for criminal conduct. So those are the two primary focuses we would recommend. And then the third and final would be, again, equipping our Attorney General, hopefully after the shield laws are overcome, to really and truly go after these groups. Technically, they could be charged with RICO violations. Organized crime under the state of Texas is 3 or more actors acting complicitly to run afoul of Texas law. And so if the Attorney General were given jurisdiction in addition to his jurisdiction, for instance, over human trafficking, over RICO violations of this sort, I think that would be a really great place to start. But I do recognize that this body has done so much to continue to be a shield. There was a very recent study that came out this month that indicates it's self-reported by abortion providers, which means it's probably under-inclusive, 4,000 drugs a month that are being self-reported into the state of Texas. So it is an exorbitantly high number, but we do not grow weary in doing good because in due time we will reap the harvest. And I commend you for the good this body has already done. And I welcome your questions.
Gentlemen, thank you for your testimony. And Senators, any questions for anybody on this panel as we move through this charge? Dr. Segal, you and Ms. Gilma both mentioned that Rodriguez case. What is the procedural posture of that case? Where is it right now? To the extent the most recent reports you have as far as the moving through the courts.
Yep. So one of the crazy things about the shield laws is it gives individuals who are breaking Texas law standing to countersue. And so that is the fight right now, is that there is a attempt to countersue those that are trying to bring accountability for the doctor in California that is actually being sued for breaking Texas law, sending those pills into Texas. And so, it is it's a long case. It's back and forth over several things. There's multiple plaintiffs. It's not just the woman, it's not just the individual man who brought it, but there's other women that are joined the plaintiffs as well. So it's unfortunately with that countersuit, it kind of slowed down the original case, and they're dealing with the countersuit right now.
At the risk of blending nautical and legal terms, House Bill 7 also provides some countermeasures against those who would countersue, as I recall. Is that right?
Yeah, I mean that was one of the crazy things that whenever there's actually the shield laws are being actually examined for their constitutionality for the radical kind of policy that they are. I think that will be highlighted as these countersuits are very extreme, and that's what y'all tried to address in Texas to protect those. If we're seeking justice for Texans and we're trying to go after people that are openly breaking our law, hurting women, you should be shielded from their attacks just because you brought this to their attention of the court. So that's definitely something that we addressed in House Bill 7, but still we're seeing some spots that need to be covered, and we need to address this. This is an ongoing kind of legal area.
I'll ask the entire panel, what approaches do we see other states taking? Obviously, under current law, Texas is doing everything that can be done. We believe that House Bill 7 is a aggressive step forward. Thank you for that. If you have a sense, obviously we're concerned about Texas, but we love little babies everywhere, and those moms. Do we see other states taking a crack at this, or anybody else got anything that's working?
Whether it's working is to be determined. There are several states that have taken steps. The state of Tennessee and Oklahoma both filed similar variants, and I believe Arkansas of HB 7, which is great. Again, the legal difficulty, we're threading this needle of needing it to not be enjoined through a pre-enforcement action, which means there shouldn't be, government enforcement from the outset. And so states have taken variations on that, but have not really successfully seen a slow in drugs.
Yeah, and I'll just say no. I mean, Texas is leading out. The only thing that we've seen is some states have talked about the drug itself, the first part of the abortion pill that kills the baby. How do we mark that? And do we put more kind of safeguards around how that is distributed, how that is handled, how that is recorded when it is used? But that that's kind of already a few steps behind where y'all have gone with House Bill 7.
Right. That makes sense. So many of the... Ms. Leonard, did you have something? Go ahead, please.
Sorry, I was just going to say, this really is a new frontier. So like I had mentioned, the FDA standards have changed very recently. So after you passed the Texas Heartbeat Act, thank you for your leadership on that as well, Chairman Hughes. But that was whenever the Biden administration removed the in-person visit requirement. So we are really dealing with a whole new political animal than what we had before. So y'all have been amazing with the Women and Child Protection Act, really leading the way and trying to combat the new abortion threats that we're dealing with, where previously we'd had a legal side of the abortion industry, and because the Heartbeat Act and the Women and Child Protection Act and the pre-Roe v. Wade statutes, we were able to shut them down, but now we still need to find those innovative tools to actually deal with the illegal side of the abortion industry that's become the widespread as it is today here in Texas.
If I could add a few creative methods, I sat for your earlier panels regarding how corporate enterprises are really engaging more politically than they used to. Walgreens, CVS, mainstream pharmacies nationwide distribute these drugs in blue states in high volume, and there hasn't really been a pushback against that. But I would hope that in order to conduct business in a state like Texas, there could be some pressure applied to those pharmacies or insurance companies who cover abortion.
Thank you. Thank you for that. I know we're going to, on the next panel, talk about pregnancy centers and some of the help that's done for moms. Just remind us often, and we don't want to forget or let anyone forget, remind us what's going on in terms of what we used to call the Alternatives to Abortion Act. It's renamed now because we're not just pro-birth, we're pro-life, right? Walk us briefly through what Texas is doing to help those moms, help the little babies after they are born. Tell us about that.
Yes, so Texas led the way in 2005. Many states fund abortion, and Texas actually started funding life resources for moms and babies through pregnancy centers, qualified pregnancy centers, adoption agencies, and maternity homes. Texas has substantially taken action to actually stand with mothers. This past session, y'all passed funding for the Thriving Texas Families Program, which does fund these qualified centers with $200 million for this year and next year, which is extremely impressive. It's more than what the rest of the country combined actually sends towards pregnancy centers. So thank you so much, because that's where we see it's not only legally stopping the abortion, but we also want to make sure that we're standing with moms, that we're not just exporting abortion across the country or abandoning her in that moment of crisis. We understand that pregnancy can be very difficult, raising children can be very difficult, and one of the biggest factors that pushes a woman towards abortion is not having support. So encouraging family units, but also helping stand with her. So thank you for your action in making sure that Texas doesn't only fight abortion, but we actually stand with moms and babies as well. So thank you.
Thank you each for your testimony. Senators, is there any questions for these witnesses? Thanks for what you're doing. Thanks for your testimony. You're excused.
Mr. Chairman, I don't have
Dean.
a question, but I would like to commend the second witness, Miss Ashley, is it Leonards?
Yes, sir. Yes.
So far, you have been the only witness who honored the 5-minute time limit.
Oh.
All right.
The record has been 26 minutes.
I was trying.
Thank you, Dean. Thank you, Dean. We have one more panel of invited testimony on this charge, and we'll be prepared for public testimony. Call Dr. William Lyle. Call Sarah Huff. Call Jana Pinson. And one housekeeping matter before we get started. Ms. Pinson, we're glad everybody's here. Before you leave, we're going to need you to get you to fill out a card just so we have a record of you in the system. Obviously, we know you're here because we invited you, but want to make sure we get this from you before you leave, okay?
Thank you. Is there a gift certificate with it?
Well, we're working on that. And thank you each. Dr. Lyle, you're recognized. Introduce yourself. Give us your testimony.
Thank you very much, Chairman Hughes and the remainder of the committee members. My name is Dr. William Lyle. I practice obstetrics and gynecology. I'm board certified. I've delivered over 5,000 babies, and I've been an instructor with both the University of Florida and the Florida State OBGYN residency program, and it's an honor to be here today. We have a wonderful partnership between Florida and the state of Texas. We recently transferred one of our patients who was diagnosed with a condition called twin-twin transfusion syndrome, where she had identical twins that were sharing one placenta, but just like a lot of siblings, they weren't sharing nutrition equally. One was real big and one was teeny tiny. We transferred mom and both of her babies over to Texas Children's Hospital. They evaluated, confirmed the diagnosis. They then took them to the operating room. They took a camera called a fetoscope. They went through the skin of the mom's abdomen, went through the wall of the uterus, took the camera into the womb with both of the babies. They evaluated the vasculature of the placenta. They then deployed a laser and they cauterized the blood vessels and literally divided the placenta in two, essentially saying, this is your side of the placenta, this is your side of the placenta. Knock it off, play nice. They watched them for 10 days. They sent them back to us. We followed them for the rest of the pregnancy. They might have started off like this. By the time I deliver them via C-section, they were almost the same weight. But we are now performing open heart surgery for babies on the inside of the womb, where babies have their own IV and anesthesiologist, and tumors are removed from the baby's beating hearts. We're doing vascular brain surgery, spina bifida corrective surgeries in its third generation. It's amazing how we are diagnosing, treating, and curing the babies in the womb. All patients have rights. We're doing blood transfusions to babies on the inside of the womb who are being attacked by the mother's immune system because they have often different blood types. We're even correcting heart arrhythmias for babies while they are inside the womb, saving their lives. But we have a tragedy which is happening. There's a danger to both women and moms, and that, of course, is the abortion pill. We've heard how it is being shipped right in here to Texas, and yes, it will kill a baby 98% of the time, up to 12 weeks gestation. but it's also dangerous for moms as well. There was a study that was released April 28th of last year, a study of 865,000 women looking at their insurance data, women who had been prescribed the abortion pill, and they followed them for 45 days to see if they had any complications. And what they found was of these women who had taken the abortion pill as directed, over 40,000 of those women had to go to an emergency room for a complication directly related to the abortion. There were over 28,000 women who experienced hemorrhage. There were 24,000 women who had to have an additional surgery, such as a D&C, removing leftover pieces of placenta or even leftover fetal tissue. There were 12,000 women who had to be treated for either infection or sepsis, and there were 3,000 women who had to be treated for an ectopic or a tubal pregnancy. An ectopic or tubal pregnancy is still the #1 pregnancy-related cause of death of women in the first trimester of pregnancy. When a woman is pregnant, 1 to 2% of the time, that pregnancy will be ectopic or tubal. My daughter just recently had an ectopic pregnancy. When a woman receives a abortion pill mail order and does not receive an ultrasound, 1 to 2% of the time, that will be an ectopic pregnancy, and the abortion pill will not be a treatment for them. Women are being harmed, but not only are women being harmed at a rate which is 10.93% as opposed to the 0.5% that we were told when the abortion pill was originally approved, 22 times more dangerous, but the abortion pill is being used as a weapon as well. In Illinois, where abortion is completely legal, a man was just sentenced to 7 years in prison for using the abortion pill to kill a woman's baby. In Louisiana, charges are placed against a man who used the abortion pill against his own 17-year-old daughter to try to kill her baby inside of her womb. She started having bleeding, cramping, and pain, was rushed to the emergency room, was taken to labor and delivery. She had an emergency C-section performed of a 23-week baby that was 1 pound. The baby is still alive, but he has been charged with attempted feticide and also assault on the mom. Women in Texas deserve better. You've done such amazing things to protect the lives of moms and of women, and also to the babies on the inside. They deserve better. We do still not have either a urine or a blood pregnancy test to test for the presence of the abortion pill. When I was in Corpus Christi this year, there was a woman who was slipped the abortion pill in a cup of hot chocolate by the father of the baby. She then started having bleeding, cramping, and pain, and she passed an 8-week fetus with fingers, toes, and eyes looking at her. They were unable to prosecute because of lack of evidence, even though they had a credit card bill. But there is still no commercially available test to test for the presence of the metabolites of mifepristone, which would be something we could definitely use, because if a woman has a miscarriage, you really can't tell the difference between a spontaneous miscarriage versus having the baby killed by somebody else. All patients have rights. Patients not born in the United States have rights, and patients not born in the United States yet have rights. God bless Texas, and thank you for your time.
Doctor, thank you for your testimony. We may have questions for you in a few minutes. Thank you for being here. So, welcome. Introduce yourself and give us your testimony.
Hello, my name is Sarah Huff. I was born and raised in Brazil. Today, I'm proud to call Texas my home. At a time, I was a feminist and liberal activist who publicly advocated for abortion rights. And at 22 years old, I found myself pregnant and alone. My abortion provider told me she trained with Planned Parenthood in the United States. She told me the pills came from the U.S. and the American women use them all the time. Well, in Latin America, we grow up believing that if something comes from the United States, it can be trusted. America meant safe. America meant advanced. So I made up my mind. She told me I will feel something like menstrual cramps and repeatedly told me to not look in the toilet. Everything was a lie. For hours, I sat on the toilet alone in pain that felt like labor, because it was labor. Contractions one after another without stopping. I was bleeding heavily, shaking and terrified. And then something larger passed from my body. I looked down. It was not a blob of cells. It was my daughter. In the same moment I recognized her, I regretted it completely. I wanted to put her back, to continue her life. But the only option left was flush the toilet. The suffering was not over. For 10 days, I bled heavily. Then one night, I woke up in the middle of the night in excruciating pain. My insides were burning. My mouth was dry. The tip of my fingers had turned blue. There was a smell of rot coming from inside my own body. I was sweating, vomiting, and I knew I was going to die. I reached out to my feminist friends and my abortion provider, but no one responded. No one came. I was left to die until a Christian neighbor broke down my door and got me to a hospital. I had developed sepsis. I lost one of my fallopian tubes, weeks in the ICU, and blood transfusions. And for months afterward, horrible nightmares of pieces of a baby coming out of my body. I could hear babies crying in rooms that were completely empty. I became an alcoholic. I was terrified of being alone with my own pain, so I ran from one relationship to the next. I was destroyed physically and emotionally. What I was experiencing had a name, post-abortion syndrome, but my provider never warned me, not about the physical risks, not about the psychological ones. No one told me this was possible. And to this day, feminists insist it doesn't exist. But I am standing here as proof that it does. But God gave me a second chance, and I got pregnant again. And this time, I said yes to life. My second chance now is called Hector, and he's 10 years old today. But when I found myself vulnerable again, broke, alone, and holding a newborn, it was not my feminist friends or the feminist movement that showed up. It was the pro-life community. The very people I had been taught to hate brought me diapers, food, clothing, paid my rent, and funded my college tuition. They saw in me a woman worth fighting for. They helped me find my footing in politics. And in 2019, after a lot of hard working, I was appointed by former President Bolsonaro as Brazil's national coordinator of maternity policies. I'm here today because I cannot understand how a procedure that nearly killed a woman in a third world country is still available in the wealthiest nation on earth. Texas women deserve better. Preborn Texans deserve better. And I beg you to keep abortion pill out of the state because everything it's bigger in Texas, including the courage to protect babies and their mamas. Thank you.
Thank you. Thank you for your testimony. Thank you for being here. Thank you. Ms. Benson, welcome. Introduce yourself. Go ahead.
Thank you. My name's Jana Pinson, and I'm just really thankful for this committee. I'm an executive director of a pregnancy center. I actually have 5 of them down in South Texas. We're in Corpus, we're in Rockport, Portland, and even down in Laredo, and about to go to Brownsville, working on it. I would love to say that Sarah's story is unusual, but it's not. It's not. And we need more protections desperately. What we do at pregnancy centers is we do pregnancy tests, ultrasounds, prenatal care, abortion pill reversal, post-abortion scans for reasons like that. Over 1,000 families in our parenting classes of all kinds, material support. We offer jobs. We do education in our schools. We do abuse recovery. We do abortion recovery. But the center of what we do is Sarah is meeting with that abortion-minded girl to try to help her not end up like Sarah did. And we work with the abortion-determined woman, to show her a different way. We offer her hope. we introduce her to hope, and we try to cover absolutely every problem that she might have that would keep her from embracing life. We're on the front lines, and we see the effect of the abortion pills every single day. We see men, grandmas, aunts, moms order pills, force them, coerce them in an unprecedented way. We didn't see this before. We're seeing it in unbelievable numbers now. Add to that desperate women seeking a way to deal with an unwanted pregnancy. They're receiving pills with no doctor, no instructions. They get silver packets. They don't even know how many to take or how to do it, and they're in danger. We have stories of men and grandmothers forcing pills in their girlfriend's mouth. One story in South Texas that you've already heard about mixing. It was a Marine who mixed pills in her hot chocolate. And as she started doubling over and bleeding, and she needed to go to the ER, he stopped and washed out the cup. And then he left and didn't come back and left her to bleed. She ended up getting to the ER. We're so thankful for that. But young women come in every day with pills in their purse. The good news is many leave those pills with us, choosing life and avoiding the pain of this awful, evil, dark path of abortion. So when you hear those numbers of this many abortion pills, a lot of those chose life. And so they bought them, but they left them with us, or they left them with other pregnancy centers. Abortion is illegal in Texas, but abortion is happening every single day. As a pregnancy center, we are confused why social media can advertise abortion trafficking boldly without any warning labels. A girl doesn't have to look hard. In fact, it's advertised to her. Every girl who gets pills needs an ultrasound to see if it's even safe for her to take those pills and how far along is she, or does she have an ectopic pregnancy. Using terms like missed period pills make it sound so easy, make it sound like it's not hard at all. Please understand this is a horrible experience that we have started using a new tool called an abortion care kit, where we tenderly take them through exactly what it's going to look like when she is by herself, home alone. She has chosen to be her own doctor, and she's chosen to be her own nurse. But what the abortion clinic and the people that sell the pills don't tell them is you're going to have to make decisions in this place. You're going to see your baby. And what are you going to do with your baby? You are going to need to measure your blood. You are going to need to be able to tell an ER doctor or anywhere that you go how much blood you've lost and what you're doing. About half of our girls who are the hardest of the hard, who are absolutely determined to do an abortion, said, no, that's too hard, because you're telling them the truth about what they're about to go through. Now, the good news is we're turning the tide. I really believe that with all my heart. Back when we could count how many abortions happened in Nueces County, when it was at its height, there were 750 a year. Our pregnancy center just celebrated 901 moms who were choosing abortion or at risk for an abortion that chose life. That's huge. 446 in Laredo, their first year medical chose life. Abortion-minded and abortion. Pregnancy centers work. But this specific evil of the abortion pill, we need more help to make them less accessible. I have wishes. I wish women would stand against their abusers and use the Woman and Child Protection Act. I wish steps could be taken to stop groups advertising how and where in Texas they can get the pills or to get an abortion. I wish we could stop pills at the border. They're pouring across the border for $35. I wish we could have a Texas or national marketing campaign about the truth of abortion pills, and maybe also how beautiful motherhood is, even single motherhood. Show them the beauty of being a mom. I wish we could talk about abortion pills in schools. I wish we could tell them what it's like. I wish we could have had more pregnancy centers on the border and in South Texas. From me all the way to the border, all we had was McAllen, and we just got Laredo going, and now we're going for Brownsville, but everything below us, there's nothing to help girls in South Texas. So I hope that We are gaining ground. I believe the culture's changing. I really do. The culture doesn't change overnight. And you guys are causing that. You guys are helping the tide turn, and we couldn't do it without thriving Texas families. I'll tell you that. Laredo is here because of TTF. Brownsville will happen because of thriving Texas family, and we are supported, and our moms are supported because of it. So thank you guys for all you do. Thank you.
Thank you for your testimony. Senator Hall, you have the panel.
Thank you for handling this. Ms. Huff, did you visit a pregnancy center before you took the pills? Did you have any counseling?
No, sir, I haven't. By the time I was a liberal activist, and I had my mind made that pregnancy resource centers and pro-lifes and conservatives, Christians, they were enemies of women's rights and women's empowerment. So I had a very distorted view of the reality, and unfortunately, I didn't have the opportunity. But I do believe if I had had the opportunity, for sure my life will have been different.
And it was horrifyingly shocking when you saw your baby, how human it was, that it was a little baby. Do you think that if you'd gone to a pregnancy center where they had a sonogram and you had seen that baby and the heartbeat and it's kind of moving in the womb, that it might have changed your mind?
Absolutely, sir, because I was taught by the mainstream media and even through the educational system that whatever was in my belly, it wasn't a human being. It was just a blob of cells. It was just a period. So I had no idea that it was actually a human being that it was inside me. And I regret deeply, and I wish every woman in this country, this beautiful country, it is the greatest country in the world. I wish they have this opportunity for sure.
Okay, I want to show you something. This is a little departure from that, but it fits with exactly what you said. Just take a look at that. What you're holding is, if you take it apart, is a thumb drive. And my wife and I, after visiting a pregnancy center where they were displaying their sonogram and bragging about how neat it was and how it changed the girls' lives, and we asked them, well, do you send them home with anything? Do you take a picture or anything like that? And they said, oh, no, we show it to them. We went home and we came up with this idea. It's a thumb drive. If you hold it up for people to see it, it's in the shape of a heart. And on it has my baby. Yeah. And what we do is they take a video of the sonogram and the heartbeat, and they give it to the girl to take home with her. And the reports we've gotten back of the hearts of the boyfriend, the hearts of the parents, when they saw the baby and the heartbeat, changed their minds completely. Not just the girl. That was what was so important. It's a family change. And so we have made those available. Jan, if you haven't seen that, if you would like some, I'd be glad to give you a bag of 50 to take back with you. And anybody else that's here with a pregnancy center, contact my office. We are making those available. They're not expensive. We get them. And I have to tell you a little story. Being a politician, when I first came up with it, my thought was I was going to put my logo on it to take home. And God says, you crass son of a gun, don't you dare do that. And so we came up and decided we put my baby on it. So hold that, put that in your hand and look down and you read, that's my baby I'm holding in my hand. Would that not make an impression on you?
Absolutely.
Absolutely.
Yes.
So make that available. If there's anyone that's associated with a pregnancy center and would like to take some back, we'll provide. Just contact me, and we've got them right here in the office. You can leave here. You can leave here with some, I think, in there. So anyway, but thank you for coming in for your testimony, Doctor. Thank you.
You're welcome.
For yours, and and all of what you do, and Jana, with your help, God bless you. And I am sure with this group here, there will be a considerable effort put forth this next session to come up with a way to figure out to do something about these pills. I just think it's one of the most horrible abominations that somebody has ever thought of to do it, and the laws that allow it to happen. Knowing now that we know how bad it really is, how dangerous it is, I think we would be absolutely, totally remiss if we didn't do everything we possibly can to make these pills illegal and protect these girls that don't have the opportunity to understand what they're really doing and end up like what you did, or worse than that, dead themselves. So thank you for being here.
Senator Hall, thank you. Senator Hinojosa, you are recognized.
Thank you, Mr. Chairman. And just a couple of quick comments. Doctor, very impressive. Thank you for all your work and what you've done for the women of Texas and wherever you've practiced. And Ms. Huff, goodness, what a tremendous, impactful story. Thank you for your bravery to share it. That's a type of story that, it reminds us why we fight, right? And that's a story that can only come from somebody like you who's been in it. Appreciate you. Jana, what can I say? Thank you so much. In my district specifically, I just want the members to know how much work Jana has done for South Texas moms and what pregnancy centers, the impact that they make throughout the United States, but specifically in Texas and specifically in South Texas, where that need has been so great. And it is very true, the impact it has made, but it's also true that there's not as much visibility down there as there needs to be when the close you can go right across the border to get a very unsafe abortion. It just intensifies the need for what you're doing. So I just can't thank you enough for all that you do. So just a couple comments. Thank you, Chairman.
Senator Hinojosa, thank you, and thank you each for your testimony. It's powerful. We needed to hear it. Everyone needed to hear that, and thank you each for being here. If there are no more questions from the senators, then you are excused. Thank you for your testimony.
Yes, sir.
Thank you. Very shortly, we'll be starting public testimony on the opening public testimony on the charges before us, so that you can plan in case you're planning on testifying publicly. We will begin with testimony on the monitoring charge, the Senate Bill 2337. Not much testimony there so far, and then we'll move to the election topics, and then to protecting life. So the committee is just going to stand at ease until 4:15, and we'll come back at 4:15, open public testimony. We'll start with the Senate Bill 2337 monitoring, then we'll go to the election topics, then we'll go to protecting life. So we'll be back. We'll stand at ease until 4:15. Welcome back. We'll open public testimony now, beginning on our monitoring charge for Senate Bill 2337. One witness is registered to testify on this. And is Ms. Gallagher here, Lori Gallagher? I know she's present.
Sorry, I signed up on the wrong.
I'm going to call you on the election stuff too. Okay, just making sure. Very good. I do. You moved. I saw you were over there before I got. Okay. All right. So on that charge, Senate Bill 2337. So no one is registered to testify on that. So we'll move on to the election charges. And so, obviously, election security and efficiency are related. There's a lot of overlap in the testimony. So we're going to begin that now. And so, we thank everyone for participating. Some testify, some are here to listen and do participate in other ways, but we are looking forward to hearing the public testimony. And so, on our two election charges, call Honorable David Stein, Dr. Laura Presley, bless you, Susan Valiant, and Dr. Marmion. We have you on election security and on. I bet you're here on the. Well, you can. Is Dr. Patrick Marmion here? I think that may be the. Wrong one. Okay. So it looks like we have Dr. Press, we have Chairman Stein. Again, that's called Susan Valiant. Okay. Very good. I understand. Call Lauren Pena. There, she's with us. Call Karen Wiseman. Is Karen still here? All right. Please come on down. Come on down. And then on our next panel, we're going to be looking for Debbie Lindstrom. For Deborah Damon. Fran Rhodes, I think, is still here. And so if you guys will be on standby, we'll call you up on the next panel. So actually, it's Fran Rhodes. We still have one spot up here. So I'm just going to call some names. And okay, very good. We're going to start on this panel, and we'll call the next. Thank you for your patience. Mr. Chairman, David Stein, welcome. Pull that microphone close. Introduce yourself and give us your testimony.
We have to share in 2 minutes?
Yes.
Okay. Well, Mr. Chairman, members, again, thank you guys for being here, and thank you for your patience through this parade of testimony. So I'm going to gear mine today just really towards the role of a county chairman and in elections. One of the things that I would ask, I'm sure there's communication with each of the individual parties. I've noticed many things that roll out. For example, when the team system rolled out, I wish our Secretary of State colleagues were still here, but when that rolled out, there were a number of things that immediately, to an eye of a chairman, you could look at and you could say, this should have been tweaked this particular way. It's like consulting the end user when something that comes out. So anytime that you can include one of the county chairmen in testimony, let TRCCA be a resource. I'm sure RPT as well is involved, and we want as much input as we can to head off some of the issues that come into it. A couple of the items that we've noticed that we need some help in, I hate coming in and asking for money, but we're really having trouble getting election workers. And a lot of cases, the $12 an hour, just comparatively speaking, versus what somebody would get paid at a fast food restaurant. We really need to look at funding for that. 15 may be the number. That's what I hear from a lot of my colleagues. Another thing that's on my mind is dealing with political disclaimers. I've noticed a lot of notices that have been going out, in particular during the primary election, where it might say Republican voter guide or conservative voter guide. And to the untrained eye, to the average voter, they might think, oh, this is a recommendation from the party. So something that would give a proper notice that this is that individual's opinion and not the opinion of a political party. I got plenty more, but I see my time is up.
So, and anything you have, share it with us. And of course, it'll be in the record, but also members of the committee want to see it, and I know we communicate about those things. Dr. Presley, welcome. Welcome back. Introduce yourself. Give us your testimony.
Yes, it's Dr. Laura Presley with True Texas Elections, and I'd like to speak on the first item, the election item. The charge says, evaluate county election administrators, any recent attempts to circumvent state law. So I'd like to speak on that. We've seen across the state, Senator Hughes and committee members, where cameras are going off where the ballots are being stored. We have evidence of that where there was a clock in the room in Williamson County in the ballot board room, and the clock skipped from 5:18 p.m. to 6:24 in an instant. Another time it went from 6:47 to 7:47 in an instant. There are hallways where ballots are being transferred, and this is a big issue. We want a new law that has a requirement of a clock, 24-hour clock in the room, and progressive progressive criminal penalties when that's being violated. We've seen these issues in Bexar County, Dallas County, Williamson County, and Hayes County, where the ballot boxes are not being under video surveillance. The second thing is you have, I handed this out, has to do with the seals that are supposed to be signed, not a seal certificate. The law says that the election judges and the watchers shall sign the seal. The seal is today is a zip tie with a little label on it. It's about as big as my finger. And you can't sign it. The judges can't sign it, and the watchers can't sign it. That is a waiver right now going on with the Secretary of State and these counties. We need them to follow the law because those ballot boxes need to be secured. And I'm here if there's any questions.
Thank you for that. We're gonna obviously we want to get some more details from you on what's going on, and thank you for that. You remember that was a big deal, that the fact that those ballots are under live stream, not just for the government season, but that anybody can go and watch. That's important, and so thank you.
That's right.
That we can't let that be circumvented, or the seals. Thank you. Spenny, welcome back. Introduce yourself. Go ahead.
Hello, my name is Lauren B. Pena. I'm the 2026 Republican nominee for United States Congress here in Travis County. In the 2024 primary election, I served as an alternate judge where I witnessed the opposing judge refuse to allow Republican voters to vote on a provisional ballot, so I did report that. And you are supposed to, according to law, have an equal number of, or at least attempt to have, as many Democrats as Republicans working the elections. Despite me being an alternate election judge during the general election in 2024, most of the election places here in Travis County did not have Republicans working in them at all. It was fully Democrats, and it wasn't an issue of having not enough Republican people there, because again, I was an alternate judge, but I was not selected to be a general participant, even though I reached out and tried. I ended up watching, some of the things going on and caught election interference on camera, recorded it, sent it to the Secretary of State, and then reported that a second time. Now, to the election that just happened in the primary here in Travis County, that same election judge was refusing to allow Republican voters to get access to their convention. So I don't know if I need to go ahead and apply for the lottery or whatever, but that's 3 elections where I have witnessed things going on. So my simple solution to this, and something that I would like to see, is a way for the public to get transparency whenever people are filing reports about election interference, things they're seeing. A public-facing dashboard where it can list the precincts of where people have reported seeing things that were not correct. That way the public can be completely transparent and they can see these issues. And I would also like to see there be a sign on front of every election poll that has like an 800 number or a number directly to the Secretary of State or the Attorney General's office for them themselves to call and report when they see things. And again, that being uploaded and put into a public-facing dashboard so that everybody can see that and have that transparency. Thank you.
And thank you for your testimony. Welcome. Introduce yourself and go ahead.
Okay. My name is Karen Wiseman. In Tarrant County, we have Hart Intercivic Equipment. In January of 2024, Tarrant County invited hackers to attempt to hack the election equipment during logic and accuracy testing. On January 11th, 2024, at approximately 8:45 a.m., I was standing behind the Director of Information Security and the Chief Information Officer for Tarrant County as they stood directly in front of the controller and scanner. Suddenly, the 2 men became distressed, and I overheard one of them say they are hacking the machines. The CIO said, "Shut it down," and someone immediately turned off the controller. They then focused their attention on 2 young men typing on their cell phones near the exit door and approached them. Later, I heard the director and CIO discussing how far the Wi-Fi reached, and they estimated about 100 feet. By this time, the 2 young men had moved outside and were still typing on their phones. Eventually, the CIO followed them to their car. In a separate incident on January 31st, 2026, while serving on the testing board for logic and accuracy testing, during the testing validation process, I personally witnessed a vote for a candidate being flipped to an undervote. Not only did the machine flip the vote in the tally, but it also altered the ballot image and removed the vote. This is not an isolated incident, as other instances of vote flipping have been documented by other members of the testing board. The county attributes the vote flips to dust in the machine or machines not being cleaned properly, even though the vote flip was replicated on another scanning machine and the exact same race on the exact same ballot out of a batch was altered in the same way. There's more detail in the affidavits included in my packet. Thank you.
And thank you for your testimony. So, and thank you for the affidavit as well. So, on the Wi-Fi, what do you recall? Was it the machine that tabulates the votes, or was it the?
It was the controller.
So the one that and it helped.
So
us
when
that-
you
there's the I know there's the poll books.
There's the e-poll book.
Yes, ma'am.
And then you're given a receipt that
Yes.
has and then you take that receipt to the controller.
Yes, ma'am.
And they scan that barcode, and that determines what ballot style that you're going to receive.
Yes, ma'am.
And so then the controller prints out a number that is then input into the ballot marking device.
Yes, ma'am.
So that you get the proper ballot style, and then you vote your ballot. So the controller is connected to all of the duos, the ballot marking devices.
Yes, ma'am. Okay, thank you. And so the hackers, they invited the hackers in just to see if this could be done, and you were there, and they said, hey, they got in or something.
I was standing right behind the chief information officer.
Yes,
I've got
ma'am.
his name
Yes, ma'am.
on the affidavit, and I heard him, and then he looked around and he saw what I assume are the hackers. They were standing by the door. I had never seen them before that day, and they were typing on their phone, and he I don't know, seemed to focus his attention on those people. So.
And did you have a chance to visit with him afterwards, or
No,
and by the way, this is not a cross-examination. I want to learn.
Oh,
I'm thankful for the
yes.
information, but please tell us more about.
No,
what happened.
because at the time it all happened, I didn't know exactly who they were. I
Sure.
knew they worked for the county and that they had to do with cybersecurity. It took me a while to track down the identities. I found out who the director of information security was, but by the time I reached out to him, he had already resigned his position. Like several weeks after this happened, he resigned, and nobody knew where he went. So I could, and it was later that I found out the name of the CIO. So I have not had a chance to follow up with him.
Okay. Well, thank you for this. No, this helps us. Thank you.
But somebody needs to follow up with them.
Absolutely. That's why I was getting that detail from you. Thank you, Senator Hall. You go ahead. You're recognized. No, go ahead, please. You got it.
Okay, I'm sorry, I didn't catch all of it, but Ms. Presley, would you elaborate a little bit on why what you're talking about matters?
I would love to, Senator Hall. Thank you. So if you're thinking about election fraud, there's only two things that need to happen. Someone to change the electronic results and someone on the ground to replace the ballot boxes in case there's an audit or a recount. It's only two parts of that equation. And I've been in lawsuits where the Texas Supreme Court has said we cannot get to the electronic voting systems because they're proprietary. So what are we left with in the state of Texas? We're left with the ballot boxes and making sure that they're secure. I was a watcher in Williamson County this last primary, and I actually signed the seal of the ballot box. I took a pen and signed that little seal, little tag that's on that little zip tie, and I signed it. And I went down to Central Count waiting for that box to be delivered. That box was delivered, and the seal had the same number, but no signature. My signature was missing, that I had just signed it a couple hours before. So I have witnessed what it looks like a ballot box to be replaced. Wow. So this is why this is important, Senator Hall. This is why those cameras cannot go off. Right. And there needs to be a criminal penalty for when they do go off, maybe a progressive criminal penalty. We reported the cameras going off in Williamson County over and over and over and over again for the primary. The cameras were going off in the ballot storage room. They were going off in the ballot board room constantly. And we could not get it fixed. So we need election administrators in this state, and I've seen this in other counties, not just Williamson, where the cameras went off. We need teeth in this portion of the bill, of the election code, that you cannot turn these cameras off. Maybe if it goes off, there's a glitch or something, but not repeated over and over and over and over. So we need your help with this, because if we can't access the electronic voting systems to prove the fraud, we're left with the ballot boxes. And this is what you guys put into place so that we could catch this, and it would be deterrent from doing this.
Right.
We need your help.
Okay, and I think some of that help comes in how we approach election security with what I refer to it as layered security. That ballot box you're talking about is a simple ballot that's been filled in and end up in the box. If we will go to using ballots that are on special paper, coded paper, that has codes embedded in it, and they're sequentially numbered for the county from 1 to whatever the number is, and then randomly handed out. But also, each ballot before it gets to the voter has been signed by an election worker.
Right.
So now you have the coded paper, you have sequential numbers, and you have a signature. 3 layers of security, so that somebody's going to switch out. They're not just going to be able to get a whole bunch of pre-checked ballots. Count them. You know, we got 142 in here. Take out 142. Pull them out and put the others in. They're going to have the paper. They're going to have the sequence numbers. And those numbers are random that are in there. So that's going to be near impossible to duplicate what's in there, because it won't match later if you match it up. And then you got the signature, not a stamp, but a signature on there. And so I think this is something we've talked about before, that this is an easy to do, has very little impact, and not talking about much in the way of cost to do this. The paper, it's probably 50% more for a sheet of paper that's coded than it isn't. It's not an expensive item. And then the sequentially numbered is a very important thing. The county will receive their ballots and they will be numbered from 1 to 20,000, 41, whatever it is, and then handed out. So whenever it goes back, you can account for all the numbers in there. And so I think that's the kind of thing that I'm glad you brought this up about, that kind of thing, because nobody's talked about a whole ballot box being full. We've gotten reports of them switching out the thumb drives.
Right.
And the thumb drive that ends up in Central County not being the one that really came from the precinct. But this is another, and so I think this is a fairly simple one, and thank you for bringing this up.
Thank you.
Oh, thank you. Secretary Hinojosa, you're recognized.
Thank you, Mr. Chairman, and thank you guys for bringing to light more of this information. Ms. Pena, your story made to some seem outlandish, and sometimes I've heard stories like that being passed off as, well, you didn't quite understand the process or that kind of thing. Even when you bring it up, sometimes it's explained, well, we didn't mean that or this. I know exactly what you're talking about, because I've seen it myself, and it's occurred in my district. And in fact, one of the counties I cited earlier with regard to not having their chain of custody records was the same county that would prohibit one party and would even misinform others about where they could get their party of preference ballot, even saying they wasn't here. All kinds of ways to thwart the effort of the actual voter. And I've seen it, but it goes back to, and several of you on the panel have testified on potential solutions, but it goes back to, we've got laws in place, right? What you just indicated right there was a law that is supposed to work the way you described, and it didn't. And what was the enforcement mechanism? That's the whole point, is that we have laws that are supposed to be followed, and now we're trying to find different ways. And I'm 100% in support of what Senator Hall here offers and ways of standardization of process to try to prevent those types of things from occurring even more so. But at the end of the day, people always find another way to get around it. And if we don't have enforcement mechanisms to stop this from happening, I don't think we ever get there. But thank you for bringing it to light. We're going to continue to work on potential solutions and ways to put some teeth behind it. Thank you all for your testimony.
Senator Hinojosa, thank you. Members, any other questions for these witnesses? Thank you each for being here, for waiting. Thank you for your testimony. Call Marcia Strickler. There she is. Come on down, Ms. Strickler. Call Fran Rhodes. Ms. Rhodes was here most of the day. She may have had to get on the road. Call Deborah Damon. Yes, ma'am, I got you. Come on down, Ms. Lindstrom. Thank you. Come on down. Thanks. And then Dr. Patrick Marmion. Doctor, are you here to? You're free to testify on anything you want to. Are you here on the election stuff or on the pro-life stuff? Very good. So I'm going to remove you from this panel, but we'll call you when we get to the other stuff. And if I forget, you remind me. Okay? I think we got you though. Thank you. Thank you. Is Andrew Hendrickson here? Andrew Hendrickson. The chair calls Luis Figueroa. So Luis earlier or not. Call Veronica Warms. Veronica Warms. Call Dawson Wilcox. Call Dawson Wilcox. Called Jenny Limcher. Jenny Limcher. Come on down. And then we'll be looking on the next panel for Ms. Gallagher. Lori Gallagher will call you here in just a minute. And Nilufar Hafizi also will be calling you up on the next panel. And William Nevin, be ready for the next panel, and we'll be looking forward to interviewing you then. All right, welcome to each of you. We're going to start over here, so pull the microphone close, introduce yourself, and give us your testimony. Welcome.
I almost want to say good morning, but it's good afternoon.
Yes, ma'am.
I'm Deborah Damon, Williamson County Precinct Chair, and I want to let you know the grassroots are here to help you. So thank you so much for listening to us. It's just a beautiful system that we have.
Amen.
So I'm here to talk about two issues in current election law that need loopholes and teeth put in there. Beautiful laws, but there's no consequences and there is no reason for people to follow them. One of them is with the election code 172.029 that has to do with the primary contract, where it says the CEC is the one that provides the approval for the election contract, but there's no mechanism in place or incentive for the county chairs to follow that. So they are either doing their own contracts or they are changing the contracts that we approve without our approval, and there's no mechanism in place for County Commissioners Court or the EA to follow that law. So they can take a illegally approved contract and implement that. So I've got some recommendations on that. The other is what I would call ghost packs. And when this is where the election promotional campaign information is being sent out, and it says, it's advertising, by such and such PAC, but that PAC does not exist. It's not registered. There's no secretary. We don't know who's funding it. There's no treasurer. That's what we call the ghost PAC. So I've got some recommendations that I have submitted to you to help with that, and there needs to be some strong implementation on that. And I just had some comments from, I wanted to suggest real quick. I do support the deadline for the primary contract. I think that will help us hit the target. We'll know how to plan for that. I also think opening up polling locations from any government or publicly funded building should be automatically available for polling. That's our tax dollars. We should have that. That marking for hand-marked ballots, there are markers that you can use to kind of stamp the ballots that make it equivalent to voting on a machine. So I guess that's it real quick. So thank you.
Ms. Newman, thank you for your testimony, and thank you for being here to help us, because you're right. You're on the front lines. You're doing the work, and it helps us so much to hear from you. And I apologize for mispronouncing your name. I'll get it right next time. Thank you. Thank you. Ms. Strickler, I know how to pronounce your name, and it's good to see you again.
Thank you.
Introduce
Senator.
yourself and go ahead.
Marcia Strickler, Williamson County also. I'm a precinct chair as well as a delegate. And to elaborate on what Ms. Damon said regarding the efficiency category and the primary contract, I have always understood, and I've been an election advocate for a long time, that our county CEC owns election day contract only, because that's what we were told by our county chairs. But after reviewing one of the handouts you received of the Secretary of State's county chair handbook, it actually says adoption of the voting system, and I'm going to read it to you. A vote system must be adopted for use in the general runoff primary election by resolution, order, or official action of the County Executive Committee, which is the precinct chairs. The adoption of the voting system may be modified or rescinded at any time. Additionally, the County Executive Committee should indicate in their official adoption action whether they are adopting the system for use in early voting, regular voting, or on election day. So therefore, if you look at the contract that was handed out to you, that Secretary of State contract is missing that blurb that I just read to you. So when you go out, and most counties use that contract to start, at least, they may modify it a little bit. So the Secretary of State, and I've sent this to the Secretary of State as well and gave it to Christina earlier, a voting system must be adopted for use, and they should be selecting what adoption that they're using. And did you know that the definition of a voting system is how the votes are tabulated? Has nothing to do with the e-poll book, has nothing to do with the hand-marked ballot. We have a hybrid system now in Williamson County because we moved to ballot on demand last June for the November, but this primary, our election administrator decided to give a choice to voters. We walked in to vote, and we said, and we got a script read to us. Due to ADA compliance, you can vote on a ballot marking device, and they had 20 of them in the room, or you can vote on ballot on demand. Very strange hybrid system. But it's all considered one vote system because it's based on how the votes are tabulated.
Yes, ma'am.
I didn't know that.
Wow.
Got a whole nother thing to talk with you about, but I'll send it to you.
Thank you for your testimony.
Thank you, sir.
Yes, ma'am. Ms. Lindstrom, welcome back. Introduce yourself. Give us your testimony, please.
Debbie Lindstrom. I'm the Texas Elections Director for Citizens Defending Freedom. This committee is charged with evaluating county election administration and any attempts to circumvent state law. I want to show you a documented example. A 5-year Citizens Defending Freedom investigation into Collin County found over 105,000 unaccounted for Election Day ballots using chain of custody forms the Secretary of State itself calls the most important documentation collected from election judges. And the is underlined, bolded, and it's all caps. In 2020, 2/3 of these forms could not even be located. The Secretary of State confirmed these violations in writing in 2024. The county was directed to improve training. The next election was worse, and I provided a summary of the issue for you. In 2025, after a second complaint, the Secretary of State confirmed in writing again that it could not act because the relevant statutes carry no criminal penalty, and I provided copies of those letters. The violations were confirmed, the law was broken, and nothing happened. The Secretary of State calls itself advisory only when asked to enforce, but the same office issues binding advisories that reshape how counties operate. The authority cannot be broad for one purpose and narrow for the other. Texas Election Code Section 276.019 needs an enforceable civil and criminal penalties and a way to bring accountability to anyone who violates Texas Election Code. The Texas Constitution, Article 6, Section 4, gives the legislature the task to make regulations to detect and punish fraud and protect the purity of the ballot box. Adding a penalty to unlawfully altering election procedures, such as Senate Bill 618 last session, makes this law more than just a suggestion. Thank you.
And thank you for your testimony. Thank you. Slim, you're welcome. And did I pronounce your name correctly earlier? I'll just listen and see how I did it. Introduce yourself and go ahead, please.
Excellent. My name is Jenny Limcher from Harris County. Just a moment.
You bet.
When significant election system anomalies are reported at the county level, are they being thoroughly investigated, documented, and reported as required by Texas law? Citizens want election system irregularities investigated and the ability to hold vendors accountable. In Dallas County in 2022 and 2023, election judges and poll workers witnessed ES&S Express poll books dramatically increase voter check-in totals after the poll closed, even as they were unplugged and being removed from the premise. One poll book escalated from 182 to 1,377 check-ins in seconds, and another added names from a different polling location, though they had been reconciled every hour up until the polls closed. Election judges and poll workers appeared before Dallas election officials, testified, and requested an investigation before certification of the election results. Officials dismissed concerns as software glitches and suppressed responses under the rumor control tab. Elections were certified without a forensic review. The SOS, or the Secretary of State, was notified, and their explanation was that's how they work. In the Bexar County 2026 Republican primary, independent analysts downloaded a no-ink poll pad file that contained 4,110 records with the voter unique identifiers, the VUID, having decimals rather than integers and exhibiting systemic mathematical patterns. Later, analysts observed the file be replaced. Bexar County officials rejected allegations of manipulation, but the dispute remains unresolved in the public record. The Secretary of State was notified by multiple parties. After receiving no response, one party filed a lawsuit against the Secretary of State on May 26, 2026, and on June 2nd, she resigned. These two cases involve different counties, different election cycles, different poll book systems, and different anomalies, yet they raise the same question: how secure is our election system? Who will take responsibility to find out? And I do have some recommendations.
Well, I think Senator Hall has questions for you, and then we'll go from there. Senator Hall, you're recognized.
Yeah, if you would just quickly finish up, because I appreciate what you're having to say, and I'd like to hear the rest of it.
Yes, sir. Texas Election Code Sections 129.052 and 279.002 address security breaches and election security incident reporting. Has this committee been made aware of these incidents? Citizens need investigations and vendor accountability. One legislative recommendation, a bill requiring all election system vendors and contractors performing governmental functions in Texas be required to register annually with the Secretary of State a list of their employees and contractors. Those with access to election systems, data, or infrastructure should be required to be U.S. citizens and willing to undergo background checks. In addition, vendors performing governmental functions like elections should be subject to the same public records requirements as government agencies and be required to preserve records and data consistent with Texas law. In banking, aviation, and critical infrastructure, unexplained system anomalies trigger formal reviews and vendors held accountable. Election systems should be held to no lower standard. I will email all supporting evidence.
Okay, thank you. Mr. Chairman, this is just another incident that underscores the need to be able to have ballots that we make very, very difficult for people to mess with, change, or otherwise change what's going on. And because it's clear we cannot, and I hate saying this, but we cannot rely on the integrity of all the people working in the system as our security system. Oh, they wouldn't do that. oh, yes, they would do that if that's what their mission is. And it's not to me disparaging on election workers in general, because they're good people. The overwhelming majority of them work hard and try to do it right. But it only takes one or two in there to subvert the system. And so I think that's why we have got to really focus on end-to-end having a system that makes it as difficult as possible for humans to mess with the system in there. And to address your question about, a law with no penalty, it's one of the most frustrating things I ran into when I came here, was saying, we passed a law, but there's no penalty if you don't do it. And in some cases, it was a dumb thing to do. But as I've gotten work, the feedback is elections are a little bit different than other things because you depend so much on volunteers. And I've heard it over and over again from people. If I'm going to be put in a position that if I make a mistake, I could go to jail, I ain't doing it. And so elections depend too much on people volunteering. So we've got to shield those people and have a system that weeds or covers over where people that want to do bad, it makes it extremely difficult for them to do it. I think we're on that path now with what we've passed before. Now we've got some of these other parts that we need to come back and fill in on, like the paper and the hand ballots and sequential, and the signature of a judge or their designee in there, so that we make it extremely difficult for someone that does do what you're talking about and can't account for it. And the other, but then when you get outside of that, where you have issues like you talk about of them not responding, everything needs to be transparent. Public inquiry deserves an answer. I don't care how absurd it is, they deserve to have an answer, because we are working for the people in there, and it's their information. We just have to be. So many people take personal ownership of that. Well, it's mine. That's my election. That's my stuff. I don't have to share it with anybody. No, it's a public servant activity. The public has a right to look at it, see it, or whatever it takes to give it to them. And so we need to tighten up on some of that to make sure that these requests for information are timely, not just done, but done in a timely way in there. So thank you for bringing that to us.
That's
Mr.
right.
Chairman, may I make a comment to that, please?
Please.
So along your lines of the laws with no teeth, it really goes back to the beginning of the primary election contract. If that process is not honored and respected, and you have somebody who's subverting the law without any consequences, that is waiving law, that we, the CEC, this is how we want that contract to be. And there's no penalties for that. And they know better than we do. And that opens it up for its election integrity issues. Because in Williamson County, our primary fell apart because our election contract was changed without our notice.
Okay, now let me comment on that.
Fell apart because the contracts weren't followed at all either.
Okay. There's a difference between those things that would put a volunteer election worker in jail.
That's right.
And a civil servant who's working for the county.
That's right.
That's part of their job. That's different. Mm-hmm. Absolutely. If we need to fill that in so that we have penalties that help enforce the law when it has to do with someone whose job that they get paid for.
Right.
That the people are depending that they're under the title public servant. That's the title that goes on someone when they are paid by your money, the taxpayer money. They are a public servant, and therefore they have an obligation that's different than the person who says, "Sure, I'll help with elections. What do you want me to do?" That's entirely different. And so we said get our focus on those that are working for the county, working for the state, or for the city in there, where we need to have penalties in there. Absolutely.
Can I just make a quick comment on There was a bill last session, SB 618, that was just giving civil penalties to election officials and election officers that were unlawfully altering election procedures. And Senator Hall, I believe that you offered a substitution for that bill. It passed your committee, like basically unanimously, and it also passed up through the House Elections Committee. It died at midnight on the second reading. I mean, literally the author was saying the name right when it was the midnight bell rang, and so it died. But it was a very incremental bill, and again, it is holding election officials responsible for holding to the law, which is what, again,
Including
your
the
duty is
Secretary of
to do.
State.
Yeah.
And the Secretary of State, yes.
Okay, well, make sure we know what that bill number was, because they all kind of run
618.
together.
618. By Sparks.
Senator?
Senator Sparks, SB 618.
Okay.
All right. Thank you for that.
Thank you.
Thank you. Any other questions, senators, for our witnesses here? Thank you. You're excused. Thank you for your testimony. Thank you for being here.
Thank you.
618.
Ms. Gallagher, come on down. And we're going to call the remainder of the witnesses who have registered to testify on this charge. We've called them before, but want to make sure everybody has an opportunity. So we've got call Lori Gallagher, Luis Figueroa. Call Luis Figueroa. Call Nilufar Hafizi. Nilufar Hafizi. Call William Nevin. And those are all the witnesses we have registered to testify on the election charges. Oh, please. Oh, yes, ma'am. Come on down. I called you. Yes, I called. Thank you. Hang on. I got you here. That's, where did she go? That's,
Apologies, there was a lag with the video.
no problem at all. No problem at all. Let's, all right, let's start down here. Ms. Gallagher, welcome back. Introduce yourself and give us your testimony. Welcome.
Hi, my name is Lori Gallagher. I'm here in Williamson County. I'm also the Director of Education with Tally, Texas. I'm part of one of the hundreds of Republicans leading us back to elections by the people in the precinct on Election Day. We have been fighting for 6 years now. After discovering and auditing, we're also the citizen auditors that request our records and look at evidence. We have evidence-based opinions. And we learned, going back through history, that Election Day in the precinct was our Republican form of local self-government. People don't understand that these political parties don't just nominate candidates for the general election. They were the mechanism. The legislature regulated the people conducting their own elections through these political parties. They were the closest to the people, and each precinct had no more than 2,000 registered voters in it. And on Election Day, the two majority winning parties had a precinct chair presiding judge that assembled a precinct committee of clerks, of hand counters that came together in their precinct and conducted their elections. And that political power stayed with those people at all times. It was never separated. And so we understand that there's convenience and accessibility and all these other competing issues, but we can't verify our election results. And so Republicans is secure our elections is the top priority for this upcoming 90th legislative session. And Senator Hall's signature on the back of every single ballot, the counterfeit measures, but countywide polling place program has been the biggest dismantling and destabilizing of these county executive committees. And these where our poll workers came from are these executive committees. Those precinct chairs, their education, they're not being educated. The Secretary of State is training them 18 months after they take office. That should be something immediately. The county chair law seminar should happen immediately in July so that those precinct chairs can assemble their precinct team and be prepared for the general election. The county chairs provide the list of the judges to the county clerk for the upcoming general election. And it used to be that the county executive committee had to approve that list. So I just ask you to help us preserve Election Day in the precinct by the people. Thank you so much.
And thank you. Thank you for your testimony. Welcome. Pull the microphone close to you. And
Is this for all
call the elections items.
Yes, ma'am. Yes, ma'am. So pull that microphone so we can hear you, and then introduce yourself and give us your testimony.
Good evening, committee members. Thank you for the opportunity to speak. My name is Neil Fizi. I'm testifying on behalf of myself and Engage Texas, a state chapter of a national organization dedicated to civic engagement, voter education, and the empowerment of Muslim American voters. One of our key areas of focus at Engage is voter protection, including a voter hotline we operate, and we also serve as nonpartisan poll monitors and recruit poll monitors to make sure everyone has their access to vote protected. I've also twice served as an election worker in Fort Bend County. On the first topic, I'd like to comment that poll watchers already have access in the polling booth that's adequate. I say this based on not just my own observations and experiences as an election worker, poll monitor, and voter, but also those of other poll watchers, other poll monitors, and election workers who have anecdotal reports. And also, just a few years ago, SB 1 further loosened restrictions for poll watchers. We're at the point where they have significant freedoms to see and hear election activity, to take notes, to be present when election materials are being dropped off and processed at central count stations. They can't be removed even if they violate the Texas Election Code unless the election judge actually observes them. And they're also protected from being unlawfully denied access because if an election judge or a poll worker does so, they're subject to criminal penalties. In my experience as a voter educator conducting Voting Rights 101 education, voters are surprised to learn that accepting assistance from an election worker means that poll watchers can watch their interactions and examine the voter's ballot before it's deposited in the scanner. When voters learn this, they frequently express hesitation to seek assistance from an election worker, even though that is a right that is enshrined in the Texas Election Code. And so as you all consider this issue of poll watchers, I'd ask that you keep in mind also the value of voter secrecy and privacy, as well as that. And on the subject of countywide polling, since I have 10 seconds left, I would like to point out that countywide polling has been declared a success by the Texas SOS and was originally piloted in 2006 by Lubbock County, which is a Republican, and has been expanded because it is better for voters.
Right. No, thank you for your testimony. And you made an important point as far as poll watchers go, and whenever this subject comes up, the poll watcher needs to be close enough to observe the activity. But you're right, the privacy, the secret ballot is fundamental. It's got to be protected. So thank you. Thank you for your testimony. And Ms. Warnes, welcome back. Introduce yourself and go ahead.
Thank you, Chairman. My name is Veronica Worms, and I'm testifying on behalf of the Texas Civil Rights Project. I think we can all agree that an efficient system is one where we have enough resources to execute the system, where everyone knows what they're supposed to do, and where we have backup plans for any routine issues that come up. Countywide polling checks all of those boxes. The primary chaos in Dallas and Williamson counties was entirely self-inflicted. One party in both counties decided to proceed with precinct-only voting for Election Day, so both parties were required to follow that same model. As a reminder, during early voting, all 254 counties effectively vote countywide, with voters being able to vote at any polling location within their county. Both counties were set up for countywide polling, and voters have voted that way for years. Wholesale changing the system for a single day created confusion and demand for more resources than the parties and counties were set up to handle. Precinct-only voting demands more staffing, more machines, and more voter education, especially when voters are used to a countywide system. Voters generally have the expectation that if they were able to vote in the previous election, that they should be able to vote in the next one if nothing has changed on their end. This time, many voters experienced lines of 4+ hours, were misinformed about what polling location they needed to go to, and worst of all, had no other option but to wait or be disenfranchised if something went wrong at their assigned polling place. So, what could we learn from this experience? The primary chaos in Dallas and Williamson County demonstrates why countywide polling is so valuable and why it should be expanded. Moreover, it would be in the best interest of the voters and counties if parties use the election system that the county is set up to accommodate and that voters are familiar with. It's not just a matter of convenience. Using precinct-only voting when both counties and voters are primed for countywide sets the election up for failure. And parties seem to learn from the March primary, since both the Dallas and Williamson County primary runoffs were conducted countywide. Just want to say that it's inefficient and against voters' interests to change up the election system for them just for a primary election.
Thanks for your testimony. Mr. Nevin, welcome. Introduce yourself. Go ahead.
Mr. Chairman, I'm William Nevin. I've lived in Harris County in Houston since 1994. In 2010, I received an email that changed my life and got me involved in Texas election integrity. It was an email from Catherine Engelbrecht of True the Vote, which I was a member of at that time, and she'd been making accusations that possibly the voting machines in Houston and in Harris County at that time could be rigged, that there were problems with the security with them, and she wanted them to be examined. On a Friday, she got a judge's signature on a search warrant. And the email came the following week after the police didn't execute the search warrant right away. And tragically, we'll never know if her accusations were accurate because the county warehouse burned down that weekend and all of the voting equipment was completely destroyed. So that got me involved as a poll watcher that year. And 2 years later, I became an election judge, and I've been there doing that in Harris County ever since, in all the November general elections and most of the other elections in Harris County. In 2022, I was an alternate judge in an area where I was in a middle school that didn't have a whole lot of voters. The the presiding judge had at least 2 cases of ballots. I think we got into the first pack of the first case of ballots. So she opened up one case, opened up one pack. I think we used that whole pack for that day. That's all we needed. Okay, so she hadn't even gotten into the first case yet. Around 4 o'clock, a technician from the county came because we called because we'd had a problem with one of our voting machines. We managed to solve it ourselves before the technician got there. I started chatting with the technician, and we chatted for about 30 or 40 minutes. And then abruptly he said, we are going to keep the polls open until 9 o'clock, and we've got 2 more cases of paper for you. So anybody who tells you that in that election in 2022, November, that there was a shortage of ballots in Harris County, they are lying. Because I've talked with other clerks at other parts of the county, there was plenty of paper. They were delivering it to places that hadn't asked for it. When polling places that had long lines and were completely out of paper, they had been calling all day and hadn't been able to get a response from the county.
So there was plenty of paper, but not.
Yes, sir. I can swear from my own
but only
personal
provided,
knowledge there was plenty of paper. It was just not in certain parts of the county.
It's provided only to certain places.
Very certain places. And if you look at a map of the whole county and see it, it's very clear that it was a partisan decision to deliver it some places where it wasn't asked for and not deliver it other places where they've been calling for it all day.
And that was your experience at a place where even more was made available that wasn't even needed. No, that
yes,
is
sir.
helpful. I will say, we don't always jump. We don't want to jump to a partisan conclusion, but you look at the map of where they were short on paper and look at where the voters were. It was pretty striking. It was a remarkable coincidence, if it was not intentional, to deprive ballots to those certain precincts. And you were there.
Yes, sir.
Yeah.
And I've been making reports for all kinds of violations of election law for the whole 16 years I've been involved in this. And I make the reports, and nothing seems to change. I haven't seen arrests. I haven't seen indictments. And there needs to be teeth in the law. So I just hope that somehow the legislature can make sure that there's a mechanism to prosecute election felonies that is outside, that can be outside the purview of the local DA.
Yes, sir.
Because if the elections are fraudulent and you can sufficiently that you can overturn an election for a district attorney, then it basically gives the cheaters carte blanche to do whatever they want with impunity.
And as you may know, last year, the legislature restored the authority of the Attorney General's office for that very situation.
Thank you so much.
For whatever reason, the district attorney may not prosecute. So to answer your question, yes, that's what we're trying to do. But let us know what you're seeing, what you're hearing. And I think Senator Hall has a question for you as well. Senator.
No, I was not. Go ahead, because I'm for the
I'm sorry.
lady sitting next to him.
I was assuming it was for you. He's got other questions. So thank you, and thank you for doing that. That's a lot of work, and thank you. And a lot of folks here serving in elections. Thank you very much. And Senator Hall, you're recognized.
Thank you. I'm sorry I didn't get your name there, but
Veronica Worms.
Appreciate you coming. So, if I listen to what you said, I think I heard all of it. The secrecy of the ballot is totally unimportant to you.
Oh, that is not at all what I said, sir. What I said is that the countywide polling system is an efficient system.
With countywide polling,
yes,
you can determine how some people voted.
That is inaccurate.
There's no getting
sir.
around it.
That is inaccurate.
Well, I'll disagree. Well, that just added to it because I'll have to say, in the whole time I've been sitting on this dais with witnesses, you are the first one that I absolutely 100% disagreed with every word you said. Because
I can't help your opinion, sir.
No, and you're certainly welcome to yours, and I mean that very respectfully because you have a different view of what's important and what isn't important than what I do, and so that's fine. I just would say it's very seldom I hear someone that absolutely is 100% out of opposite of how I feel about it because I think that we have sacrificed security with countywide. It's not just the secrecy of the ballot. It's the whole process that's threatened as a result of countywide voting. And there's no reason for it. We voted for years. We voted with a much more cumbersome system than what we have today in precincts because that's where people live. Precincts voting is closer to their homes, mostly closer to the schools their kids go to, and closer to the grocery store they shop in. And so there's no good reason for someone not to be able to vote in the precinct. But the security of the ballot is threatened. We've proven it multiple times by identifying people and exactly how they voted in there. And so that's what we'd get as long as we stick with countywide voting. Everybody needs to know that if you don't vote in your home precinct, there's a real good chance that someone can find out exactly how you voted.
Senator Hall, if I can respond.
Sure.
Sure. So I would disagree categorically that only being able to vote in your precinct is the most convenient way for voters to vote. Texas is a big state. We have very big counties, and folks work across the county. They go to school across the county. It's not necessarily the most user-friendly way for people to vote. Also, as we saw in both the Williamson County and the Dallas County elections, one of the big problems with precinct-only voting is that if there's a problem at one of those polling locations, if the machines die, if there are really long lines, those voters are without a paddle. They don't have another location that they can go to. They are only able to go to that assigned location, and we saw that play out during the March primary. So I also think that ballot secrecy is very important. I disagree with your characterization of the countywide polling place program being, no, sorry, that is not a fact. And the Secretary of State's office has also touted the success of the countywide polling place program and has not said that it has any impact on ballot secrecy. So I disagree categorically with your statement on that.
They've recognized the data that's brought to them. And I would say that some of the failures out there is because the people operating it absolutely are opposed to precinct-only voting, and so they go out of their way to find ways to trip the system up and make it difficult to do. And if with voting for almost 20 days, I don't care where you work, where you go to school, where you go shop, where you get hair done, where you play golf, you go home every night. And the precinct is near your home. And so the opportunity to vote near your home is greater than it is any place else. But I appreciate you coming.
What happens when the polling place near your home that you're assigned to doesn't have any machines working on election day? I haven't heard a way to deal with that.
We can always come up with hypothetical things that would cause something to happen. I mean,
we saw it happen, sir.
Okay, well, as an example, we need to polling locations can have multiple machines in it. You can have multiple people using the common machine, but voting precinct only. There's a lot of solutions to it. For those who want to find a solution, they find it. For those who don't want to, there's none so blind as those who choose not to see.
I mean, I guess we can agree that if you don't want to see the evidence, then you won't see the evidence.
Okay.
That is fair.
All right.
And the Dean of the Senate is recognized.
Thank you. Thank you, Mr. Chairman. Ms. Worms, do you have any recommendations for how we can address threats to election officials and workers?
Sure. I think that, so in Williamson County, we saw EA Bridget Escobedo and her staff receiving death threats during the election because of a conspiracy theory regarding a clock. I think that we can protect our election workers from doxing and having their personal information available online so that bad actors can threaten them. I think that that's something that would help our public servants executing our democracy.
Thank you. Do you have any anecdotes or any experiences to share with us regarding people who were adversely affected by the switch from county to precinct voting?
Yes, we received, I can't even tell you how many calls. We also participate in the election protection program. We received so many calls to the 866-R Vote hotline of folks who were assigned to a single precinct. There was a senior living center where a ton of folks were basically waiting for over 5 hours outside in order to go vote because there were problems with the machines and things were improperly staffed. That just wouldn't have happened during in a countywide polling situation because, as I tried to explain, when you have countywide polling, if there's a problem at one polling place, the most common solution is that volunteers, folks, even that are working in the polling location, will refer voters to another polling location that's close to them. They didn't have that opportunity here. So a lot of people just left line. They were disenfranchised because of the decision to switch to precinct-only voting, and it was completely unnecessary.
Well, what can local officials or what can this committee do to ensure that we don't have the mass confusion that we had in the primaries?
I think it would be a great idea to continue with the system that the county is staffed and resourced for and not make a switch to a different system that confuses voters just for a single election day. Because as I said, even during a primary election, even if you think that precinct-only voting is God's gift to elections, during early voting, everyone votes countywide. People are used to voting countywide. Switching that up for a single day, it's just going to confuse voters. So I don't think that one party should be able to force another party into using a system that voters aren't familiar with for a single day. And that goes for any party.
Well,
I just don't think that's fair.
I have to tell you, I love countywide voting. I absolutely love it. And it has saved us time and time again. I live in Southeast Laredo. And had I had to go that particular day, which was the only day I could vote, all the way home from where I was, I wouldn't have made it. But because I could vote anywhere, I was able to vote, along with a staff member who was with me.
Thank you, Dean Zaffarini.
Thank you. Thank you, Mr. Chairman.
And thank you, Senators. Any other questions for our witnesses on this panel? Thank you each for being here. Your excuse. Thank you for your testimony.
We have one more witness if he is registered.
Oh, very good. Thank you for making sure. Come on up. I was going to ask if I'd called you earlier.
Hi.
Hey, welcome. Have a seat. Before you get started, tell us your name.
Yes, sir. Good evening, everyone. My name is Dawson Wilcox. I'm testifying on behalf of the Texas Civil Rights Project on the charge regarding election security.
Excellent. And your name? Tell me one more time.
Dawson Wilcox.
Got it. Yes, sir. Very good.
The Texas Civil Rights Project is committed to ensuring that every eligible Texan can participate in our democracy through safe and secure elections. To that end, we would like to draw the committee's attention to two potential ways of improving election security in Texas. First, safe elections are not possible without countless hours of work by public servants and volunteers, as we've talked about all day, that make sure our elections run smoothly and in compliance with both state and federal law. Election workers have been subject to harassment and death threats stemming from unfounded conspiracy theories of election fraud. For example, during the primary election, as we have talked about, Williamson County election workers received death threats because of a viral conspiracy theory. So, in addition to contending with countless election security and compliance concerns, election workers also had to contend with threats of violence. It is so much harder for election workers to secure our elections when they are fearful for their own personal safety. To secure elections, we recommend taking steps that would ensure that election workers are safe from doxing, online harassments, and threats of violence that jeopardize their safety by rejecting the harmful rhetoric and debunked misinformation about election security in this country. Second, we'd like the committee to consider the implementation of online voter registration. Texas is one of only 8 states to not have a comprehensive online voter registration system. The implementation of online voter registration would lower administrative burdens, ensure the accuracy of voter rolls, ensure the and add another secure way of registration in the state. Every day, Texans use the internet to conduct banking transactions, pay student loans, and store their sensitive personal information. In our digital age, Texans should be able to vote or register to vote online. Thank you.
And thank you for your testimony. So I'm curious, as a law clerk, are you a law student or a new lawyer?
Yes, sir. I am a rising 3L.
Where are you going to law school?
I go to Berkeley.
Outstanding.
Yes, sir.
Thank you very much. Senators, any questions for Mr. Wilcox? All right. Thanks for your testimony.
Thank you for your time.
Now, those are all the witnesses who have registered to testify on our election security, election efficiency charges. So we'll close public testimony on that topic, and we'll move to our final charge. On the charge of protecting the unborn, we'll open public testimony. I call Blake Rocap, Mike McFarland, Kim Batchelor, Jonathan Covey, and that'll be our first panel. We're going to get a few more folks on deck to be ready for our next panel. So shortly, we want to hear from, or we invite to testify Alex Evans, Ling Zhu, Shanika Holder-White, and Shelley McCann. So if you're close by or make your way down here, we'll have you on the next panel. And welcome. And I think it's welcome back for most of us. Pull that microphone close, introduce yourself, give us your testimony.
Thank you. Good afternoon, Mr. Chairman. My name is Blake Rocap. I'm the Legislative Counsel for AVOW. And as much as the committee's charge today is about studying, monitoring, and making recommendations about medication abortion and protecting the life of the unborn, it kind of raises a more existential question and problem for this committee and the legislature, which is, have you reached the end of your power, right? You heard from the invited testimony about the legislation that you already passed and how that was being litigated in the courts. So HB 7 attempts to regulate out-of-state conduct. We'll see if that's successful or not, right? It's on a collision course with the SHIELD laws. You have the Attorney General prosecuting those cases. You have criminal charges. And then the other suggested ideas are ones that were rejected as they were maybe previously part of 2880 or rejected because they also are sort of at the limit of a state legislature's power, because other states, of course, have their own sovereignty as well, and people have other federal constitutional rights. So the idea that this state legislature would prohibit the publication of accurate information, such as abortion remains legal in New York, California, New Mexico, right? You can see the First Amendment problem there, right? The idea that somehow providing the Attorney General with more enforcement authority would be helpful. I mean, maybe, but I don't think the Attorney General is right now not enforcing the laws, or that there's prosecutors not enforcing the laws, right? So you're at the point where you're going to have to see if what you've done works, and there's not much else you can do. So I think you should consider that as you think about, the problems you're trying to solve, whether you've reached the limit of your own power in the system we're in.
Well, Thank you for your testimony. Welcome. Pull the microphone close and introduce yourself. Go ahead.
Thank you, Chairman Hughes and committee members. I'm Mike McFarland. I'm the Texas Faith Director with Citizens Defending Freedom. Our organization is committed to mobilizing churches and communities to confront moral and cultural challenges facing our state and nation. One of our core values at Citizens Defending Freedom is that we believe in the sanctity and protection of human life. Every human being bears God's image and possesses inherent value from conception to natural death. Now, while Texas has made incredible progress in protecting unborn life, a new threat has emerged: the widespread availability of mail-order abortion drugs. Today, abortion pills are just a few clicks away, ordered online and delivered within 24 hours, or smuggled across the Mexican border. Though marketed as simple and safe, these drugs carry severe risks, as you've heard from other testimonies today, including dangerous bleeding and complications. Without immediate medical supervision, women are frequently left to face these emergencies entirely alone. Texas has a responsibility to protect unborn children and to ensure women are not exploited by a greedy industry that intentionally evades our state laws. The reality is that abortion trafficking has adapted. Out-of-state organizations and social media networks now openly advertise free transportation, lodging, and financial support to circumvent Texas protections. Texas has long led the nation in defending life, but the fight is not over. We must close these loopholes and strengthen our laws to stop the trafficking and distribution of abortion-inducing drugs. And we cannot allow out-of-state actors to undermine the safeguards this legislature has worked so hard to establish. Thank you for your continued commitment to defending both women and unborn children in Texas.
And thank you for your testimony.
Thank you.
Ms. Batchelor, welcome. You already got the microphone there. Introduce yourself and go ahead.
Hi, my name is Kim Batchelor, and I have recently heard from two Christian church friends of situations brought about by the severe penalties associated with current Texas law. I'm here to tell you about one of them, my friend's daughter, a 37-year-old mother who was treated on June 7th in the emergency room of a hospital in DFW for a miscarriage at 9 weeks of a very much wanted pregnancy. While receiving treatment, she was asked if she wanted to take misoprostol to help complete the process. The doctor explained that taking the drug would help avoid the need for a D&C. It's not really surgery, it's just a procedure. Due to concern about leaving any tissue that could lead to potentially life-threatening sepsis or damage to future fertility, she chose to take the drug. The first dose was administered in the ER with instructions provided for taking a prescription submitted for her to pick up at her local pharmacy. The hospitalist explained to the patient that she might be asked to tell the pharmacy that the medicine was for a miscarriage and said with a meaningful look, "Because this is Texas," unquote. The hospitalist and the care team provided compassionate care, but this would not be the case at the pharmacy. At their local branch of a national chain retail pharmacy, the pharmacist repeatedly asked in an accusatory manner, "What is this being prescribed for?" With the devastated and confused couple consistently explaining to complete a miscarriage, as was included with the prescriber's instructions. The pharmacist sent the couple home without the prescription, stating she was unable to fill it until she spoke with the doctor. The patient, in significant physical and emotional pain, was required to return to the pharmacy hours later to pick up the prescription and show her ID. She was again questioned about the need for the prescription. And after enduring a lot of accusatory questions, she was able finally to obtain the medication. I have to say that a recent study that was published in Forbes magazine shows that abortion bans in 9 states are forcing doctors across multiple specialties to delay or withhold standard pregnancy care. Pregnant women in states with total abortion bans are nearly twice as likely to die during pregnancy, childbirth, or the postpartum period.
Thank you for your testimony. Just go pull the microphone over there, introduce yourself, and go ahead.
Thank you, Mr. Chairman. If you're not careful, you're going to lose your reputation as the most deliberative body, because I waited 10 hours to testify at SBOE yesterday, and I only waited 9 hours here, so I'm feeling pretty good. I've got a lot here on one subject. I'm just going to try to summarize a little bit. But we've heard a lot of valuable testimony on the from the invited witnesses on the important steps Texas has taken to protect the unborn, and distribution of the pills occurs in many different avenues. But one area that deserves, I think, particular attention is Texas college and university campuses. So, in fact, college campuses, they may represent one of the largest blind spots in Texas's understanding of the abortion pill distribution and use, because there are thousands of young women living in dormitories, student apartments, university housing across the state, and these pills can be ordered online, shipped directly to those locations, yet policymakers have very little visibility as to their use, or very few reliable mechanisms exist to understand the scope. So, a lot of questions that we would ask in a circumstance like this, how frequently are pills being shipped into student housing from out-of-state providers? To what extent are young women facing the pressure or coercion from boyfriends or others to use abortion pills? And what enforcement challenges exist out there when the drugs are distributed through those mail-order abortion channels? So I guess the reality is we can't effectively address what we don't understand. So just as an example, California, Colorado, New York, a lot of other states, they're actually starting to require abortion pill availability in health centers on college campuses. So if they're doing it, it must be a concentrated area of a lot of viable users. It's something we need to understand better.
And thank you, Ms. Covey, for your testimony. The chair recognizes the Dean of the Senate.
Thank you, Mr. Chairman. My question is for Mr. Roca. Do you have an opinion regarding how the Supreme Court's decision impacted Texas law?
The Supreme Court.
Mr. Roca, get that microphone so we can hear you.
Thanks, Senator Zaffirini. The Supreme Court decision in Dobbs, or
No, in Louisiana versus FDA. Well, let me ask you another question. To what extent can states restrict the distribution of an FDA-approved medication?
Right. It's part of the subset of the point I was trying to make. Right, is that the medication abortion regimen is approved by the FDA, and it's not a matter for this legislature to deal with that approval and the REMS and how it can be prescribed. And other states can regulate their practice of medicine and choose how it can be prescribed as well. So the decision for the court to not take up the case and not agree with the state of Louisiana that the REMS, the in-person dispensing requirement should be reinstated, didn't affect Texas law at all. Texas is still, of course, completely free to enforce and does enforce the law within the state of Texas. Senate Bill 4 comes with both criminal and professional licensure penalties for physicians and criminal penalties for individuals. Anyone who were providing medication abortion in the state would be subject to that, would be subject to Senate Bill 8 and the trigger ban and those criminal penalties. So the problem, of course, that I'm suggesting is that the state of Texas is very limited in its ability to enforce its law outside of its borders, right? And some of these ideas that were brought up earlier about like hiding evidence, I don't know if we go to Las Vegas and we come home and have our betting slips in our pocket. If I destroy those betting slips here in Texas, have I hidden evidence of a crime because it's illegal to gamble in Texas? I don't think so, because we were in Vegas doing the gambling, right? So this allegation of criminality because people are following the laws and living in other states is a little far-fetched to me.
Do you know in Texas to what extent private civil actions have eliminated or reduced the use of this medication? I'm talking specifically about private civil actions.
I don't think they have at this moment because thus far there's no determination that the private civil actions can can be enforced for physicians providing telehealth outside of the state. Now, if you're talking about provision of care within the state, I think the felony criminal penalties are, have prevented physicians from providing the care in the state, if that's where your question is going to. I mean, I think there's layered penalties for someone who would, either a physician or otherwise, who would provide or distribute medication abortion in Texas. But again, those penalties can't be enforced outside of the state, which is.
Thank you, Mr. Chairman.
Thank you, Dean. Senator Hall, you're recognized.
Yeah, I appreciate the box we're in, and but we're also at one time we're in a great box with vaccines, where the federal government gave complete immunity to the vaccination companies for their vaccines for damage. You cannot sue them directly because of their vaccine for damage. But this last session, we managed to get a bill passed that said that if you advertise in Texas that your vaccine is safe and effective and it hurts someone, that's a cause of action for a lawsuit. That's a little bit different. I would think if we would use our aggressive imagination and treat this as a barrier, which is like what I learned when I was in school. If you run into a barrier, you either go over it, you go under it, you go around it, or you blow it up. And I think if we look at this as the same thing, we're going to get through the barrier. So we just have to use our creative thinking to see what we can do to at least minimize this incredibly irresponsible evil that's out there. And it is that. If you didn't, anybody that listened to the testimony of the lady who found her baby in the toilet and others who have suffered similar to it, it is something that we need to use our creative thinking on how we go about blunting it if we can't kill it altogether. And so just because somebody tells us we can't do it makes me want to think we really need to double, triple our effort to find a way to do it. Because when you put your mind to it, there's a way to do most anything. It's just a matter of the will to do it. Most things that don't get done is because the person wanting to do it doesn't have the will to make it happen. And I think this is one where we need to dig deep and find our will and make this happen.
Well, thank you, Senator Hall. Senators, any other questions for our witnesses on this panel? We thank each of you for being here. Thank you for your testimony.
Thank you, Mr. Chairman.
I call Alex Evans, Ling Zhu, Shanika Holder-White, Shelley McCann.
Oh, it's the other McCann. She was like, you spelled it wrong.
All right, welcome to each of you. You've already got the mic ready, so introduce yourself and give us your testimony. Welcome.
Good afternoon. My name is Alex Evans. I'm the Government Relations and Political Manager at Planned Parenthood Texas Votes. Less than 2 weeks ago, the Texas Republican Party voted on their party platform, making explicit their intention of criminalizing Texas women and banning IVF. Of course, party platform is not law, and we're discussing HB 7. So first, medication abortion is safe and effective, period. Second, it is extremely alarming that the official position of the Texas Republican Party is that HB 7 did not go far enough, and that Texans must continue to be experiments for more dangerous, unpopular, anti-woman and anti-child legislation. When the two groups centered to the convention floor flight, Texas Alliance for Life and Abolish Abortion Texas are in conflict. They frame the other as standing with Planned Parenthood. I disagree. Neither of these groups provide any of the good Planned Parenthood does, but that's not the point. Anti-abortion extremists have made it clear that if you are not in favor of criminalizing Texans and banning IVF, you are a rogue official, a rhino. It doesn't matter how much pro-life legislation you have passed. By their standards, you are just as pro-abortion as we are. This is not a fringe movement to be written off. It is a real threat gaining momentum in the confusion and crisis caused by 4 abortion bans and decades of defunding women's health. My hope is that both the committee and Texans listening follow the wisdom of when people tell you who they are, believe them. Supporters of the aforementioned platform have outright said that the thousands of Texans who self-manage their own abortions each year are murderers who ought to be prosecuted, even eligible for the death penalty. Every subsequent abortion ban, Senator Hughes, you have promised that you will never support criminalization of women. I hope that you will keep that promise, even though your party is pretty eager for you to break it. Though it is scary, I'm glad this trajectory is transparent, because clearly it's us or them. Us being Planned Parenthood and the Texans we fight alongside who deserve dignity, quality health care, and the right to determine their own futures, and them being anyone plotting to impose further cruelty, in secret or out loud on malicious display. Thank you.
And thank you for your testimony. Pull that microphone over there. Welcome, introduce yourself, and go ahead.
Hi, my name is Lin Su. I'm from Austin. I volunteer with Planned Parenthood. I'm here to represent myself. Abortion is healthcare, period. Medication abortion has been safely used for decades and is supported by extensive medical research. Banning abortion is taking healthcare away from Texans. Multiple pregnant women have died since the abortion ban. Their doctors, fearing legal consequences, refuse to provide abortion care. Instead of upholding the unpopular abortion ban, I urge you guys to do something to improve our health care. Here are a few things you can get started. Restoring funding to healthy Texas women and allowing Planned Parenthood back in as a Medicaid provider. Expand Medicaid coverage of certified pregnancy doulas. Investment in reproductive and maternal health deserts, especially in rural or undeserved communities. Thank you.
And thank you for your testimony. And welcome. Introduce yourself and go ahead.
Chairman and members of the committee, my name is Shanika Holder-White. I'm the mother of 5 and the Deputy Director of Planned Parenthood Texas Votes. I am here today to share how a medication abortion helped save my life. For years, I struggled with uterine fibroids that caused significant pain and discomfort. In July 2024, I underwent surgery to remove 3 fibroids from my uterus. During that surgery, my doctors made 5 incisions in my uterus to remove the fibroids. The surgery was successful. 2 months later, I unexpectedly became pregnant. After consulting with my physician, I learned that continuing the pregnancy posed serious risk to my health and my life. Because my uterus was still healing from surgery and multiple incisions, the pregnancy could have caused those incisions to reopen or rupture, putting me at risk for severe hemorrhaging, permanent injury, loss of fertility, or even death. As a mother of 5, I could not imagine leaving my children without their mother. Fortunately, at that time, I lived in a state where medication abortion was legal and accessible. Under the care of my doctor, I was prescribed mifepristone and misoprostol, 2 FDA-approved medications. They allowed me to safely end the pregnancy at home, continue healing, and keep caring for the children who depended on me every single day. When lawmakers talk about abortion medication, they often ignore people like me. Abortion care is health care, and medication abortion is an essential part of that care. 60% of people who have abortions are already parents. These are decisions made by loving parents trying to protect their health, their families, and their futures. The continued attacks on medical abortions in Texas are dangerous, inhumane, and disconnected from the realities that families face. Mifepristone and misoprostol are safe, evidence-based medications that are also used in miscarriage care. Every Texan deserves the freedom to make deeply personal medical decisions with their doctor without political interference. I am here today because a medication abortion was available when I needed it. Without that care, my children could have faced the trauma of losing their mother. No family should ever be put in that position. Thank you for your time and consideration.
Thank you for your testimony. Pull the microphone over there, introduce yourself, and go ahead.
Hi, my name is Shelley McCann, and I'm here today as a mother who experienced multiple forms of adversity during and after pregnancy, adversities that far too many Texas mothers know all too well. I was pregnant and uninsured, experienced postpartum depression, anxiety, PTSD, and psychosis. And like many Texas mothers, I had to navigate those challenges with little to no affordable health care. I gave birth to my daughter in 2015 before the abortion bans while covered under Texas Medicaid for pregnant women. My birth experience was traumatic and nearly cost both of our lives. Yet 6 weeks after giving birth, I lost my health care coverage, which was standard practice in Texas under the program at the time. Like so many parents, we had to make impossible choices, paying for necessities, finding childcare, returning to work, addressing serious health needs, all of which are basic survival, necessary for basic survival. So I accepted being uninsured for about 2 years because there were no realistic options available to me. And accessing an affordable IUD from Planned Parenthood changed my life. So birth control is often debated as a political issue, but for me, it was a lifeline. And today I'm thriving. However, my success, my healing, my future were not guaranteed. They depended on access to health care, reproductive freedom, and the ability to make decisions about my own life. Adding another abortion ban and taking access to medication abortion from those who need it to survive, denying us autonomy in our own lives, is criminal. The reality is your Texas policies are the root cause of so many burdens on women and mothers with life-threatening consequences while receiving fewer resources, fewer access to healthcare options, and less support. So access to medication abortion and reproductive health care is about more than health care. It's about dignity and self-determination and whether Texans have the freedom to make decisions that allow them to care for themselves, their children, and their futures. Thank you.
And thank you for your testimony. Dean Zaffarani, you're recognized.
Thank you, Mr. Chairman. Ms. Evans, you mentioned the Republican Party platform.
Yes.
Irrespective of the Republican Party or the Democratic Party platform, does Planned Parenthood have any access to polls showing how Republicans versus Democrats versus independents feel about access to abortion?
I mean, regardless of party, abortion access is extremely popular. It's growing in support on partisan leanings, even for Republicans. And I think the reality is that the abortion bans in Texas are extremely unpopular, and they continue to show people and turn people, engage people, and make them feel more strongly about how important access is.
Thank you. Do you have any access to polls showing how religions differ and their attitudes about access to abortion?
Sure. I mean, I think we automatically make some assumptions that Catholics or the devoutly religious of any kind or Muslims, any type of religion has like an inherent bias against abortion. But the reality is that abortion polls, again, pretty well across all types of religions. And people, above all, respect the need for people to make decisions with their doctor and their God.
Thank you. Thank you, Mr. Chairman.
Thank you, Dean. Senator Hall, you're recognized.
You call it female health care. Explain to me how that's health care for that little girl that dies a horribly agonizing death and then is expelled into the toilet. What kind of health care is that for that child?
Are you addressing someone in particular?
Anybody, any of you, all of you segregate it, that it's okay to kill the child.
I actually want to refer to the child that I had at home. If I had had another complicated, nearly fatal, unplanned, unwanted pregnancy while I was experiencing a multitude of adversities, which I did not list here, the child that is under my charge, the child who was in my care already, the existing child who had a right to basic needs that were not being provided by the child that is already under the care of my family is the one we're talking about. When we're talking about access to the autonomy and the choice to decide when and how and if we expand our families, this is our dignity. These are our decisions. This is our autonomy. This is our body.
So it's okay to kill one child for the benefit of the other.
Would you say it's okay for a mother to die and leave 5 children behind with no one to take care of them?
And I'll address that. In Texas, it has been since that law was passed that a mother's life is in danger, then an abortion can be performed. Unfortunately, let me finish. Unfortunately, we have had several doctors who knew they were going to lose a lot of money by having the abortion business go away. And so they allowed the women to die by refusing to give them an abortion when they should have, because when the woman's life is in danger, a doctor can do an abortion. That's the law makes that absolutely clear in there. And so that is, don't you shake your head, it is the law. It is the law.
I believe that it is the fear of penalization that causes doctors to stall on making the decision that provides care for women that
There
need
is
it.
no penalty for an abortion that is warranted because of the mother's life in danger. And that is those folks who want to have abortion to be for anybody who makes a bad choice and gets pregnant to be able to kill that child. They want that. So they use that as an excuse. It is not true. I don't care what you have to say about it. We passed the law. We know what the law says, and we know that those doctors were wrong in letting those women die. So I just wonder how you segregate it in your head. That's my question, that it's okay to kill one child.
I think if
for
it's
whatever
okay for
reason.
someone who made a bad choice to make the decision to keep the child because it's their body and they made that decision with their doctors and based on the needs of their families and what they can sustain at the moment, it should be okay for a woman to make the decision if she made a bad choice to also decide to not go through with the pregnancy if it is best for her family and if it's being decided with a doctor.
Okay.
I think that is the safest thing for families.
Okay, and so along that line, you have the child, it's turning 2, the terrible 2. This child is really a burden to me. I think I'll kill it too. I killed one before in the womb. Why is it okay to kill a child in the womb and it's not okay to kill one that's 1 or 2 years old? I mean, I had a couple of teenagers that I wanted to kill them, but so explain that to me.
It seems like you're bringing up killing children more than we are. I will say that.
No.
I also think,
No, you're
back to
talking
the point
about
of
killing
doctors.
children, and every time you tell me make abortion is okay. You are talking about killing a child.
Senator Hall, I think your point about doctors intentionally choosing to let women die under the abortion ban because they had monetary interest is appalling, and it's an offensive to every single physician in this state who is working hard under the laws this legislature set. And it makes their job harder. It makes them want to leave the state. And to allege that they are doing it because of money rather than fear of investigation, because even if the law provides that the life of the mother may be saved with an abortion, that does not prevent them from investigation. That does not prevent them from undergoing the beginning of severe criminal penalties. It doesn't prevent them from suffering under the ban. So I think alleging their hesitation is from anything other than a result of the law is absolutely unfair.
Well, I can't do anything about their self-inflicted guilt, so. Okay, thank you.
Senators, any other questions for these witnesses? Thank you for being here. You're excused. Thank you for your testimony. I called called Jonah Pop, Eric Diaz, Grace Brooks, Katie Bai. Jonathan Pop. Eric, all right, thank you. Eric Diaz, is Mr. Diaz still here? All right, Grace, is it Ms. Brooks? All right, thank you. Katie Bai, B-A-I, Katie Bai, if I'm pronouncing that correctly. Call Raven Freeborn. Raven Freeborn. Call Shelley Hayes McMahon. Shelley Hayes McMahon. All right, welcome. Darcy Caballero. Darcy Caballero. All right, welcome. Looks like we have a panel. And then shortly we'll be looking for Laura Terrell, Kritika Sao, Kobe Heisey for the next panel. All right, so thank you for waiting. You already have the microphone. Introduce yourself and give us your testimony.
Hello, my name is Grace Brooks, and I'm the Government Relations Political Coordinator at Planned Parenthood Texas Votes. Now, I'm here with the concerns regarding House Bill 7 and the interim charge. If the purpose of this hearing is to protect women and children, we should address the need for investment in reproductive and maternal health, especially in rural areas. Health deserts are already presented throughout the state and growing rapidly. Continuing to neglect the crisis puts people of all walks of life at risk. as well as healthcare suffers for one Texan, is inevitably affecting us all. Today, only about 40% of Texas rural hospitals provide labor and delivery services, according to the Texas Organization in Rural Community Hospitals. Texas is still among the worst maternal mortality rates in the country, especially amongst African American mothers. 1 in 4 Texas women of childbearing age are uninsured, the most in the country, and the state has the highest rate of repeat teen pregnancies. Despite all the alarming statistics, this committee is choosing to hear ways to further restrict medication abortion access. Mifepristone and misoprostol are proven to be safer than drugs like Viagra and penicillin. Medication abortion is a critical point of access for Texans living under a total abortion ban, but also for miscarriage management, which has suffered tremendously because of laws of House Bill 7. Restricting access for mifepristone and misoprostol for any reason is dangerous and a disservice to the constituents you represent, and any attempt to protect women and children that does not expand access to reproductive and maternal health care is a waste of time. I urge the committee to look for actual solutions, not worsen the problem manufactured for the compounded by House Bill 7.
And thank you for your testimony. Welcome. Get that set up and introduce yourself and go ahead. I think you got it.
Chair Hughes and members of the committee, Dean Zaffarini. My name is Shelley Hayes McMahon. I'm the Executive Director of Planned Parenthood Texas Votes. Thank you so much for the opportunity to testify today. So if Texas is serious about improving health outcomes for women, children, and families, then we have to address the fact that 1 in 4 Texas women of reproductive age and more than 1 in 10 Texas children are uninsured. According to the Texas Policy Evaluation Project and census data, these are the highest uninsured rates in the nation. But at the same time, Texas continues to exclude Planned Parenthood from Medicaid and from state-funded family planning programs. Research published in the New England Journal of Medicine found that after Texas excluded Planned Parenthood and cut family planning funding in 2011, access to effective contraception declined dramatically. And in counties where Planned Parenthood had health centers, placement of IUDs and other contraceptive implants fell by 36%, and Medicaid-covered births among injectable contraception users increased by 27%. The idea was that other providers would fill the gap, but unfortunately they did not. A 2022 study published by the Texas Policy Evaluation Project at UT Austin, using a sample of 194 providers, found that only 34% of nearby Medicaid providers both accepted Medicaid and stocked highly effective contraceptive methods, and only 6% of those could provide those in a single visit. Meanwhile, the Baker Institute at Rice University recently examined the state's $200 million Texas Thriving Families program and found significant gaps between its goals and its activities. The report noted that the program excluded medical services and concluded that reinstating Planned Parenthood into Medicaid and other state programs would improve access to needed reproductive health care for Texas' most vulnerable residents. If we want healthier women, healthier children, and healthier families, Texas should work with the federal government to expand Medicaid, bring Planned Parenthood back as a trusted provider, and then utilize our extensive network of sexual and reproductive health care centers, now including menopause care, especially in medically underserved communities.
And thank you for your testimony. Welcome. Introduce yourself and go ahead.
Good evening. My name is Darcy Caballero, and I'm the Government Relations and Political Director at Planned Parenthood Texas Votes. First, I want to restate what has been established medicine for many years. Medication abortion is a safe, evidence-based form of healthcare. Decades of research and extensive real-world data have consistently shown that it is safe and effective, and patients deserve access to accurate information and medically sound care. At the same time, we must address a real threat to women: the state's willingness to turn a blind eye to the real medical malpractice and deceptive practices happening in crisis pregnancy centers across Texas. Senator Hall, you might be interested in this story. A recent Dallas Morning News investigation highlighted the story of Kaylee Hall, who visited Abundant Life Pregnancy Resource Center in Athens, Texas, seeking reassurance after experiencing a previous pregnancy loss. An unlicensed ultrasound provider told her that her pregnancy was normal and marked yes for intrauterine pregnancy. In reality, she was experiencing an ectopic pregnancy and required emergency surgery. When asked what steps had been taken to prevent this from happening again, an OBGYN affiliated with the clinic responded that the clients acknowledge that the scans are for educational purposes only and that there is nothing to fix. Because of the state's willful negligence, there is no realistic recourse in state law for Kaylee. When preparing for today, I looked at the medical definition of a diagnosis. It's pretty straightforward. Medical diagnosis refers to the process of identifying the cause of a patient's condition by analyzing information such as physical exams, lab tests, and patient medical records. Under this definition, confirming an intrauterine pregnancy counts as a diagnosis, no matter what was previously signed by the patient saying the opposite. Under this definition, one could even argue this counts as a deceptive practice. Texans should not have to decipher legally dubious waivers while seeking what they thought was legitimate care. If a facility is providing ultrasounds, which are inherently used to diagnose conditions, there should be appropriately licensed sonography staff who are actually trained to read them. This is about one simple principle. If an organization presents itself as a source of healthcare, it should be held to healthcare standards. Thank you.
And thank you for your testimony. Welcome. Introduce yourself and go ahead.
Good evening, elected officials. My name is Jonah Pop, and I am here today to oppose any additional restrictions because medication abortion is healthcare. As a social worker and former history teacher, I have both studied and witnessed how reproductive freedom is directly tied to survival, safety, and human dignity. Access to healthcare determines who lives, who suffers, and who gets the opportunity to build a family safely. What frustrates me most is that this legislature continues to add ban after ban, restriction after restriction, while ignoring the real-world consequences that these policies are having on working-class Texans. Since Dobbs, fear has become part of family planning conversations. Pregnant people are dying at unprecedented rates in our state, and maternal mortality rates in our state are approaching an all-time high, especially for communities of color. Maternal health care access is declining. Maternity care deserts continue to grow. Families are struggling to find providers, specialists, and basic health care services. That should outrage every person in this room. But instead of addressing these crises, the state continues to create more barriers. You have cut $1 billion from our public education system. And who gets gutted first? Special education programs. Programs that provide family support services. And how do I know? Because I have seen it firsthand as a social worker. Connecting families with resources that do exist, reunifying families, and navigating systems that are already stretched to their limits. So I have to ask, if the goal is to protect mothers and children, why are we making it harder for them to access health care? Why are we allowing maternity care deserts to expand? Why are we dismantling programs that help families thrive? The truth is simple. Abortion bans do not make families safer. They make people afraid to start families at all, like myself and my own wife. Thank you.
And thank you for your testimony. Senators, any questions for witnesses on this panel? Senator Hall, you're recognized.
The lady in pink there. I would agree with you. It's a mistake made in a something like that gives bad information mistake is a mistake. But the willfully killing of a human, of a person, it's a willful killing. I didn't interrupt you.
That's fair, but I was talking about the CPC, so I just want to make sure we're talking about the same thing.
Yeah. You're talking about the sonogram that was given, and she was given bad information. Mm-hmm. Mistakes happen. That's wrong. I don't like that. It should. Those things should never happen. But each abortion is a willful killing of a human being. It's a willful killing of a child, and I can't see how that's. If you're that concerned about a mistake in a medical procedure, why are you not concerned about the child that's killed? And how do you categorize, if it's a female, that it's female health care for that child that was killed?
First, I don't think we're going to see eye to eye on abortion, to be totally honest. And can I finish since I let you finish? And so I want to go back to the crisis pregnancy center situation because I feel like you're sort of dismissing the situation where a woman who had an ectopic pregnancy, which can be fatal, which can make her lose her entire fertility, that you're saying, oh, that shouldn't happen. Anyway, let's go talk about this other thing. And that's my entire point with my testimony, is that that's what the state is doing. The state is wishing to wave away all these other problems that a program that has been completely allowed to run amok with $200 million every 2 years has no actual oversight over a woman who almost lost her entire fertility, and instead would prefer to look at the abortions that they don't even happen anymore. Like, it's the rate of abortion is so much lower than it is now, and yet we are still here trying to find yet another abortion ban. And so my question to you actually is, what do y'all plan to do to make sure that this doesn't happen actually in CPCs? Because it's great for you to say you don't agree with it. I'm glad we're on the same page about that should not happen in CPCs. But what kind of consequences will there be for CPCs, for crisis pregnancy centers, that do sonograms without licensed technicians that lead to negative outcomes for people who might die or lose their fertility? That's my question for you.
There's already laws in place.
There
for
are not
that.
laws in place because they are providing non-educational or non-diagnostic sonograms for things that are entirely diagnosis. Like, it is absurd to me that we are continuing to debate this, and frankly that you're changing the argument to be something else entirely, when what I was talking about was the negligence that crisis pregnancy centers have and that they're allowed to have, and that they're even the crisis pregnancy center themselves said nothing's going to happen, there is nothing to fix, because it was an educational sonogram, which she probably didn't even know about that. So honestly, I would recommend everyone here to look into a deceptive trade practice problem here with CPCs, because they are genuinely, like I'm saying, allowed to run amok with the situation.
No, I agree that it shouldn't happen, and there should be better training and something should be done about it. But it's like worrying about a hangnail when you're about to have your whole
I'm
leg
sorry,
cut
a woman's
off.
ectopic pregnancy to me is not a small situation.
So, but the killing of a child is. The killing of a
Did I say that?
child-
I did not
But
say
I don't. What I don't understand is how you reconcile it in your head that it's okay to kill a child. Just to
That's
make
not
the
part of
mother
my
happy.
testimony here today. My testimony here was to talk about crisis pregnancy centers and how a crisis pregnancy center almost killed an existing living woman on this side of the uterus.
All right.
Thank you.
Dean Safreni, you're recognized. Thank you, Central Hall.
Mr. Chairman. Does any one of you have any information regarding pregnancy-related deaths since these abortion laws were passed in Texas?
Yeah, I can speak on that a little bit. As far as I know, the state of Texas has not released statistics for about 4 years now, but some third-party organizations like March of Dimes have taken what info we do have, and we're approaching a rate of about 30 deaths per 100,000 births, which is, frankly, that number is approaching what we had before Roe v. Wade in the 1970s. And that number, for reference, was as low as below 10 or around 5 per 100,000 births in the 1990s and 2000s.
And to expand on what Jonah said, so there are three that we can attribute specifically to the bans. There are 3 women who have died because of it, both since SB 8 was passed in 2021 by this body and members on this committee, and then also by the actual trigger ban / the Dobbs decision. But what Jonah was saying, just to expand on that, is that the Maternal Mortality and Morbidity Review Committee is unwilling to look at any deaths that happened between, I believe it's 2021 and 2023, which are, coincidentally the years that the abortion ban was initially enacted in, and that doctors, for the most part, had not a whole lot of understanding of how to, treat women and treat pregnant people appropriately. And so because of that, there are multiple attributable deaths to the Texas abortion bans.
Thank you. Thank you, Mr. Chairman.
Thank you, Dean. Senators, any other questions for these witnesses? Thank each of you for being here. I'm sorry.
Just one line kind of thing.
Is this, you want me to excuse them and then make the comment, or do you have questions for them?
They can go.
Yeah, you'll go. Thank you. Thank you for your testimony. Go ahead, Central.
We do have had women die, but it's due to medical malpractice on the doctors who refused to do the abortion when they knew the woman's life was in danger, and they knew that the law allowed that to happen, and they did it because they want to push bringing back abortions. And so they were willing to make an example, use these women and make examples in trying to bring it back. And I think the Texas Medical Board should be investigating every one of them, and they should lose their license for having let those women die.
Central, there are
because it was a double death. It was the mother and the child died.
We've learned about some tragic cases where moms, for example, experiencing a miscarriage, and where the doc and the ER refused treatment, and 2 of those docs are being investigated, being disciplined by the Texas Medical Board as we speak. So that is being dealt with. And that's, of course, why we passed the Life of the Mother Act, to make it crystal clear and to require that physicians are trained on what the law is, so that isn't happening. Again, thank you for your testimony, your excuse. Thank you so much for being here. It's an important point, Senator Hall. Thank you. You're exactly right. That's a big deal. It's a really big deal. Call Laura Terrell.
She's not able to be here.
Okay.
I have her written testimony.
Oh, very good. Well, you'll get that to us before you leave, and we'll get that to the committee. Thank you so much. Call Kritika Sau. Call Kobe Heisey. Jenny Limcher. And Shreyasi Madala. All right, welcome. You already have the microphone there. Introduce yourself and go ahead.
Thank you, Mr. Chairman. My name is Kritika Sau, and I'm here to testify on the Protecting the Unborn Act. And specifically, I'm here to clarify some statistics to help clarify some of the arguments that were presented earlier today. So specifically on the topic of abortion bills, I believe that it can help with so many other issues that could be entirely unrelated to terminating an unwanted pregnancy. For example, stomach ulcers, which according to the FDA has millions of prescriptions for mifepristone and mifepristol. Postpartum hemorrhages, which are incredibly common, affecting 40% of women after the child is born. Crushing syndrome for individuals with type 2 diabetes, where mifepristone prevents cortisol from acting on tissues. Ectopic pregnancy, where the fetus is no longer viable, which annually 36,000 to 72,000 women have to suffer with. And I believe that we cannot claim to protect women when this bill would significantly harm all of these women and men who are affected with these conditions. And we cannot claim to protect every woman when we will ignore the ones who we pretend not to see. Moreover, on the effects of abortion pills, specifically mifepristol and mifepristone, severe complications occur in less than 1/3 of 1% of patients, and the risk of death for medication abortion is about 14 times less than the risk of giving birth, or about 0.0005%. Today, approximately 21 million women around the world obtain unsafe, illegal abortions each year, and complications from these unsafe procedures amount for nearly 13% of all maternal deaths, which is nearly 50,000 women annually. If we want to bring these numbers down, gutting abortion pills isn't going to prevent these numbers. Abortion pills serve a purpose in our community, and they act as a form of health care. By denying women around Texas this right, it will only encourage greater danger to the women who become pregnant. Thank you for your time and consideration.
And thank you for your testimony. Pull the microphone over there and introduce yourself and go ahead.
Hello, I'm Kobe Heisey, and I'm testifying on behalf of myself. I'd like to start by thanking the senators for holding a meeting on such a crucial issue in the hearts of Texans. I'd like to start by saying that my mother is a nurse in a labor and delivery unit in Georgetown. Through seeing the light in her eyes that she brings when describing the beauty of a birth and the process leading up to it, I know that it's crucial to protect children across the board in Texas. However, holding this to be continuously true, I feel it's also important to put a lens on the issues where I personally feel an abortion is, unfortunately, necessary. I speak firstly on the case of one Amanda Zarowski. In 2022, Zarowski's water broke at 18 weeks. Because there is still a fetal heartbeat, her doctors determined that they could not legally intervene under Texas law until she was considered in a life-threatening condition. She was sent home, developed severe sepsis, and spent days in the ICU. The infection caused permanent damage to her reproductive organs, scarring one of her fallopian tubes shut and compromising her future fertility. Secondly, I point to the case of Kate Cox. Cox's fetus was diagnosed with trisomy 18, a fatal genetic condition. Continuing the pregnancy posed a high risk to her health and her ability to have children in the future. She had already delivered 2 children via C-section, and a 3rd C-section could jeopardize her future fertility. She requested a court-ordered exception, which the Texas Supreme Court ultimately denied, ruling that her condition did not meet the state's narrow medical exception because her life was not actively in danger. She had to travel out of state for care. Cases like these may be relatively isolated, but if the Texas Legislature truly intends to follow up on its mandate to protect all Texas citizens, it's necessary to provide exceptions for these cases in a more clear manner. Despite powerful testimony earlier today, I feel it's necessary to point to the facts. Seeing as my time is about to end, I'm going to conclude. While exceptions are rare, a total ban of safe, legal, rare abortion access in the form of an abortion pill is, in my view, unwise and in bad taste. That concludes my testimony, and I yield my time to the chair.
Thanks for your testimony. Ms. Limcher, welcome back. You got the microphone there. Introduce yourself and go ahead.
My name is Jenny Limcher from Harris County. I did not come here originally planning to testify about this, but I could not be quiet listening to everybody's comments. First of all, I want to say thank you for protecting the lives here. And I want to tell from my own experience. I lived in Russia for a decade, and while I was there, I did have a pregnancy that ended in a natural type miscarriage, right? And whenever I had a DNC, the only place to get one was at an abortion clinic. And I remember being in the room and waking up, there it's socialism, and socialism, everybody's a number. And so I was just literally put on a chair next to a lady who was out of it, and we were all treated like numbers. So I was in the chair. I'm having a DNC. She's having an abortion. And I just remember when we both woke up in the room, all I could think of was that this child was so important, one, to God, and important to the future. That child had a future. And here I am next to a lady who did not want her child. It was very difficult for me to imagine that anybody would not want their child or would give them an opportunity for life. I think of Mahalia Jackson. She was an incredible singer, and she was saved because her mother did not go get an abortion. I know other people as well. I just want to say it's about a worldview. Either you value life at all stages, whether before birth or even close to death. Either you value life or you don't value life. But I ask for people here to please value life. Life is valuable, and you need to value it today, tomorrow, every day of your life. So it's not a choice, do I kill somebody or not? In Russia, it was 114 abortions per 1,000 women. When I was there, I did not meet a single woman who had not had abortions. And I worked with women, and they were so sad later in their life of their lost children. Please continue to stand against abortion. Thank you, including the pill. Thank you.
Thank you for your testimony. Pull the microphone over there and introduce yourself. Go ahead.
Thank you, Mr. Chair and members of this committee, for this opportunity. My name is Shreyasi. Before the break, we previously discussed on total prohibition of abortion medication in Texas, but I believe we must ground our debate in the harsh economic and human realities facing young women in our state. Although it is important to educate individuals on the medical side effects of any medication, we cannot ignore the profound consequences of removing this option entirely. Consider the immense injustice of forcing a survivor of sexual assault to carry a pregnancy to term against her will. She is immediately saddled with overwhelming costs of healthcare alongside 9 months of physical and emotional strain. The long-term economic trajectory is even more stark. Data shows that women who are denied a wanted abortion face 4 times greater odds of falling below the federal poverty rate. In 2026, that poverty threshold stands at just $15,960. And monthly, that would be around $1,330 a month. And rent alone would take up $1,000 of this baseline. A single mother is left with a mere $330 a month to cover food, healthcare, utilities, and child's basic needs, resulting in both the child and the mother living in poverty. I firmly believe that women should retain the right to make these deeply personal medical decisions. Providing comprehensive education on the effects of these medications is a reasonable goal that I stand and support. But completely stripping this option away from women of Texas is an unnecessary overreach that will push vulnerable families and women of our state into poverty. Thank you. I yield my time to the chair.
And thank you for your testimony. Senators, any questions for the witnesses on this panel? Thank each of you for being here. You're excused. Thank you. Senator Hall.
Could you give me the information on that court case Because I'm not familiar with it, where you said the Supreme Court ruled against a woman?
I'd have to get back to those specifics and give them back to you.
Yeah, I would like to know, because the law is very clear. If the woman's health is in danger, the doctor can perform an abortion. And there are a lot of people out there spreading a lot of misinformation about it in order to help the abortion industry out there. But the law is very clear. If you don't have to wait till she's on her deathbed. If the doctor, in his medical opinion, feels that her life, her health, it doesn't have to be her life, but that she would suffer permanent damage and it would affect her ability to have future children, he can perform that abortion. So I'd like to see that. I'd like to know what that court case is, because I think somebody gave you some bad information.
With respect, the specific case that I was referring to was in 2022, and I know you mentioned an act that was passed to further clarify the issue here, but if you want, I can follow up with you after this.
Yeah, I would like to see it if you would.
Court case.
Get it.
Absolutely.
I'd appreciate it. Thank you.
Of course, should pull the microphone over. You go ahead. Thank you. Yes, ma'am.
Is it okay if I ask a question to one of the senators?
We don't normally do that, but you're one of the last witnesses. Go right ahead. Yes, ma'am.
Okay. Senator Hall, I have a question for you. Is your belief against abortion because of the murder of a child?
Well, yeah. No, I mean, yeah, it is. It is a child. It is God's creation.
Okay.
That pregnancy occurred because God allowed it to happen, and it is a child. It has a different DNA. It is a person on its own from conception.
Well, I want to point out specifically like a point of clarification. I would say that the government itself isn't necessarily against murder as a whole. I would say there are some forms of murder that are allowed, like, for example, murder in the act of self-defense, or for example, in the military, where people who are a part of the military are state-sanctioned to essentially murder other people, and that the justification for that is that there was a significant reason as to why the murder was necessary. And I would say that abortion has a similar motion for that. Like, there is a similar significance, and there is a similar reason for why that murder is justified.
Oh, I'm sure that the mother forms a justification in their head, but to call a self-defense murder, that's not murder, that's self-defense. And war is entirely different category. This is a totally helpless, totally without any defense taking of the life of a child. It is classic murder. And the law does consider the child in the womb a human being. We have the law. If you kill a woman who's pregnant, you've killed two people. That's already in the law. So
yes,
thank you.
I agree with that. But also, in terms of like, first I want to address specifically, like, when it comes to women who are pregnant, I would say there are some instances where the law considers it murder, and there are some instances where it doesn't. For example, when it comes to the unborn child or the fetus, considering that a human person, I would say that there are some times when the law does not consider that. For example, we do not have tax credits or tax burdens or insurance on fetuses or unborn children, and we do not celebrate birthdays, for example, on the minute that the child is conceived, but rather the minute that it takes its first breath. And so I would argue that the law has kind of a sense of ambiguity where it comes to defining personhood. And I would definitely agree that when it comes to double homicide, I believe is the name for when you kill a pregnant woman, you're also killing her child as well. I would say that there is a bit of ambiguity where that line is drawn.
And we've been working on that as well. You know, there's child support obligations are due. You want to a father is responsible for supporting the child even if the father is not married to the child's mother. In Texas now, we recognize the child support obligation begins at the time the child is conceived. We don't wait till birth. So you're correct. All these issues need to be addressed. We want to be as consistent as we can in the application of the law. We recognize these are heavy topics, and these discussions are good, and we want to get to the right place. We may not all agree on them at the end of the day, but we thank you each for your testimony, and thank you for being here.
Okay, thank you.
We are coming to the close of our testimony on this topic. We have 3 more witnesses: Veda Kaluri, Nissa Tiabji, Dr. Patrick Marmion. Did you register on this one too? We didn't have you on here. Come on down. That's fine. We'll hold on one second. Almost ready for you. We're not going to cut you off. Yes, ma'am. This is the last panel. Will you do a card for us before you leave? Because we had you registered on the other topics, but not on this one. So make sure and fill one of those out. Okay. Thank you. Welcome. Pull the microphone a little closer and then introduce yourself. Go ahead.
Thank you. My name is Veda Kaluri, and I'm a student in the state of Texas representing myself today. I would like to respectfully state that along with reduced access to abortion pills, doctors and hospitals face severely reduced flexibility to treat critical conditions. This includes severe fetal abnormalities, premature rupture of membranes, and other intrauterine pregnancy complications that directly threaten a patient's health, a woman from Texas's health. I just want to say that fewer legal restrictions are vital to reducing dangerous delays in care. And to echo an extremely moving earlier testimony, abortion care is health care. I encourage you to refer to the National Bureau of Economic Research. Researchers have associated with the well-known Turnaway study, and they have published extensive findings here. This research ultimately proves that women denied abortions are significantly more likely to experience long-term financial hardship, poverty, and debt, compared to those who receive wanted abortions. Expanding public health access to abortion alongside contraception creates 4 key benefits. For starters, it reduces unintended births, improves family planning, allows people to better time their pregnancies, and improves outcomes for existing children by enabling families to allocate resources more effectively. We must recognize that unintended pregnancies heavily disrupt education, employment, and also financial stability. And finally, we must address some of the unequal distribution of these burdens. Out-of-state travel restrictions disproportionately affect low-income, poorer, and rural residents who face the greatest logistical barriers because wealthier Texans can simply travel elsewhere for care, and the burdens of these restrictions is fundamentally unjust and extremely unevenly distributed. Thank you. I conclude my testimony.
And thanks for your testimony. Pull the microphone over close so we can hear you, and once you get situated, introduce yourself, give us your testimony.
Okay. Chair and Senator, thank you for this opportunity. My name is Nissa Tiabji, and as you can see, I am a young woman living in this new era of Texas where access to women's health care is nothing but a political tool, can be debated, and is almost too easily taken away. I wish to represent my opinions on this topic. I've listened to many concerns stated regarding the abortion pills, and while there have been some very valid statements regarding the safety of these pills, if at the end of the day the concern lies with the vulnerable, the optimal solution would be to make sure that these women can have access to their desired medical care instead of feeling the need to seek out illegal substances. I urge you to consider legalizing these abortion pills. The legalization of these pills would allow regulations to be put in place, ensuring that children and women within our state are carrying out this procedure safely. At the end of the day, despite any political divisions, we can agree that the unnecessary death of Texas women must be prevented. By not placing further measures that restrict abortion, you save both women and strain on their families. Once again, thank you for your time.
Thank you for your testimony. Doctor, pull the microphone over there, and thanks for being here. Again, we had you registered. The system had you on the wrong topic earlier, but thank you for waiting, and I'm glad you had the benefit of hearing all the other testimony. So please introduce yourself and give us your testimony.
Thank you. Thank you, Mr. Chairman, members of the committee. I'm
Patrick Marmion, Dr. Patrick Marmion. I'm an obstetrician, gynecologist, delivered over 7,000 babies. I'm here representing the American Association of Pro-Life Obstetricians and Gynecologists, and there are 40,000 members, all physicians and obstetricians. We are here to testify in favor of strict compliance with the Women and Child Protection Act. So, well, we've all heard the risks of the abortion pill regimen, but we didn't hear this. Of all abortion deaths, the abortion pill accounts for 40% of them, of women dying from abortion. 40% are victims of the abortion pill. So that's a big risk that we really didn't hear today. 1 out of every 12 women who have an abortion pill experience ends up in the emergency room for complications. So it's a big drain on our healthcare system. Right now, rogue out-of-state prescribers are using shield laws to bypass Texas safety regulations. In so doing, they are placing the lives and health of our Texas women at risk. These out-of-state networks operate on a system that's a drive-by model that has no patient encounter. It's a fill out a form on the internet, and it fails all standards of care for health care. The provider or the prescriber does not meet the person, they do not check their ID, they do not do a health history, and they do not perform an ultrasound. And sorry about that. My time is up.
We'll probably have some questions for you, Doctor. Thank you for your testimony. Welcome back. Pull the microphone over, introduce yourself. Go ahead.
Hello, my name is Lauren B. Pena. As a nominee for United States Congress, the topic of abortion is kind of outside my realm, given that this is a state matter. However, as a survivor of human trafficking, this particular issue is in my jurisdiction because during the Biden administration, he had the FDA remove the requirement for in-person appointments in order to receive the abortion pills. What this did was set out a protection that was there that could protect people that are being trafficked from getting the assistance that they need is no longer there. And so I urge this committee to please write a letter to the FDA, please write a letter to the federal government and urge them to reinstate the requirement for in-person visits for survivors of human trafficking because it's our duty to protect them. Secondly, and most important, I've heard so many people on this panel talk about how being in poverty is a reason to kill your child. Well, I want to tell you right now, as a person that currently lives in poverty and has children, I can tell you that my children are very happy. My children are thriving. My children are getting the education that they need, and they've got the experience that they saw coming from me to get out of their situation to prevent them from being in poverty. So I don't think it is a rational excuse to say just because you're poor, you should kill your child, because my children are great. And so I would really appreciate in the future, anybody advocating for things like this, how about you actually go ask the people in poverty how we feel about these things? Thank you.
And thank you for your testimony. Senators, any questions for these witnesses? I'll ask Dr. You've delivered how many babies, you said?
7,000.
7,000. Pull the microphone over.
7,000.
7,000. Thank you very much. And this has been covered, but I know folks have been in and out, and I know people here care about this, regardless of the side they're on. But we've talked about the abortion pills, and we know the effect they have on the little unborn baby. But let's talk a little bit more about the effect they have on the moms, because, I want to make sure we don't miss this. And I'm going to try to state something without being biased, and tell me if I got this right. The 2-pill regimen, the first pill. Well, tell us what the first pill in the abortion pill regimen. Tell us what that does.
That's my mifepristone that destroys the placenta by blocking estrogen or progesterone, and the baby dies.
So that's what the first pill does. It causes a little unborn baby to die, and then what is the second pill? What does it do?
It's misoprostol, and it actually it starts labor.
Okay.
The mom goes through labor
Okay.
and delivers the baby.
Okay. Now, you told us a number of witnesses have testified, and you, as a treating physician, would be able to understand this better than most of us. So, we understand that there is no longer any requirement for any in-person visit in the use of these abortion drugs. Is that right?
That's right. And you know, the biggest problem with the abortion pill and the cause of the abortion deaths is ectopic pregnancy.
I was about to ask you, doctor. So, if a mom, now, this is we're talking about such heavy things here, and I don't want to be glib about it, but let's just talk about what happens. The little unborn baby is going to die if these pills are used. But let's talk about the mom. If a mom has an ectopic pregnancy, and she either calls a number or goes online, or her boyfriend or pimp or someone provides these drugs to her, she's not examined by a physician or by anybody. She takes the abortion pill regimen. If she has an ectopic pregnancy, tell us what that means for her, for the mom.
It means she's going to die, really. She's going to hemorrhage internally and bleed to death without urgent or emergent care.
What if the mom's pregnancy is further along than she realizes? The unborn baby is more developed, a little bigger than she realizes, and she takes these pills. What happens to the mom in that case?
Well, it's not designed for late-term abortions, so a woman that's further along in her pregnancy is going to have a horrendous delivery. She's going to deliver a well-formed baby at home. She's going to hemorrhage and at home and could possibly exsanguinate before she gets to the emergency room.
And exsanguinate, I think that means has to do with blood. And
Yes.
tell us what exsanguinate means.
Well,
Tell
it means
everybody
she's-
else.
Yeah, she will go into shock from blood loss and die.
You mentioned to us that of the deaths of the mother related to abortion, of those cases, of all the times when the mother dies, what percentage did you say are when they're from pill abortions?
40%.
40%. All right. Senator Hall.
Yeah,
you're recognized.
It's just along the same line, to be quick, because I know it's a long day here. But how far along is in the pregnancy can a woman be, and I'm going to use the word safely, and I don't mean it, but safely take the pill in terms of it would just kill the baby and get rid of it and she'd be okay?
Safely, according to they keep changing the original REMS, I think was 63 days, but I think it's up to 70 days now. I'm not exactly sure, but my recollection is 70 days from conception.
So they're up to 70 days now. And what's a rough estimate of a woman that can be pregnant and really not realize it, or just accept maybe she missed her period and didn't think about it? She's done that before, no big deal. It comes back around later. How far along can a woman be before she all of a sudden says, "Oh, I think I'm pregnant"?
Well, I've seen people come in at 26, 28 weeks and not realize they were pregnant. And it's half the women do not know their last menstrual period when they come in for health care, for pregnancy care. And the dates they come up with for their due date are dramatically wrong in 50% of the cases. So they're generally dated much late. Their real gestational age is later than what they think.
And for someone who's fairly sexually active, probably has no idea when it happened.
That may be the case, but the fact is that ultrasound is the standard of care in obstetrics and gynecology in early pregnancy dating, and it rules out ectopic pregnancy and confirms the gestational age, making the abortion pill a little more safer to use.
But that's only when she does that under a doctor's care. That's different. When I'm talking about the lady who looks on the internet and orders it off the internet when she, I think I might be pregnant, and she orders it. There's a big difference, and I think a huge mistake was made on this issue when we removed the doctor participation in something as serious what this is. So in today's environment, you have a woman who has no clue how long she's been pregnant, but she knows about the pill, so she orders it. And I think that's going to be a major contributor to your number of 40% of them dying.
All right. And the fact is that there's no standard of care. The prescriber collects the bill and abandons the patient and tells her, when you go to the emergency room, tell them you're having a miscarriage, because they don't want the abortion complication to be coded as an abortion complication. They want it to be coded as a pregnancy complication.
Right. I think this is probably the only combination of drugs in which the second pill kills the killer.
Right.
The second pill kills the killer. In there.
That's very true.
Okay, thank you, Doctor. Appreciate you being here today.
Doctor, how long have you been practicing?
50 years.
And where do you practice medicine?
Well, right now I'm in Texas with grandchildren. I've lived here for 5 years, and the one thing about the hearing today is that it's like waiting for a child to be born, waiting in the hospital for you to go to do your job. So thank you very much for your time and for what you've done.
Thank you, Doctor. We thank each of our witnesses, and you're excused. Thank you for being here.
Thank you.
That concludes the witnesses that registered for all of our charges. We thank each one invited testimony and public testimony. We thank the members of our committee staff and the staffs of each member of the committee and those senators. Thanks for all the folks that help us keep the trains running on time. And with that, if there's no other business, the Committee on State Affairs stands in recess subject to the call of the chair. Good evening.